Okay, it says it's just preparing, so should be.
Yeah, got it.
Yeah.
Okay.
Yeah.
Excellent. Thank you. So it's recording now. Excellent. Thank you very much. Well, good morning then, ladies and gentlemen. The time is now 9:30. It's just gone past that, and I'll resume this inquiry. Now, as there's been a few weeks gap in the proceedings since we had the last few sessions as part of the inquiry, just a reminder to anybody who is viewing that I'm the inspector. My name is Yvonne Wright, and I've been appointed to determine this appeal made by Healy Development Solutions Broadway Limited against the decision of the Council of the Royal Borough of Kingston upon Thames to refuse planning permission for the proposed development at the Tolworth Tower site as previously described. I'm not proposing to go through that. If I can just ask, for the benefit of anyone who may be viewing this event either for the first time or has forgotten who everybody is, can I just ask that the main advocates, please, if you can just introduce yourselves. Can I start with the council, please?
Yes, thank you, madam. My name is James Burton. I'm a barrister practicing from 13 Essex Chambers, instructed by the council on this appeal.
And the appellant, please.
Thank you, ma'am. My name's Scott Linus, Queen's Counsel. I'm instructed by Ms. Caldeira for the appellant.
Thank you. I'm not going to remind everybody about the sort of housekeeping matters. You're all aware that we're not using, chat, and please keep mobile phones on silent, etc., etc. We will be having breaks as and when required today. Hopefully breaking for lunch around 1 o'clock, but we'll see where we are in the proceedings, etc., as to what's the most appropriate, the appropriate time to do that. Now, today there are, if I look at the agenda, we've got on the agenda 4 items. The main items are in relation to outstanding viability issues, and that was a session that was set out if necessary. Then there will be roundtable sessions on planning obligations and planning conditions. Then any cost applications, not that I've had any in, but I do need to go through that. And then site visit arrangements, which I will go through. And obviously there's some updates on that as to the date has now been confirmed, etc. But I'll go through that a little bit later. And then obviously on Wednesday this week, we will be listening to I will be listening to the closing submissions, and anybody else who is tuning in can listen to that as well. So before I make a start on that, on going through the agenda, I've had a number of emails sent through and additional documents, additional information that's been sent through this morning from my case officer. And some additional documents were sent as part of the, or sort of were attached as part of the emails in relation to the Section 106, the planning obligation, the planning conditions, and the SIL compliance statement, which I requested those documents, but I just want to understand the context of the additional documents and the additional emails that have been received. I haven't read any of the documents that I haven't requested. Doesn't mean that I won't, but obviously I want to understand the reasoning for putting in those, and to give the council an opportunity to respond on those before I decide whether to accept those documents or not. So can I just have I don't want to go into the detail of the documents yet, because obviously whether I accept them or not needs to be determined first, and then will need time to have a read of those. So we may have to move some things around on the agenda today. So it gives me an opportunity to read them if necessary. But can I just have an explanation around the different documents? I have to admit, I haven't even opened some of the emails this morning because I haven't had the time. So I will open those, but I haven't looked at the documents. So can I just have an explanation as to where these, first of all, the 2 additional documents that were attached in relation to the unilateral undertaking, I understand, but again, I don't, and I think they're from the appellant, but I haven't read them, haven't opened them. So could I just have an understanding about those documents, please?
Ma'am, you're correct. There were two documents that have been submitted in association with the obligations. The first one is an explanatory note. The second one is a technical note, which is related to the explanatory note. And if I deal with those in turn, the explanatory note essentially does two things, ma'am. It explains why the planning obligations that you have do not include the obligation that we understood the council was seeking, which was an obligation to complete the development. You'll recall from what seems like a fair amount of time ago now that the appellant was resisting that suggestion by the council and indicated that to explain why it was going to be resisting that. It's a matter which could be dealt with in submissions, but as we indicated at the time, we thought it was going to be helpful to set out our position in advance of closing so that the council could see where we were coming from and you could see where we were coming from. So that's the first element of the explanatory note. The second element of the explanatory note relates to an obligation which has been added to the unilateral undertaking since the last part of the inquiry. As you'll recall, ma'am, one of the issues that's been raised by the council is concern, which we don't accept, but a concern nonetheless that the developer is going to stop at phase one. There isn't sufficient incentive to continue with the scheme. Since the last session of the inquiry, the appellant has reflected on that and is prepared to offer a further obligation if you find that it's necessary to do so, which would provide an extra incentive for the developer to continue beyond phase one. I need not go into the detail on that at this stage, but that was the other element of the note. And the technical note that supports that by Mr. Ashdown explains how that obligation is intended to work to create further incentive to proceed beyond phase one. Now that's the broad purpose of both those notes, ma'am.
Okay. Obviously, I'm aware of what's set out in the section 106 in the unilateral undertaking. Yes. So I understand the reference to the additional element that has been added into the section 106. So what you're saying is the technical note is in relation to that. Yes, additional element.
Part of the explanatory note is in relation to that, and the technical note is in relation to that as well. So what we thought we'd do is, and actually what we understand, and in my experience is a normal way, that to assist you with the obligations that are being offered, the note is prepared outside the obligations themselves, explaining the basis for the obligations that are in the undertaking. So that was that's the purpose of those two documents, ma'am. They were the explanatory note was sent to the council last Wednesday, and then the technical note followed on the Thursday morning. We understand that Mr. Ashdown spoke to Mr. Scott about that on Thursday morning. But those are the documents and their broad purpose, ma'am. And we say that first of all, the note in relation to the additional obligation, we prepared that on the basis that it was necessary for you to understand what we were proposing by way of unilateral obligations, albeit we don't think the additional clause is necessary for reasons that are explained. And then secondly, the explanatory note responds to the suggestions from the council that there needed to be an obligation to go as far as to complete the scheme. We could have dealt with that in later submissions, but we thought it helpful to lay out our position on that in advance of the session today, and that was produced last Wednesday.
Okay, thank you, Mr. Linus. Mr. Burton, council's comments on these two documents, not on the additional emails that have been sent through this morning to me, but on those two documents. Let's make a start with those. Sure, obviously, yeah. I understand we will be going through the planning obligation in quite a bit of detail later on. So council comments on these notes, whether they, well, just your comments on them, really.
Yes, madam. Right. So firstly, madam, as you know, our approach is always, wherever humanly possible, to let things in and then deal with them. And that's certainly the approach that we're taking to these two two documents. So headline point. As regards the explanatory note, of course, you've seen from the section 106 what it is the appellant is suggesting by way of an additional obligation. In due course, yep. We'll come to explain why the council considers that doesn't remotely touch the side, if anything, the opposite. The only issue the council has about the explanatory note, and I should say, it's helpful to see the appellant's submissions, as it were, on the additional obligation that's suggested. The only issue the council has is some filler in there suggesting that the council hasn't suggested any specific mechanism to ensure the completion of the development. I mean, we can come on to that, but frankly, we don't think we could have been any clearer. And my learned friend has just reminded us all of the obligation the council is seeking. It's one line: complete the development. Anyway, so we can deal with that in the section 106 session. No problem with that. Turning to the technical note that Mr. Ashdown has produced to accompany it. Now, make no bones about it, this is evidence, of course, but so long as Mr. Scott, who is available for today, is given an opportunity to explain to you his position on this evidence that Mr. Ashdown has produced regarding the additional obligation, then we've no objection to that going in.
Okay. Thank you for that. That's really helpful. Obviously, I know they're not lengthy notes at all, so I will need to have a chance to have a look at those, even if it's just, quickly, and then so that I can see exactly what has been set out in those. But we can see it could be that we just move things around, and then I can just do that in a break anyway, so because I don't want to delay things at all. In relation to Mr. Burton, you've just raised the issue of Mr. Scott coming in to have his say as part of is that as part of the roundtable session?
Yeah.
Or yes, so it's not part of because what I wanted to come on to next is to understand whether either advocates wish to bring or cross-examine in relation to any outstanding viability issues, and cross-examine any the witnesses of Mr. Scott and Mr. Ashdown at all in relation to that aspect, or is it all to do with the section 106 now?
Madam, my understanding is it's all to do with the section 106. Certainly that when I just said so long as Mr. Scott has the chance to have his say, I was talking, to be absolutely clear, I was talking in the context of the roundtable discussion that we're going to have on the section 106. That's
clear, Mr. Burton. Thank you. Mr. Linus.
Yes, my understanding has been the same. I have Mr. Ashdown available, so he can join any roundtable discussion, because this issue would link in with section 106 obligations generally.
Okay, it sounds like it makes much more sense then to just have the roundtable session on planning obligations, because quite rightly, viability and elements like that will come into that anyway, because it forms part of that discussion. Excuse me. Okay, can I now just have explained to me the emails that I've received this morning, which have additional either comments attached or emails attached, etc., just so that I understand. Again, I've got the emails now up in front of me, but I haven't opened any of the attachments.
What do you have, madam? May I check?
I've got 3 emails. One is, okay, that one is irrelevant, because that one is just explaining why. I have an email from Mr. McCurry, who I think is in response to my request that we discuss additional documents here. So I'm going to ignore that one now, because we've accepted those 2 additional documents now. So I'm going to close that one down. I have another email which has documents attached to it, And again, this is from Mr. McCurry. And he summarizes, so it starts in relation to the below and attached draft suggested planning conditions. There are 4 conditions that are not agreed, etc. And he goes into detail within the main text of the email on 2 of the conditions. And then there are documents attached, which is CD 1019. And then there is a Word version of the planning conditions, and then there are a couple of emails, which obviously I've not opened these documents. And then I have an additional email from Martin Hanmore, passed through my case officer, which I haven't read the email, but there is text in the email, and then an email Tolworth Tower Complex item attached, appendices, and Appendix 3 3-bed scenarios attached. So I need to understand why, well, whether I accept those documents and that information.
Well, I believe Mr. Feltham sent an email in response to Mr. Hanmore's email as well, which doesn't sound like it's reached you, madam.
Well, bear with me and I will check my emails now, because it might well have come through while I was, oh, there we go, yes.
Yes, we've received an email, ma'am. Ma'am, that's in relation to the same issue that Martin Hanmore's email was dealing with. Perhaps I can take the topics in turn. The email relating to conditions from Mr. McCurry was obviously anticipation of the roundtable discussion we're going to have today. The attachments essentially send what we understand to be the latest draft of the conditions, along with emails that were exchanges between ourselves and the council relating to the outstanding matters of dispute. So it may not be necessary for you to read those, in the sense that you're going to hear about these conditions in due course, and Mr. McCurry's covering email identify where the outstanding areas of dispute were, and try to help you in identifying what our position was in advance of the session. So I don't think there should be anything controversial about those emails, in the sense that they simply preface what you're about to hear, I suspect, as part of the condition session in any event. As far as the other emails are concerned, they relate to this question of the statement of common or uncommon ground on the 3-bed issue. Ma'am, you'll recall, again, it seems a long time ago now, but following the cross-examination of Mr. Scott, the parties were going to engage in further discussions to see if a statement of common or uncommon ground could be produced relating to how the viability work fed into the 3-bed issue. Now, as part of that, discussions did take place, as we heard at the last session of the inquiry, between Mr. Ashdown and Mr. Scott. And I can go into further detail as necessary, but by Wednesday last week, there was a draft of a statement of common ground that was sent back to the council. We received a draft later that day, which I think, as far as we're concerned, had made substantial amendments to it. I think it was more than 50% of the text, but be that as it may, what we tried to do was then acknowledge that it was unlikely in the time that we had before we returned to the inquiry that we're going to reach substantive agreement with the council. So we sought to try and convert the document into essentially a statement of uncommon ground, whereby we set out the very limited areas where agreement had been reached, amended the text to set out our position, and then the intention was to give the council the opportunity to put their positions, so that you had a document that was going to essentially indicate the respective positions taken by the parties, even if agreement hadn't been reached. Now, what appears to have happened is that the council has taken that as another substantial amendment. The way it's been described as a substantial amendment to the document, when in reality, all we were trying to do is to tee up respective positions being expressed. And that document has not been agreed. And to try and help you, ma'am, the email that you've been sent was essentially the last draft version. It hasn't been agreed, but the last draft version that we were trying to get in front of you to allow you to understand the respective positions of the parties. The appendices to that document are the appraisals, which we've spoken about at the inquiry before, which Mr. Ashdown sent to Mr. Scott some time ago as a basis for discussions, including the appraisal which demonstrated the scheme breaking even at 27.5%, therefore, on our view, not being viable at 30%. Now, in our view, we think it would still be of assistance to you to receive that document because it sets out essentially our position on the 3-bed issue in the relationship with viability. We have no objection to the council setting out its position as part of a statement of uncommon ground, but that process has not been reached, and we felt that rather than you simply being presented with nothing at all, it was going to be more helpful to you to see the document which set out at least our position and indicate the council's had an opportunity to put their position to you. So that's where we are with that document. I don't particularly at this stage want to get into a debate about who did what and when, apart from to make the point that the latest changes that were made by us were done in an attempt to change the structure of the document from a statement of common ground to one which was a statement of uncommon ground and let you understand the respective parties' positions. So that's what's happened. We think it would still be useful and helpful and necessary for you to see that document.
Thank you, Mr. Linus. Mr. Burton, your comments, please.
Well, Madam, you may recall when we last rose at the very end of October that the understanding was the parties would attempt to engage in an effort to agree the maximum viable amount of 3 beds. And frankly, it's become apparent to the council that the appellant doesn't want to do that. It's obviously disappointing because council's put some effort into trying to engage with the appellant on that, but no doubt the appellant has its reasons. And I think those reasons are pretty obvious. But yeah, it was a bit of a surprise, frankly, that the appellant put in to your case officer the document that it did whenever it was. I thought it was this morning, but I think it was actually late last night. Mr. Felton, I think I only got it this morning, but I think it was late last night.
Yes, I think my case officer received it at 20:58.
Yes, and I mean, really, madam, it creates a somewhat awkward situation because obviously what the appellant is seeking to do is put evidence before you that isn't before you yet. The council's usual position applies. It doesn't ever seek to stand in the way of evidence if it can possibly be dealt with. And so what the council have done in an instant response from Mr. Felton, I see, is sent the version of the statement of common ground that the council sent to the appellant last week, to which the somewhat surprising from the council's perspective response was this document that your case officer got from Mr. McCurry late last night. I should say it's not a statement of uncommon ground because it has sections that are agreed, which the council doesn't, of course, accept as the right way to present those matters. But in any event, it is probably, madam, probably just to cut through, the best thing for you just to read those various emails. I'm trying to imagine how it might affect the structure of the day, but the best thing is probably for you to read the various emails and their attachments, of course. And then if you've got questions, perhaps we could discuss those questions around a round table or a sub round table, because both viability consultants are available today. But I suspect that once you've read them, it will become pretty apparent that this is now a matter for submissions. Actually, is my suspicion.
Ma'am, I mean, just before we move further, I mean, just a brief response from me. I mean, I'm afraid it's not correct to say that the purpose of the document was to agree the maximum viable 3 beds. We know from the way that questions were put to Mr. Scott that Mr. Ashdown had taken the view that it was not going to be viable, even in the absence of any affordable housing provision, to provide 30% 3-bed units on the site. And part of the discussions that were going to take place between the parties was to allow that position to be hopefully confirmed. And as we said at the last session of the inquiry, part of the problem that's being created and why we're discussing it today was that what we understood to be an agreed position following on from those discussions, we were suddenly being told at the inquiry that it wasn't. So the purpose of the discussions was not as has been mentioned today. I don't want to, again, get into too much detail, but again, we don't accept this sense that the council is somehow expressing disappointment at documents that have been produced last night. That document follows discussions that have been taking place for some time. You may not have seen the result of those, ma'am, but the document was being drafted in an attempt to try and see if agreement could be reached by the council. So these matters have been going on for some time, including exchange of drafts on Wednesday last week. Now, as far as we're concerned, the council shouldn't be disappointed or surprised that we weren't going to agree a document that was sent back with more than half of the contents being changed. And what we've tried to do is at that stage help you by preparing a document which allowed the respective positions of the parties to be set out. It's been called a statement of uncommon ground because although it identifies certain limited areas of agreement, fundamentally the parties are still at issue. And we set out our position. What's disappointing, in fact, is that we've made the effort to prepare a single document which allows you to understand our position and then for the council to express theirs. What you appear to now have is our document with the council sending another one. But be that as it may, we don't have any objection to you reading those documents. I agree that much of this can now be dealt with by way of submission, because at the heart of it is really a difference as to how the policy should be interpreted. But I would say that part of the discussions that took place between Mr. Ashdown and Mr. Scott, as I said, related to the basic proposition that 30% 3-bed is unviable, and some of the information you have in front of you is the appraisal work which demonstrates that. And that was the reason why this document was being prepared. It's a good reason for you to consider it.
So, Madam, firstly, what you have before you does not demonstrate that 30% is not viable. Secondly, don't need me to tell you this, but the questions that my learned friend puts are not evidence. It's the answers given by witnesses that are evidence. And you'll recall Mr. Ashdown's evidence in response to questions from me concerning the possibility to optimize, or whatever word one uses, the number of 3-bed units by different numbers of the other unit types. And you recall that discussion about how studios are the most valuable per square foot and so forth. And you know that hasn't been done. And but maybe we were ships passing in the night yet again. But the council's understanding, as the last day of the inquiry, hence all those discussions we were having in front of you, was that there was going to be an attempt to identify that number. Now, maybe the appellant has done that work without letting us know, but certainly hasn't been willing to do that with us. And as I say, that's disappointing, although we suspect it is pretty obvious why that hasn't been shared with you. Now, there's the reason the council was and is surprised that the appellant firstly rejected the statement of common ground that Mr. Scott had suggested last week, and then put in front of you without telling us the version it prepared on Friday, is, as I think Mr. Feltham has said in his email, things as basic as the appellant not even being willing to agree tables showing the number of units, different types of units in these quote scenarios that Mr. Ashdown had modelled. I mean, it really does seem to the council that it was from whatever point in the process, it became apparent that the appellant just did not want to engage in this. But we are where we are, you know, and frankly, the evidence is what it is, and we'll make submissions on it. And I don't really see it's going to be of much benefit to go back and forth over this.
So, Mr. Burton, from your perspective, as I said, I've not looked at this evidence yet. So would there be a requirement from yourself to cross-examine Mr. Ashdown again? Or are you saying, no, I will deal with it in submissions?
Well, I think, madam, that I don't see a requirement to cross-examine Mr. Ashdown. I do. Well, I'm quite content with what his evidence is and what it isn't, as it were. I'd see the possibility that once you've read the documents, you may have questions which would need to be aired in a round table.
Okay. From your perspective, you're content that it can be dealt with from your perspective, that it could be dealt with in a round table session, not through cross-examination. Okay, thank you. And Mr. Linus, your comments on that approach.
Ma'am, if you have any questions after reading the documents, then I'm sure it could be dealt with in a round table session as a prelude to any submissions that are made later.
Okay, thank you. Okay, well, I will need time to have a look at those. So there is now a choice. I could adjourn to go away and have a read of these documents and then come back so that we can deal with the deal with this as a roundtable session as part of the section 106, as it's all interlinked or partially interlinked with that, but obviously the 3-bed is not part of the section 106. Or we could move on to subject to there not being any other updates, we could move on and deal with planning conditions first. And then, having done planning conditions, then have a decent break so that I can read all of the relevant documents and then come back and we can have a session dealing with the 3-bed as a round table, and then have a roundtable session on the planning obligations. I know they're interlinked. There's an element of interlink there. Yeah.
Well, madam, that certainly sounds sensible to me. I mean, I'm taking instructions on it. Could I just make one point clear there, madam? When you come to read those 3-bed documents, one of the things you'll see in the document the appellant's put in front of you, and I've only had a quick scan of it, but it looks like there's quite a long purported account of who said what and when, and so on and so forth. Now, that certainly, I would object to that going in that what I fully expect you will do, madam, of course, is refer to the evidence you've heard. And I don't see it as a useful expenditure.
I'm sure both sides will agree that I am really not interested in who said what to who and when. I'm interested in the evidence. So that's what I want to get to the crux of exactly what the positions are. It's irrelevant about this has been delivered late, or this has been delivered, we haven't had an opportunity to do this, that, and the other. I'm not interested in that. I'm interested in what actually is the evidence, because I need to have all of the evidence before me so that I can make, my decision. So absolutely, there could be elements of the evidence that's in front of me that I don't accept on that basis.
Well, ma'am, I think you need to read the documents. Obviously, I suspect if I understand what Mr. Burton is referring to, then obviously you can't assume that whatever you see in the document hasn't already been given in evidence, including by Mr. Ashton at the inquiry. So I think you just need to read the documents, then we can come back to these. But I don't accept the implication that appears to be made by Mr. Burton there. There may be information there about emails that have been exchanged outside the inquiry, and you can take a view when you read that, ma'am, and come back to this later.
Okay. Thank you. Okay, so that's the as you said, I will let me read that evidence. I won't release the two viability witnesses completely from cross-examination yet. I know you have both said you don't think that it is necessary to cross-examine, but I just need, until I've read the evidence, I actually don't know what the best procedure may be to actually, whether actually I do need that cross-examined, because I need to understand this, that, and the other. So, so bear with me on that. What I would therefore like to do now then is to make a start on looking at the planning conditions on the basis of us swapping the agendas around. Then, does that cause any issues with anybody? Does anybody have any time restrictions in terms of the respective your respective witnesses or?
Ma'am, no. Mr. McCurry is going to be leading on conditions, and I don't understand him to have any time constraints today. Okay.
And anybody else who's dealing with planning conditions, there's no.
I've just checked
on the planning obligations. There's no issues there in relation to swapping it around.
Conditions, madam. Yeah, yes, no.
If we do planning conditions now, does anybody need to prepare? Because obviously it was supposed to be a little bit later.
No, I'm just double checking. I'm looking at our team WhatsApp. There's no issue there. Mr. Felton will be leading, but we also have Mr. Maguire, because you'll have seen there's an issue over the energy condition. So Mr. Maguire's available as well, I believe.
Okay. Okay, because I don't know how long obviously we're going to be sitting today. Hopefully, and I always say this, but wishful thinking, we won't sit too late. But this inquiry hasn't quite worked out like that. However, I think we can get through the conditions. I have a certain process that I go through when I deal with the conditions. So it does mean going through each condition in quite a bit of detail.
Could I check one thing, madam? Because there have been various emails about conditions. What is the email to which you are working?
I am working to the planning conditions that I was sent last week by the deadline that I stipulated. Yeah. So that was by Wednesday, close of play Wednesday. So if anything has been, and I'm not proposing to look at anything new, you can tell me in the session what's been updated, because all my notes, and you'll be pleased to hear I've actually got a written version of this rather than it's on the screen. all
I
of
think
my
that's the
notes.
first.
Yes, I know it's the first time, but it's actually the easiest way of dealing with
Yeah.
planning conditions. I have my notes against each planning condition and what my queries
Yeah.
are, etc. So I'm not proposing to look at anything updated at the moment. Obviously, if
Yeah.
as we go through each condition, you say, oh, we've now agreed this, can you just look at the updated version which is on the email? I'm happy to do it then.
Sure, madam, but just so I at least am clear, but it might help everyone else. I think that means that the version you are working to is not the version that Mr. McCurry produced in response to a request via your case officer that the conditions be ordered in terms of order of
Oh yes,
appearance.
yeah, no, that's the one I'm referring to, the one that where they've been ordered.
Right, you are referring
Sorry,
to
so
right.
yes, sorry,
Okay.
you are correct. Yeah, I sent yes. Sorry, so it's
That's
not
fine.
the ones that were sent through.
So
Yes.
just to take one example to double check that. Condition
Yes.
13 in your list is one that begins a single detailed energy statement.
Indeed.
Great. Okay. Thank you.
Okay, so on that basis, shall we make a start on planning conditions? Now,
No,
before I make, sorry.
I'll ask Mr. McCurry to put his camera on if that's going to help you, ma'am.
It is on.
It is on.
Oh, is it? Sorry, he is not on my screen. I see him now. Thank you very much.
Okay, thank you. Now, before I make a start to go through the conditions, there are a number of informatives that have been attached. There's 43 conditions, and then there are 12 informatives. Now, informatives have no legal status, and as inspectors, we don't add those to any decisions should we be minded to allow any appeal that is before us. So just be mindful of that, because I know that the informatives include definitions of wording, etc., etc. So just be mindful of that, it could mean some changes to the conditions to make sure that that's included as part of that aspect, to make sure that the conditions are precise, etc., etc. Now, just for anybody watching who is wondering why I'm going through conditions and planning obligations, and I did set this out in my introductory statement, but this is a standard procedure. It doesn't mean that I've made my mind up on the case at all, and it purely is trying to ensure that I have all the evidence before me so that I can make my decision. It doesn't prejudice my decision in any way, but I need to go through these aspects so that if I were minded to allow the appeal and that decision has not been made at all, because I haven't made my decision on this, I need to go away and consider all of the evidence before I make that decision. I need to go through the conditions and the planning obligations in quite a bit of detail to ensure that they meet the required legal and policy tests. So just so that anybody watching is wondering why I'm going through this, then hopefully that clarifies that particular point.
Yes, ma'am. I mean, Mr. McCurry can comment as necessary, but certainly I can see your point on the definitions and interpretations, so-called informative. That doesn't strike me as informative, and if that relates to other conditions, that will need to be brought into the conditions. Looking at that page, there is a reference to the piling method statement, which again has slightly more of the character of a condition rather than informative. So I do take the point, at least in relation to those two. I suspect as well the others do look a bit more informative and aren't actually informatives in any event. I mean, the first one about the council dealing with the applicant in a positive and proactive way, regardless of what we might have to say about that. It doesn't even strike us as, as an informative anyway. So
No.
You're right. I think we need to review that. 10 and 11 in particular look like matters which may need to be brought back into the conditions themselves.
Yeah.
Well, there is a condition on piling, so whether that can be brought in to that.
Yeah.
And I'm not necessarily expecting today for the absolute wording to be set out. That will be a matter for myself, obviously taking into account the national model conditions as well, and whether any of those are relevant. What I want to ensure is that there are no, should I go through the process and be minded to allow, and as I said, that's without prejudice to my ultimate decision, then I don't want there to be any surprises in terms of any planning conditions. So that's why I need to highlight everything today. But obviously, the ultimate wording maybe that will be up to myself to decide. So on some of these, it will be more about the principle, and others it may be that we do need to go into a little bit more detail about the actual wording themselves.
Yeah, could I just flag, and you've obviously got this, madam, but that informative 10. I mean, I believe what's happened is I think the appellants, as it were, done the first draft, the council's commented and so on, but I mean, that immediately jumped out at me as quite an issue. Of course, we don't have a description of development that is phased, and I may be missing it, and Mr. McCurry can set me straight, but I'm not aware that one can take the plans and drawings and extract from the plans and drawings everything in that list of the so-called defined phases that's in that informative number 10. So that
well, that was going to be one of my questions was going to be about phasing, because obviously there are some plans that set out phasing, but it's not in the, as you quite rightly said, it's not in the description of development. And so that I was going to come on to the phasing aspects when we started when it started to come into the actual conditions themselves. But actually, what does that mean? And how does that meet the tests? And how does that relate to the development? So that is a concern that I have about, actually, you're talking about phased development, but there isn't phased development in terms of the description, but there are some plans that relate to phasing. Yes,
but so, as I say, that even the plans, so far as I can tell, don't set out. Even the plans don't set out the entirety of those phased stages, as it were, in the definition.
No, because they only refer to phase 1 and phase 2.
Precisely.
Yes.
Yeah.
Which was another question I was going to raise.
Yeah.
Yes. However, where are these council conditions that have been put forward? Because ordinarily it's the council that decides what the conditions are. So I was going to obviously come to the council first in looking at any of the conditions and actually say, okay, why have you said that condition is necessary? And then obviously come to the appellant for any additional information, etc. So, or is this more? I'm just trying to understand, because phasing is in there quite a lot. So I'm trying to understand from the council's perspective, why have you put phasing in on those conditions?
Yeah. In terms of that, as Mr. Burden said, they were drafted by the appellant, partly sort of due to our resourcing, and it's just seemed we can make quicker progress by doing that. So then we've
which is what I thought, but I needed you to say that.
Yes, absolutely.
Okay. Can we just start to go through that's a fundamental issue. So can we just start to go through? I might be able to tick off at least a couple of conditions without actually having to go into major detail. And then we are going to have to start going through actually what does it mean by when it mentions phasing, but there are other aspects that where a lot of these conditions need to be reconsidered or considered or potentially removed. But I really want to understand the council's perspective and because it's the council who's going to obviously need to enforce, etc. Sorry, who was that?
Sorry, madam. It was myself, Mr. McCurry. It was just slightly in response to Mr. Felton's comment, just quickly, and just so you understand the context. We obviously did start the drafting of the conditions. We've had a lot of back and forth with Mr. Felton, and who's obviously consulted others as necessary. The table you've got obviously shows a lot of green, and I know it's for your consideration, but it was just to indicate that, you know, we have agreed with the council those elements in green, and there were 4 conditions highlighted in red where we had not agreed them. Now, I know we need to go through them from your perspective, but it was just to say a lot of work had been done going back and forth with the council confirming to us that they were happy with those listed in green, as opposed to I didn't want it to be suggested that these were drafted by us and no,
Mr. McCurry, I fully understand that, because obviously there is agreement. So I'm fully aware that the council, looking at the list, the council doesn't have any issues with the vast majority of the conditions. I may have quite a few issues with a lot of the conditions.
No, understood. And then the second quick thing,
which is fine, because obviously I'm looking at it from you obviously got the legal tests, but I will mainly be looking at it from the 6 policy tests. And for anybody viewing, that's the 6 policy tests that are set out in the framework, which are necessary, relevant to planning, relevant to the development permitted, enforceable, precise, and reasonable in all other aspects or respects.
And then just the other thing I wanted to mention was just on phasing. I mean, obviously from my perspective, the application, you know, as I prepared it and lodged it, was on a phased basis, and that was obviously set out clearly in the phasing plans. From my perspective, I'd be interested in from a principal perspective about the lack of phasing in a description, only because obviously I deal with many applications, very large ones that are multi-phased, and I don't really see that, you know, that phasing is picked up in the description. It is generally picked up in the drawings themselves, which are then listed in the conditions. So I just wanted to understand that, because I didn't see it was necessarily a penalisation, as it were, just because because it isn't identified in the description as a phased development. It's quite clear in submitted drawings, which they would be listed. Just on those definitions, phase 1 and phase 2 are obviously referring to the drawings. I think it's phase 2A and 2B, which may be the ones that we might need to discuss further, and if necessary, add into any conditions under the informed 10. Just to add those points from my perspective.
Well, let's just start to go through, and then it could be that it may become clearer as we start to go through the conditions. But thank you for that, Mr. McCurry. And as I said, I'm using the list that has been put into the order that's recommended. It doesn't have to necessarily be in that order, but it's the recommended order that is set out in the planning practice guidance. And it's the order I prefer to do conditions in, as it makes a bit more sense. So condition 1, I don't have an issue with that. That's a standard time limit condition. And condition 2 is the approved drawings. Again, that's a standard condition, so I don't have an issue with that. I just want to confirm that are both main parties absolutely clear that those are the correct drawing numbers? I will obviously need to check those myself, but from both of your perspectives, I'm looking at Mr. McCurry and Mr. Feltham.
Yeah.
Yes. Okay.
I'm comfortable.
Okay. Thank you. So I'm not going to be asking any questions about those because they're just standard. So moving on to pre-commencement conditions. And I think there are 12 in total on this, starting at condition 3. And the first one is an external materials condition. So it's going to get a little bit repetitive here, but my main question is going to be, how does each condition meet the tests? And those are the 6 tests. So doesn't necessarily mean, because obviously each needs to meet each of the 6 tests. Now, an external materials condition, not necessarily an issue. That's pretty standard on the vast majority of planning applications and decisions and grants of planning permission. But this is where for the first time phase is referenced. So for each phase, a sample of the external materials to be utilised on the building, etc. There is some duplication of wording as well.
Yeah.
At the end of the first sentence. So just exactly the reasoning behind the different phasing. So why is it necessary, and for each phase a sample? So you're expecting, so is it my understanding from the council's perspective that you're expecting that for phase 1?
Yes, absolutely.
If that is the case, or are you talking about, are you saying that the development in its totality, you want all of the external materials set out there and then? Because obviously this is the first time that phasing is mentioned.
Yeah. So this was one which was under some discussion, but I took the view that we could have the materials submitted in relation to phase 1, and deal with that, and then obviously before we move on to phase 2, we'd have the materials for phase 2. They wouldn't necessarily need to be submitted all prior to the commencement of the development, was my view.
So from a council perspective, do you see any issues in reference in the conditions to phase 1 and phase 2?
I suppose
I'll come to Mr. Feltham, and then whether you need to bring Mr. Burton in, it will be up to yourself.
Yeah, I mean, I suppose obviously the only challenge I suppose there is in relation to the definition of that. Now and we're coming on to the unilateral undertaking later, but obviously there's appendices submitted there in relation to phasing. So to some extent, I'm going from those two phases there.
Well, obviously, Random, if it's if it's a question of simply referring to phase 1 and phase 2, which are the phases not broken down, as it were, that
Yes.
aren't shown on the plans and drawings, then at least we have a solid basis for that without having to worry about,
Yes.
do we write a condition with definitions? Eek. Yeah, so long as it's not breaking down into the A's and the B's.
I suspect that's why the conditions have been phased that way, because if phase 2A is the demolition of existing retail units, then one's not going to be contemplating materials in that divided way for phase 2. I think there's no disagreement with the principle that because you're going to have the detail of each phase being progressed at different times, and they're being treated as distinct phases, as Mr. Felton has said, that there's no issue with the principle of the condition. You don't need to have all your materials approved before even TAR 1 begins. So unless I hear otherwise, I've misunderstood. The assumption was that those reference to separate phases was intended to relate to phase 1 and phase 2, rather than extending into further details, splitting phase 2A and 2B, given that phase 2A was purely about demolition.
Yeah. Okay. So what I suggest then that the wording that presumably one is looking for here is wording that refers, well, back to condition 2, because that then avoids the need to define anywhere else or anywhere what phase 1 and 2 is.
Condition 2 includes the phasing plans. Yes,
it does. Yeah.
The purpose of that condition, I suspect that's yes, because if we're referring back to the phasing plans, then that would identify phases 1 and 2.
It does, yes.
Exactly. Yeah.
Okay. Thank you. Now let's move on to 4, and I may also look at 5 at the same time. I know one deals with demolition, one deals with construction in terms of the logistics plans, or they usually doesn't matter what you call them, but they're demolition management plans and construction management plans, aren't they? So logistics is just another way of saying that. Now the demolition one. Now, again, just clarity about that, is that's not a pre-commencement for the entire development, is it? Because the demolition, am I correct in saying that the demolition only comes in when phase 2 is built? Am I correct on that? There is no demolition in relation to phase 1, or am I wrong on that part?
I believe you're correct.
Yeah. Okay. I mean, strictly speaking, ma'am, the materials condition isn't a pure pre-commencement.
No, it's not. It's above ground works, isn't it?
Yeah. So you're right, ma'am, to say that although there's an element of pre-commencement, because some of these conditions will relate to matters that need to be done before the commencement of phase 1, strictly speaking, because they're being gathered together to deal with some phase matters, it's pre-commencement and phasing, actually, strictly speaking.
Okay.
I think you're right in relation to condition 4.
And in relation to, is there a particular reason why demolition and construction needs to be separated in terms of setting something out in a logistics plan, as it's termed?
It may be that whether or not it's strictly regarded as demolition, need to think about this. There's obviously some work being done at level 22 in phase 1, the TAR. Now, it may be that the intention was to split this condition by reference to each phase, just to make sure that to the extent that the council considered that any works involved work that needed to be controlled, then there was the opportunity to control that within phase 1 as well as phase 2, where the retail units were going to be demolished. So it was for the avoidance of doubt to give the council control in the event that there was phase 1 works which they wanted to be controlled by way of the logistics plan. I think that was a broad intention behind it, to avoid any doubt about whether any works covered in phase 1 should be controlled in that way. I think there's plant being moved from roof level as well in TAR 1. So I think it was just to make sure that the council had control over the logistics of that work. even if there may be technically an issue as to whether you'd call it demolition in the legal sense.
Okay. Okay. And again, the listing of the provisions that need to be set out are exactly the same in 4 and 5.
Yeah.
Yes.
Yes.
So will there be differences in terms of the demolition logistics plan compared to the construction logistics plan?
Instinctively, ma'am, there may be, in the sense that demolition works may raise slightly different issues in terms of the controls that are required when compared with the construction works. Obviously, different things are involved. If one takes Tower 1 as an example, what one's doing is, as part of any notional demolition or works to bring T1 into a state to then develop, they may be different compared with the construction phase. The same may well apply in phase 2. So I suspect the rationale is that although the list is the same, the nature of the actual works that need to be approved could be different. If ma'am, you're keen to keep the conditions as neat as possible, I don't see any reason why condition 5 could be tightened up just to make sure that the provision, the list that's made, and the list that's referred to in condition 5, rather than relisting everything, just refers back to condition 4, if one's repeating the same matters.
And is it clear, now you've referenced obviously phase 1 and that there are some works, whether you can call it demolition or not? I'm just trying to understand whether the start of the of condition 4 saying no demolition shall commence, is that precise enough so that it can cover phase 1 if necessary? So that the council is able to ensure that that's covered, that phase 1 works if it's deemed to be demolition. Is it tight enough? Is it precise enough?
Well, if one reads the conditions, no demolition shall commence until demolition logistics plan has been submitted in respect of each phase where demolition will occur. So, I mean, I think in the normal scheme of events, if it's anticipated that might encompass works in phase 1, that would be the subject of discussions with the council to check whether that condition needed to be complied with in respect of phase 1, and it's offering the council the opportunity to require that plan to come forward in the event it thinks a demolition would occur. So it's really giving a degree of control and flexibility to the council. So
sorry, madam.
I was just going to ask for the council's comments on that. Are you content with that gives enough comfort?
I think it's a good point you of course you raised, madam, because whilst the appellant may be comfortable, or rather willing not to argue the toss about whether or not is or isn't demolition, that might not be the case with the subsequent developer. And if the intention is to ensure that whatever is needed to be done in terms of knocking out bits of level 22 and moving the plant is captured by this condition, then doesn't the wording need to be amended to remove the wording of each phase where demolition will occur, and just say of each phase? So remove those words where demolition will occur.
Yes, because then it makes that's an option. So appellant, Mr. McCurry or Mr. Linus, any comments on that?
I think that would be acceptable.
Yeah, I mean that seems fine.
Okay, thank you. And just a question just to make sure that I understand. Are all the elements that are listed, most of them look pretty standard to me, but just so that I hear it from yourselves, are all the elements listed reasonable and adequately precise in terms of the A to M that are listed in terms of the requirements, given the size and scale, the size of the site and the scale of the development that's proposed? Obviously, I know that the council and the appellant have agreed that yes, this makes sense, but there's nothing missing out of that area, or nothing that's too onerous that that can't be enforced, or there's nothing that's not precise?
One thing which actually, just reading through, I wonder if we should also have is the routing of vehicles, just so that we that can control that, so that we don't have these large vehicles going down residential streets and things like that. So they're using, obviously this is accessed via a main road anyway, but it's just to try and encourage and make sure that vehicles come, if they can, via the A3 and onto Tolworth Broadway. So that might be another one to add at point N, which I think I don't see it there.
Mr. McCurry, any
Quite,
queries with that?
For me, that's quite a standard matter to deal with in such a condition, so I wouldn't have an objection to that. It should be quite straightforward here as well, as you say. I'm sure it will all come off the A3 anyway.
Yeah, we just want to make sure that it does.
Yeah, I think that's fairly that's reasonable from my perspective. The only other thing I would add to this is I'd just like to highlight that there are a couple of elements in this condition, in particular Part M, where we've got arrangements for keeping the existing service area clear of compound storage materials. I think the parking vehicles, there were some bits that were specifically added in just to deal with M&S as well, and their requirements, just to ensure that their servicing area at the back is maintained at all times. I just want you to be aware that we've been very mindful of the fact that there are M&S in particular and other and the hotel that will continue.
Yes, there are existing businesses already there that will continue. Absolutely, yes.
So I just want you to be aware. We've been very mindful of that. And
okay, thank you, Mr. McCurry, on that. Anything else on 4 and 5? Is there anything you want to add to 5 as well? Again, the routing of vehicles, of construction vehicles, etc., or vehicles in relation to demolition, which is obviously what we've just added, or potentially I would be able to add that to condition 4. But anything different for 5, which is to deal with construction?
So anything other than the addition of that routing subparagraph N or whatever it would be. Mr. Felton?
No, just that, yeah.
Yeah.
I mean, the aspect for me is this is where obviously in condition 5 we first see the reference to phase 2B.
Yes.
So, and that's obviously picked up in the definition in informative 10, where we are referencing phase 2A and 2B, 2A being the demolition of the existing retail on the Broadway and 2B being the commencement of development of new build Broadway. Those are broken out for the reasons of SIL, that obviously in demolishing retail on the Broadway, SIL would not be payable until commencement of construction, which we put under 2B. So those are the definitions in there, and it's whether or not we would want to bring in any explanation into condition 5 as to what 2B is referencing. So there's no construction of phase 1 or or its construction, like I say, of the phase 2 development, which we defined in that informative rolling. So yeah, in the informative 10, we said 2B means the construction of the 2 new buildings.
Yeah, I'm just wondering. I'm just wondering. Does the appellant need to? Sorry, I mean, does one need to actually go as far as those subdefining it to do to 2B? Because presumably there won't be any construction in phase 2 until one gets to what is actually defined as 2B, which it won't be defined as 2B because we won't have the informative, but until one gets to the building bit. And unless I'm missing something, and people might say, oh, well, erecting false work for demolition purposes is construction, or unless that's the concern. Is that
I think
the purposes of so I think for the purpose of condition 5, if this is about construction, and it's clear that construction isn't going, that's only going to cover the sort of positive acts of construction within phase 2. Yeah, and you could refine that condition anyway, in the way it's been suggested. So it would be no construction under phase 2 shall commence, because you don't need to have the distinction drawn for the purpose of that condition.
Yeah.
And can I just confirm, are you expecting 2 separate logistics plans for each phase?
Yes, that is. I think the way the condition is structured anticipates that, because you'd have separate submissions of separate plans for those phases. They may say very similar things, but bearing in mind, of course, there's a lot more going on in the second phase than the first, so they're probably going to be different.
Yeah.
Okay.
Yeah, they would be separate.
Okay. Anything else anybody wants to add on 5?
No.
Having reread it. Okay, let's move on to 6 then. And again, not sure this is a pre-commencement, because it's only pre-commencement to development associated with the ground floor freestanding retail kiosks, so I just want to understand, what does that mean? Because you're asking for design details and refuse and servicing arrangements.
Yeah, I mean, so the proposed drawings indicate the location of 3.
It does, yes.
Kiosks, under the existing tower. So in liaising with Mr. Feltham, obviously it's been understood that there are no details submitted with the plans for those. So in principle, we were quite happy to submit information about what those kiosks, would, as it says in the condition, what it would look like, etc., how they would function before they're erected. So I take the point, they're not pre-commencement to the entire development. It's pre-commencement to the erection of those kiosks.
Okay, so so would there be any specific development associated with that, other than actually just putting those retail kiosks in that location? So is there any servicing or any development that needs to occur before, any groundworks, for instance, that need to occur before those kiosks are put into place? I'm just trying to understand whether.
Yeah, I'm not aware that any groundworks will be required from.
Well, my understanding is that they're just freestanding retail kiosks. So
freestanding kiosks that would probably be wheeled into place, to be honest, and it would be a case of how they're serviced in terms of electricity. I suppose, you know, how they're plugged in, what they look like, and then they say how their waste and refuse is dealt with. So my understanding is, yeah, they're highly likely to be, you know, kiosks on wheels that are just placed in position.
Okay. And the element that says thereafter retained as such, what does that mean? And is that reasonable in terms of that element of the clause? So the retail kiosk shall be developed in accordance with the approved details. So that's in relation to the design and the servicing elements, and refuse, etc. And thereafter retained as such. What does that mean? And does that meet the tests?
I suppose, yeah, it's just there to ensure that it can't then be changed, I suppose. But I think that's the point of it. Okay. If there were any changes, well, then we'd need some more details.
You'd want a variation or whatever.
Or yeah, that's right, absolutely. Or a planning application, or
a new planning
whatever.
application. Yeah.
Absolutely.
Okay.
Yeah. Okay. So it's a good one. In the event that these kiosks may or may not be interchangeable, for the want of a better word, you know, if they're somewhat temporary, it would be a shame if there was a new permission required, and whether the condition could deal with any, you know, changes beyond the original kiosks that were placed. So let's say a kiosk is put in, and then a year later it's swapped with a different kiosk.
Yeah, well, this is my slight concern. Is it reasonable to have that retention element there? Because things can change, can't they?
Yeah, I mean, we can probably visualize and understand the nature of these.
We all know what a kiosk looks like, and they can be varying. They vary quite significantly on what they look like.
Yeah. And I don't think it's not the suggestion that we wouldn't be happy to submit design details of any changes, but it's just whether if any changes.
I think, ma'am, is partly to ensure that no changes take place that might have an effect on things like refuse and servicing arrangements. So potentially there's scope, which I can't really contemplate at the moment, but I suppose what's being thought of is in the condition is that changes are made to the kiosks or the way that they are used, which has an effect on the arrangements for refuse and servicing. And the idea is to make sure that there's still control over that those things don't change. And that's why the retention is required by the condition.
Yeah, I mean, is one allowed to suggest that one has at the end unless agreed in writing by the local planning authority?
Oh, I don't like tailpieces.
I know.
Well, I think this is one area where
that's a bit dodgy. That one, yes.
Well, Mammy, given it's retail kiosk as part of a much larger development, I suspect there could be a debate on whether the tailpiece would be problematic. But I take your point. I mean, I don't think we have a particular problem with the retention, in the sense that if changes were going to be made to the kiosk, which could potentially have an effect on refuse and servicing, the idea was that the condition provided the trigger to make any developer seek approval for that.
Okay.
So it's just providing a particular level of control over the kiosks.
Okay, thank you. Okay, thank you for that. Let's move on then to condition 7, which is the in relation to the fire statement. Now, I understand that this is, and this has got a tailpiece clause phrase in it. So we'll come to that shortly. This is not a complete rewriting of the fire statement. It's an update, really, to provide the additional information. Am I correct on that? It says a revision of the fire statement, but it's because obviously the fire statement exists.
Yeah.
And then it provides a list of what needs to be provided.
Yeah.
So it's just understanding the necessity of that and how it meets the tests, and you know, particularly in relation to obviously the great importance that is attached to fire standards in relation to taller buildings, etc.
Yeah.
Can the council just explain the reasoning behind because obviously you've agreed that yes, you're content with this, the reasoning behind these additions or these updates that need to be made to the fire statement?
Yeah, I mean, well, this is based on a standard condition which the GLA have provided us.
Okay.
That's I'm looking at they've following the London plan, new London plan. They've given us some standard conditions, and this is, I think, pretty much identical. The only change probably is that it's just to provide that update to make sure that it meets everything that it needs to do, and that this also follows in relation to condition 8 as well, which is also something that the GLA have given us as a standard condition for us to look at in terms of all of these major developments. But yes, I mean, I think there's.
So it's not saying that the information isn't already in the statement. Then it's just a standard condition.
Yes, I mean,
GLA requires.
It's. I'm just looking at the one which is standard. So in terms of what is slightly different to the standard is the first bit where we're talking about the revision of the fire statement. But I mean, actually, what I suppose these vary. So from the one they've given us actually is in relation to sort of older cases now. So I suppose what we're saying is that there will need to be some amendments looked at in relation to the fire statement version 01, and it's going to deal with all of these 6 points to come up with a fire statement which we and ultimately probably the GLA are happy with, because I suspect we will ask them to look at that as well.
I mean, I think the difficulty, ma'am, with this is that obviously we're in a situation where fire safety is an agreed matter, and the appellant had produced a revised fire statement as part of its evidence. And some of the drafting of that condition sort of suggests that essentially almost a new fire statement has to be produced in circumstances where we already have an agreed fire statement. Because that list just looks almost like a list of features that need to be covered by a fire statement in general terms, and we've already provided one that's been agreed. So it seems difficult to understand why the condition is necessary in circumstances where there's agreement between the parties that the fire statement produced is acceptable. If it's intending to seek further details on matters having reached an in-principle agreement, I think one could start to understand it, but it's not clear why the condition in principle is necessary if there's essentially a fire statement which has been agreed already.
I suppose the one area which I don't think has been agreed is about the requirements for the number of lifts.
Yeah, I mean, I think that's a fair point in the sense that we know that matters continue to be discussed on lifts after the fire statement went in. So one can see why that might be a particular detail which needs to be confirmed as part of the fire statement beyond what has been submitted. There may conceivably be circumstances where one just needs to confirm that matters haven't sort of changed between the fire statement that's been submitted and immediately prior to commencement, but that doesn't appear to be the way that the condition has come forward. So we entirely take the point that insofar as the debate has taken place regarding lift provision, and that seems to be covered by means of escape, and potentially how provision will be made to enable fire appliances to gain access potentially. But some of these matters appear to sort of cover ground that ought to have been agreed as part of the fire statement.
I just wonder if because we don't yet know what, if we go down to 8, we don't yet know how many lifts will be required and quite how that will work. So once that work's been done, then does that not then feed back into 7 to say, well, okay, so what is now your final fire statement? I don't believe we're expecting many changes, and it may be there won't be any changes, but that must have an impact on number 7 once we've decided what situation is in relation to number 8.
Yes, well, maybe you combine the two conditions just to require a revision of the fire statement, confirming details of the 1 lift per elevator core. So I entirely take the point that if further discussions have taken place and there's further material required to confirm the position on the elevator core and the lifts, that should be incorporated into the fire statement. I can understand that, but whether you need both conditions to do that is questionable.
Probably particularly point 2, isn't it, of condition 7, where we're talking about means of escape and fire evacuation lifts and how that.
I think the difficulty is it's not clear whether the GLA suggests this as a standard condition which just requires a fire statement to be produced in all cases, or whether they think there are further particular details which aren't in the fire statement relating to those matters which need to be progressed in further detail. And we know certainly the issue of the elevator core is one matter which does need to be secured by way of condition, but it's not clear why the GLA is looking for the other matters in condition 7.
Well, look, all the other matters, obviously, they look certainly very sensible. So the question is, are they already covered?
Yeah.
I mean, it seems to me we could either spend, well.
Yeah, I mean, take the point. You could either spend half a day checking whether all these matters are in the fire statement, or one accepts the condition on the basis that there what the intention may be, although we can't confirm it. The intention may be that the GLA just wants to it's happy with the fire statement, but it just wants to confirm matters of greater detail as they come through prior to commencement. And I think we've agreed the condition. And I think, unless I'm told otherwise, we'd be prepared to proceed on that basis, that it's really a question of looking for details which are essentially substantially in accordance with the fire statement, but just give a little bit more detail beyond what is there, even though what's there is acceptable.
I mean, when I read this, obviously I'm fully aware that there's an agreed fire statement in place. I looked at this and thought, oh, is this too onerous? But actually, if the information is already there, it's not very onerous in terms of any conditions, and it would only require some revisions where necessary. And then otherwise you can still point to what is already set out in the fire statement. If it's still relevant and doesn't need to be updated or revised.
Although if that's the intention, ma'am, I mean, just for the avoidance of any doubt, what we wouldn't want to happen is for some reason this condition is then treated as a basis for opening up matters which have already been agreed at the moment.
Yes.
So it may be, rather than it being expressed as a revision of the fire statement, we draft it to make sure that a fire statement, let's just see.
What about an addendum? I mean, a full revision is.
Don't suggest an addendum. That would definitely be more work.
Yeah.
I think.
Is it just an update of detail of because a revision, to me, a revision is usually quite significant. The term revision just means something is significantly revised.
The way it's done in other conditions is that you have
supplemental
details of the following matters in accordance with the fire statement version 1 shall be submitted to and approved. So it's made quite clear that you're building on the existing fire statement, requiring further details rather than having a whole-scale revision to the statement itself.
Yeah,
so
well, that works.
Okay, right. And obviously there is a tailpiece phrase. So understanding why that's there.
I suspect, ma'am, this isn't the case where one would be fundamentally changing the development or materially changing the development that's been approved. There might be, for example, minor changes to things like fire alarm system within the building, which could be approved without going through a sort of full amendment to the condition, as it were. But if you have any concerns about the tailpiece, then for the avoidance of doubt, you would remove it.
Okay, thank you. And the suggestion about combining 7 and 8, is there any reason why 8 needs to be standalone when it is the two items are linked, aren't they? It's all about fire safety standards.
No, if the purpose of condition 7 is simply to confirm further details, then the lift provision in condition 8 would seem to fall within the same scope, so it could be included in condition 7.
Mr. Felton or Mr. Burton, any comments on that?
Yeah, I'd suspect they could be combined, actually.
It would just be an additional, I don't know, where everyone slotted into the list, wouldn't it? An additional point, making 7 points under condition 7.
Yeah, and I suppose what it has to probably be it feels it has to be the first thing that is done, and then the fire statement follows. So I suppose there may be an advantage of having them separately, in that once you get approval for 8, then you can go on and update 7. But I think as long as 8 effectively comes before 7, then within what's required, then that should be okay to combine them.
Okay, we'll leave leave that with me, and I'll have a look at that. Okay. Let's move on then to 9, which is in relation to security measures and secured by design. So my comments or queries here are in relation to how this meets the tests, and should not secured by design be part of the architectural element of the scheme. So therefore, what does it mean by security measures to minimize the risk of crime? Because that should be determined as part of the design of the scheme. So I'm trying to understand the purpose of the condition.
Well, I suppose there may be other elements which aren't obviously, I suppose, design features in that those would tend to look at sort of larger scale things. But obviously, you know, I guess you've got things like you've got cycle stores and you've got access to the buildings. It's all looking at all of those kind of things to ensure that there is security considered through each of those, which may not be so obvious in the actual design.
Yeah, if I can just jump in here as well, because obviously I've dealt with the discharge of this condition on other schemes across London, and the details required under secure by design. There are obviously some that are broad principle that are dealt with at an architectural level, but there are others that are very fine-grained detail, and we're talking about the locks on doors, locks on windows. We're talking about where post boxes are put, how the entrances to the actual sort of entrance to the buildings are actually dealt with, light, and then there's other aspects maybe around lighting and security cameras, etc. So that very, very fine detail that is normally picked up in the condition submission, not broad principles around movement and where front doors
so without this condition, there would be such significant harm that the development should be refused. Because this is where I'm coming from for each of the conditions. There are niceties that need to be added, and I'm not saying that this can't be a condition. I'm just trying to understand in terms of what locks and whether there are cameras and whether is that such an important issue that it's a reasonable planning related issue to alleviate harm, because that's the purpose of conditions.
I suspect,
I'm just trying to understand that.
I suspect our position would be no, it's not something which would be necessary in the sense that permission should be withheld without it. I think our position would be in the event that you took a different view, then we would be content for the condition to be imposed. But I think our starting point is obviously that it wouldn't be necessary strictly, but we wouldn't have any objection if you took a different view to being imposed.
Okay, I understand them.
And needless to say, the council takes a different starting point, madam. I mean, it may seem like fine details, but if you don't design a resi-led scheme so that it does actually provide people with security, that's absolutely fundamental.
And, you know, I think this is particularly because of the way that this is not knocking down everything and starting again. We'll be retrofitting various elements to an existing situation. So, you know, you've got car parks and things like that, which you know will have certain challenges. So I think it's particularly important on a scheme like this, where we're literally doing a bit of demolition, we're changing the use, and we're creating amenity spaces at deck level and things like that, which we might, if we're starting with a blank sheet, we might be doing something slightly different. So I think it is going to be particularly important on a development like this.
Okay,
thank you. Ma'am, we're content with your judgment. Obviously, secure by design was dealt with as part of the design of the scheme. We've engaged with the secure by design officer, but we're content to leave it to your judgment.
Okay, thank you. I meant to raise this earlier, but it's referred to in this one as well. The term beneficial occupation. Now, again, there's a definition in the informative. Is there an, again, because beneficial occupation would need to be, if it's included, would need to be defined, because it's usually just occupation. And I understand the definition makes it clear that occupation can be by construction workers, etc. But this is about occupation of the actual units, whether they be the commercial or the residential, etc. So is this a standard form of wording that the council uses in its conditions, or is it particular to this scheme? I'm just trying to understand. I've never seen beneficial occupation.
No, yeah,
so
it certainly wasn't a word that we put in. So, but yes, with looking at it again, yes, it may be that occupation would be more straightforward. That's the wording we would usually use.
Okay, I just wondered whether there was something in your own conditions that you used. Okay, I'll have a look at that, because obviously I won't mention it again because it's mentioned in several conditions. Let's move on then to condition 10. And again, I just want some clarity on how this one meets the tests. Is it because it's requiring, is this a requirement under other legislation?
Yes, this was this is in part because the whole borough is an air quality management area, but this is suggested by our environmental health team to in relation to dust and emissions. I haven't been able to get any more clarity from them on that.
I think, ma'am, we take your point that if there's a separate procedure under the 1974 Act that we'd have to follow in any event, it's difficult to see how the condition is necessary.
Don't need to be duplicated.
Yes, I mean there can be some times where not duplication, but it's necessary to put something in. You know, for instance, we'll come on to some in relation to the building regulations. Even though it's controlled through building regulations, you can still have a planning condition in. I just wanted to understand this one, and whether even, you know, some form of reference can be made in the logistics plans that you're proposing anyway, if you wanted to. But not put it down as a condition. If it's already a requirement under other legislation, then would that cause a problem? I know it's been put forward by your EHO.
I'm just sort of having a quick look at it now.
I mean, if it's noise and dust, then there's a dust management plan provided for in the next condition, and then noise.
Well, I'll be coming on to that one as well. Yes, and the next one.
Yes, piling method statement 2. So insofar as there are any particular concerns arising from the demolition or construction works, the other conditions could cover those in any event, and any other matters would be covered by the 1974 Act process.
So let's have a look at 11 and 12 as well, because do these need to be covered as separate conditions, or can they be covered by other conditions that are already set out, i.e. the logistics plans? Why is there a need for a separate dust management plan? Why is that necessary?
I'm just wondering whether.
Yeah, I mean,
yeah.
So could I? I mean, obviously, Matt, as I understand, the reason that this condition 10 is there is that, well, otherwise, and you may say, well, this isn't actually a very good reason, but otherwise,
I'll let you know.
The local, otherwise, what happens is the local authority under, I think, the preceding section 60 has to reach a judgment about whether or not work's going to be carried out that might engage the statutory provisions, and then decide whether to serve a notice on whoever it is who's about to do those works. And then when that person gets that notice, then they may serve something back to the local authority. So in a sense, the way I understand it is essentially this is cutting through all of that. This is saying, look, let's accept that what is going to be done under this permission is clearly going to engage the statutory provisions. So just provide us with the particulars rather than going through.
But is that an adequate reason? Is that an adequate reason to add it as a condition?
Yeah. I mean, I think Mr. Burton, and he, in fairness, Mr. Burton, he anticipates the response to that, which is that that's still provided for as part of a separate statutory procedure. So I think it's a pretty good example of something which would duplicate other controls and therefore is not necessary.
Again, leave that one with me, and I've heard what what both sides have had to say on that. So I can, where relevant, I can make a decision on that should I need to consider the conditions in more detail. So the dust management plan element. So my query about why that needs to be a separate, is it necessary? And then does it need to be a separate condition? Or does that form part of the logistics plans anyway? Because that's all about.
I mean, I think, again, and others will jump in if I'm speaking out of turn, but I would have thought that it could quite easily be added to the list of works to be addressed under the demolition or construction.
Yeah, I would.
Logistics plan.
It's partly addressed under 4 and 5E.
Yeah. And I mean, it confirms as well that you're really concerned about the dust during demolition and construction itself, rather than necessarily anything which happens after that. So it just ties everything into the same place. So, ma'am, if that's what you're suggesting, then I think that has a lot of merit.
Does that would that suggest though that something would need to be done with the word logistics in condition 5? I may it may be that I'm thinking of logistics a bit too narrowly as being more about the trucks and so on moving around and that kind of thing. And
well, I don't think we'd have a problem with changing logistics to demolition management or construction management. I mean, you often see construction management plans.
Yeah, that would probably set, I think, the better tone, wouldn't it, to ensure that there wasn't any confusion.
Yeah, it wouldn't materially change what's required because that's set out in the rest of the condition.
I think you're right. Logistics is more about getting from A to B. Sort of logistics. I know it can have a broader definition, but I think management gives a much wider interpretation, I think. So okay. So no issues with potentially including 11 in 4 and 5. And 12, and I'm going to finish on this one shortly before we come to the disagreed or the ones that are not yet agreed, because I will take a break because I know we've gone slightly over. So 12, the piling method statement. Again, the reasons for this is about safeguarding amenity of neighbours by minimising impacts in relation to nuisance. So is that in relation to noise, to
noise and vibration?
Yeah. So again, is it necessary when you've got these now, well, potentially what could be called management plans, construction and demolition management plans, is there, and obviously this would be involved in the construction side, is you want a piling method statement. Is it clear? First of all, my first question is it clear what a piling method statement is and what you would require from that piling method statement? And then does it need to be separate? Or can it be incorporated as part of the construction method statement? Or is it such a separate part of construction because of the implications of the vibrations and the noise, etc., then it needs to be separate?
I mean, the only drafting point I'm thinking about, Ma'am, is obviously one matter we discussed before was keeping the conditions tight so that the list of matters covered by the construction management plan, as we're now calling it, could largely replicate what is set out in the earlier condition relating to demolition management plan. One reason for potentially having piling dealt with separately is that it wouldn't cover demolition, so that you wouldn't want to have it in the list if you weren't carrying it across equally between demolition and construction management plans. We need to deal with it separately if it was concerned with construction only. But you could, I don't see any reason why you couldn't put that into the condition relating to the construction management plan.
Yeah,
Council, comments?
Well, I mean, piling is obviously very different. It does have very particular implications. It doesn't fall, certainly neatly, it doesn't fall within either demolition or construction. So there's a definite case for it standing outside. I mean, perhaps, Madam, this discussion does just open up the slightly broader question of what's to be the trigger. I mean, under 4 and 5, there's obviously a demolition trigger. Now, I don't know, you know, one might say, well, don't forget that before you start demolishing, you might have to bring lots of lorries on site. So you want to guard against the dust that's going to be caused by that operation before you actually demolish anything. I don't know.
Yeah.
So there are other implications, and I'm thinking back to the way that one incorporates condition 11 in 4 and 5 now, and just thinking, okay, does the trigger demolition under 4, does that do enough if you've got to bring lots of kit on, which might have dust and so on implications before you demolish?
Well, that was my question on 4 and 5. Are they true pre-commencement conditions? As written, they're not, but do they need to be true pre-commencement conditions? Actually, you know, line up all your ducks first before you even start on site, whatever that is, which is why I sort of raised that that concern, because if you're starting to come on site for whatever reason before demolition or before construction, in terms of the definition of construction, there could be some clearance that needs to go ahead.
Yeah. Well, yeah, indeed.
So is that under the definition of demolition or construction?
Maybe not.
Okay, Ma'am, I mean, there's 2 separate points arising here. I mean, I think we are content to have piling dealt with, you know, separately, in the sense that it may have sort of particular issues which have caused it to be identified as a separate form of control. So, you know, we've agreed that we don't have any, in principle, difficulty with it being treated separately. I think we just need to reflect upon the point you just raised about the trigger for the plans. I need to take instructions on that. We understand the point that you're raising. Essentially, you may be doing some form of work which is pre-demolition and pre-construction, which I suspect the immediate response might be is, well, if that work does not involve demolition and does not involve construction, is it going to create impacts that need to be controlled in the same way as the statements set out in 4 and 5 are concerned? Because obviously, if you're not demolishing or you're not carrying out the construction works, you're looking at a completely different order of activity, if I can put it that way, on the site. And my instant reaction would be, do you really need to have a plan which covers all these matters for those relatively minor works compared with the demolition and the construction? That's just initial reaction, but perhaps we can take that away because we understand the point.
Well, if we, as I said, I'm going to stop now and have a break. So if you want to discuss that, you can discuss it amongst yourselves, and then come back on that. I don't have an issue with having a separate piling method statement condition, because I think it is a separate element that has particular issues with it that need to be properly managed and enforced, etc. But it's just the management of those. The wording of those management conditions 4 and 5. So maybe we can. I don't want to. As I said, ultimately I'll have a look at that anyway. But if you, after this break, you come back and let me know if there are any additional thoughts on those, and then we'll move on to the next set of conditions.
Okay, ma'am, before we do that, can I just make clear, is this point on conditions 4 and 5 as to when the plan needs to be approved on its own, so that one's contemplating that the plan is submitted to and approved in writing before any development commences on the one hand, or are you looking for or you're contemplating a tighter form of control that kicks in effectively even before any demolition takes place?
Well, that
two separate things.
Really. You're correct, and that's what I'm trying to determine, whether actually these should be set out prior to any development, so no development should occur until, or is that unreasonable because actually it doesn't relate to some of those aspects until demolition occurs, because demolition doesn't occur, or does it, as part of phase 1? We've had that discussion about actually there is an element, or could be an element, of demolition as part of phase 1. So do those plans need to be put into place before any development occurs, or as you said, does the wording need to be just tightened up some way to make it clear? But it's how that is done. I'm just so I'll leave that with you to see if you can come up with some thoughts on your own. Can I suggest that we are back then at, because it's just 11:33 at the moment, that we're back at 12 o'clock, and then we will get conditions done before lunch, and then we will deal with planning obligations this afternoon. Is that okay? Okay, I'll adjourn for now then. So I'll meet you back here at 12 o'clock. Thank you.
Thank you, ma'am.
Thank you.
Yeah, I'll send that across to him now.
Thank you, ladies and gentlemen. If we can make a start back now, please, I will resume. Right, we got everybody back in the room. Brilliant, thank you. Let's move on then to condition 13. And my question is, how does this meet the tests? So if I go to the council first, was this a council requirement?
Yeah, so madam, this is the first, as it were, substantive area of disagreement, isn't it, between the
It is, yes.
between the parties. And I'm not sure whether you've had, I think you probably have had separately, haven't you, from Mr. McCurry, the, as it were, appellant's suggested wording as well. I think Mr. McCurry's nodding. Yeah.
Yeah, I'll send an email.
Yeah. So I think this is the one, of course, that Mr. Felton was going to speak to, but along with Mr. Maguire. Is Mr. Maguire here? Am I missing?
No, he doesn't seem to be, does he? Let me just.
We can come back to it. We don't have to do them in the order.
Yeah,
If you need Mr. Maguire to be present, then you know, I don't want to delay things because we've still got an awful lot of conditions to get through. But I'm happy to come back to condition 13 later if you want to.
Sorry.
He's in the lobby. We're waiting for Mr. Felton to let him in.
There we go. Sorry, I've just spotted that. Okay.
That's okay.
There we go. He's coming in.
Great. Thank you.
He still hasn't popped up on my screen though.
He's on my screen.
He's there. I can't see him.
There we go.
Hi everyone. Sorry, I'm stuck in the lobby.
That's not a good place to be stuck, really, is it? So.
Okay, so yeah, I don't know if you heard Mr. Maguire, but all I'd said was I understood that you and Mr. Felton were going to talk to this together.
Yeah.
And of course, Madam Inspector is aware that in addition to the wording that the council suggested, Madam Inspector has also got the wording that the appellant's suggesting under this head, as it were, by a separate email. Okay.
So do you want me to, sorry, Mr. Byrne, do you want me to lead?
Mr. Felton, please, you know, Madam has asked for the council's position.
Yes, please. Yeah. If I can have council's positions first, please. I don't want to spend too long on this one, but I just need to understand, just because I don't want to get into the detail surrounding all of the energy matters that we've already gone into. I just need to understand, why is a condition necessary, and how does this wording meet the tests?
Yeah, fine. Okay, so I think the obviously it's not. This is really, I suppose, a sort of sticking plaster. Effectively, this is not. Ideally, we would, you know, be looking at this from first principles, but we think that if permission were to be granted, then we would need something really which I suppose reflects the arguments that have been made during the inquiry in terms of what should be done in terms of sustainability and energy to make this development acceptable.
I think that's entirely right, Madam Inspector. We set out the arguments or the comments that we had on the energy statement as they were submitted. We reviewed the appellant's proposed wording for the condition in relation to energy. I mean, there always should be a condition in relation to energy to resubmit on the basis of the estimated carbon emissions leading into construction, because you're obliged to, under building regulations, to calculate those at every stage of construction anyway, or most stages of construction. And the point is that through the appeal process, we've identified a number of flaws in the submitted information, and we've argued that had some of those things been considered more fully through the design development process, then the energy and sustainability objectives of policy would be more ingrained in the design, where we don't think it is. The appellant's proposed wording just to submit the energy statements as they stand, subject to the changes that have broadly been proposed and agreed in terms of improving the fabric performance and reducing the temperature in the heating insulation or the heat network in T1. Both of those mean that the calculations have got to be recast anyway. And when they're recast, what we should do is take as big a step as we can towards complying with the policy as it should have been through the process. So Mr. Feltham used the word sticking plaster, and that's exactly what it is. It's to do the best that we can do, but in any event, it needs to be, all of that work needs to be redone anyway on the basis of the changes that the appellant has also committed to, or is committing to do, should permission be granted.
Sorry, Madam.
Thank you. Can I have the appellant's
Yes, ma'am.
concerns about this condition or the wording of this?
Yes, I think we were trying to understand the basis for it, because the way it was advanced to us, we understood it would come originally from the GLA. It was suggesting that, well, if all these matters are dealt with at a later stage, then any concerns that had been raised about energy would be essentially resolved, because if work had to be done to produce an energy statement to cover all the matters that had been listed in the condition, it appeared to be suggesting that, well, whatever debate that was being taking place at the inquiry so far, however that might be resolved, there's a way that the condition can actually remove these concerns if these issues have to be addressed prior to construction anyway. Because ultimately it appeared to be suggesting that if that energy statement was submitted and all those consequences were followed, then the design was, then the scheme was going to be acceptable. We didn't anticipate that was the positions. We didn't really understand the basis upon which the condition was being suggested, because, as I've mentioned, it appeared to suggest that if this condition was imposed, then there wouldn't be any issues with the scheme that you're considering, because to the extent that there are any issues under debate, they would be resolved through the outworking of that condition. And we just didn't know if that was the position either of the GLA, insofar as they were suggesting it, or of the council, i.e. that whatever the position was at the moment, if there was a confirmatory energy statement put in that was otherwise then going to be accepted by the council, then that was an adequate means of dealing with the issues on energy that were before the inquiries. That's the first initial point. The second one is that it's right that the condition that we suggested was designed really to make sure that the matters that had been the subject of agreement in discussion with Mr. Maguire during the inquiry were reflected in any energy statement that we had to sign up to. We were concerned to make sure that the energy statement that had to be, or the energy strategy that had to be deployed, wasn't conditioned in a way which failed to take into account the matters which had been the subject of discussions with Mr. Maguire. But our concern was that the condition appeared to go a lot further, for example, in terms of asking for information on viability and so on to be produced, because of course, unless there's a mechanism built into the 106, for example, and it was confirmed through a late stage review, If that work were done and it were demonstrated that, for example, the provision of extra electrical infrastructure was going to cost, say, for the sake of argument, a number of millions more, then in normal circumstances, you wouldn't expect that simply to be borne by the development without it having an effect on other contributions that are being made, in particular affordable housing. And the concern is that whilst in principle you can see the sense in a sort of confirmatory submission of details that's done across other subject areas, if you want to do that here, and the condition was followed through in a way which essentially required a few more £1 million worth of electricity infrastructure to be provided, then that would create difficulties in circumstances where there was already an obligation to provide a certain amount of affordable housing, unless that could be picked up, for example, in a late stage review. So I think those are the two sort of main concerns we had with the condition. It's not quite as simple as simply having a condition which requires the resubmission of an energy statement. There are other matters which need to be taken into account.
Well, madam, obviously, as regards the first point, there's no suggestion, of course, on the council's part that this condition would render the development acceptable. It wouldn't. I mean, clearly, if contrary to the council's arguments, you decide to grant permission, then you'll be granting a permission where the buildings, in terms of their footprints, internal layouts, etc., all set in stone by the plans and drawings under condition 2. So you wouldn't, and clearly you wouldn't be able to then embed what we say is the correct approach to energy at the early formative design stage that's required, and so on. But this is the council's attempt to, I think, as Mr. Maguire said, do the best one can in what would obviously be a very unsatisfactory circumstance from the council's position. I mean, look, I absolutely take on board, and we have, my learned friend's point about, well, this might have implications down the line, and that is, I mean, that's clearly the issue. I suspect they would be picked up by the review mechanisms in the Section 106, but we don't shy away from that.
Right. I mean, I'm sorry to interrupt, Mr. Burton. I mean, perhaps, ma'am, that's something we need to take away, because obviously Mr. Burton understands the concern. I mean, I think our point is, well, if you agree with us, let's say, having heard all the submissions, you just reject the case that's being put by the council. So you consider that the energy strategy that we've proposed is appropriate, subject to the amendments that have been discussed with Mr. Maguire. Our concern is just to make sure that if that's the case, then having accepted our position, that any energy strategy that is then conditioned is essentially restricted to that. You've adopted our position on the energy strategy, subject to us accepting these two changes that have been raised through discussions. Our concern is that if that opens up wider matters to do with the entire viability of the scheme, it goes really beyond what the underlying purpose of the condition was supposed to be. But if the council is recognising that there could be knock-on consequences, but it's prepared to accept that if this condition were imposed, there may need to be a need for these matters to be picked up as part of any late-stage review. I may need just to take instructions on that, because it could affect the approach we take to the condition. As we've said before, and I suppose the same issue arose with the fire strategy condition in a way. We understand why there may, in some cases, be a justification for having a condition which is sort of confirmatory in its approach, which means that it allows matters to be picked up changes of circumstance to be picked up prior to commencement. But a lot of care is required as to how that is then fleshed out in the detail, particularly when there are knock-on consequences and viability terms which might arise. And I think that's what our main concern with the condition, the way it's drafted, is.
Yeah, I mean, look, you won't. I don't think you'll find the council suggesting, madam, that this isn't a condition that throws up some issues.
I mean, what we're trying to, the other thing we're trying to understand, Mom, is that let's if one turns it around and one assumes that this condition, a way through can be found with this condition. Let's say, for example, I am talking aloud here. We need to reflect on this before reaching a final view. But if it were concerned that any review mechanism for affordable housing would take into account, for example, the influence of any finding relating to electricity infrastructure, I think, to be perfectly frank, we would be saying, well, if that, without prejudice to anything that we're saying about the energy strategy at the moment, our position would be, well, that would give you additional comfort as far as the approach to energy in this whole case is concerned. But we would need to make sure that those issues with viability could be properly addressed. Our fundamental position is that if you accept, for reasons we'll explain in closing, that our approach to energy strategy is right, then in principle a lot of the need for this condition could be said to fall away, subject to the tweaks relating to matters such as U values. You wouldn't need to broaden the condition to basically encompass an entire sweep up of everything, such as an entire repeat of the strategy. But if a way could be found to make sure that the wider concerns that we've got about impacts on viability could be addressed, and that may be something we'd be prepared to consider, so that the condition were approached on a sort of confirmatory basis.
Yeah, madam, I should say it must be right that if you did reject the council's case on energy, then much of the wording in this condition, as my learned friend says, would fall away. It seems to me to have been drafted in the event that you did, or generally at least, perhaps accept the council's case on energy, but for whatever other reason decided to grant planning permission, and perhaps in the planning balance and so on. And it's an attempt to essentially put a sticking plaster on there. So rest assured that I think you're going to hear from both parties that there should be no need to impose this condition. The appellant will tell you there'll be no need to impose it because it wants you to accept its case on energy. The council will tell you there'll be no need to impose it because it says the effect of accepting its case on energy is permission should be refused. So so that's where they're going to be coming at it from. And
I suppose.
Sorry.
I'm also just looking at the wording and asking myself whether it actually requires anyone to do anything substantive, having revised the energy statement. I'm not sure it does.
I mean, we can have a look at the wording. I mean, I think our point is that if let's say if one follows Mr. Burton's that this is being advanced on the basis that you, contrary to our submission, ma'am, had accepted the council's case, then one needs to ask the question, well, on that basis, if a condition of this form were imposed, our position would probably be that would then be sufficient to essentially resolve the concerns of the council, because what you would be getting, if a way could be found through this without prejudice to our case, would be a condition which would essentially resolve the council's concerns, so that it wouldn't be a case. I think sticking plaster may be that slightly euphemistic way of putting it, but it wouldn't actually be a sticking plaster in the sense that if it's being offered on the basis that you'd accepted the council's concerns, but then this condition would operate as a so-called sticking plaster, it would actually do more than that. It would actually be a means by which any concerns that have been expressed by the council through the appeal would be addressed. And that's why we sort of queried the basis for it being suggested. Because let's say you accept the council's case contrary to any submissions we might make. If this condition were imposed in an agreed form, it would provide a means by which those concerns would be addressed through the approval under the condition.
No, it wouldn't. It wouldn't, though. That's the point. It wouldn't, because you've got to get energy in at the very start.
Well, then I'll have the condition. I mean, this is the thing. The condition would be providing for another energy statement to be approved, and if it were approved, the development could proceed.
Yeah, but with the energy statement would be in the context of the scheme, building footprints, internal layers, and so on, having already been set by the drawings under condition 2. So necessarily, you would not be embedding the energy principles at the start of the design process. So even if you could work up a notional, the notional scheme with a different energy system, the ambient loop system, if you found that was stymied for whatever reason by the plans and drawings fixed under condition 2, then that's an impasse. Anyway, I mean,
but if you're imposing a condition, it must assume in principle that it's capable of being discharged. So this condition would be imposed on the basis that on the council's position, it was going to be possible to find an energy strategy that would render the development acceptable. That's the reason why.
No, that's not right. I mean, this condition is being suggested to try to ensure that all options are explored, but clearly it's no substitute for embedding the right principles at the beginning.
So I'll come back to the 6 tests. Is it necessary? Is it reasonable?
I believe the purpose of the condition is to ensure there's a mechanism that requires if permission were granted, requires the appellant to follow the correct process based upon the changes that it has advanced through the course of the inquiry, in response to some of the points that have been made by the council, particularly in relation to temperature and external wall U value. And the thought process is that the appellant will need to review, or the requirement I should say, is that the appellant will need to review and undertake all of those design calculations again to calculate the carbon emissions, which may change the position that it arrived at. So it's not to impose a particular strategy, it's to say that if you granted permission, the appellant would have to do this and can't just proceed with things as they are, because even not just the energy statements, but the design of the installations that already been done to RE before by Cud Bentley, that has to be redesigned even on the basis of these temperatures and U value changes, because in theory, plant capacity should come down as a result. And if that capacity is coming down, then that releases some other stated constraints of the development, which then may change the strategy because it's cyclic. And Mr. Burton was saying that it's those things that are the sticking plaster. So you can then try to start re-engineering and go backward steps to improve efficiency and ultimately reduce carbon emissions further, because that is the primary aim. And that's why the appellant has agreed to the increased U values and the lower temperature, because it will result in a carbon reduction over what has been presented so far. When that's then incorporated, it might then change the strategy that it imposes. The requirement for the life cycle analysis and other aspects are simply there because they are requirements of the London plan, which haven't been provided to date.
But what we accept, madam, what the council, of course, accepts, much though the council would like to be able to suggest a condition that actually required the appellant, as the council says it should, to start again from the very start of the design stage to get the best carbon energy result, the council can't do that. hence because obviously the plans and drawings are fixed by condition 2. That's the scheme. So it's this best one can do in the circumstances sticking plaster, but it doesn't. I mean, it doesn't mean the development would be acceptable. Not in the slightest on energy grounds.
Well, I think, ma'am, our point is that if the condition is going to be imposed, it must assume that there is a in principle solution to the mischief at which it's aimed. I entirely accept the council might be promoting it on a sort of without prejudice to their main case on energy, but it must be right that you would only be able to impose the condition if in principle it were capable of resolving the concern at which it's directed. Otherwise it wouldn't be reasonable to impose it.
I'm not sure that.
No,
sorry,
Mr. Lang, might I? Sorry.
Well,
Mr.
you go after me as well. I'm not sure that's right, madam. The thinking behind it is that it might improve matters. It doesn't have to go as far as resolving the concern in order to meet the test. I mean, obviously, there's only so much we can say in this debate because we're going to keep sliding into submissions, which you'll hear on Wednesday. But I'm not convinced that the test is would it resolve the concern as opposed to might it improve matters.
My point was going to be that it's necessary by virtue of the changes that the appellant has agreed to make. None of that information is relevant. Not none of it. The carbon calculations are no longer relevant because there have been fundamental changes which change energy demand and carbon emissions. It has to be there because you have to redo those calculations.
And we have accepted all along. We've actually proposed wording to reflect the fact that the energy statements need to be amended to take on board these changes. That's something that we have accepted. As I say, the difficulty we've got is that the way that that condition is drafted, it potentially opens up other issues relating to viability and so on. Perhaps, ma'am, the best thing to do is for us to consider whether that particular concern about opening up matters relating to viability and so on could be addressed. As Mr. Burton said, he recognises there's an issue there. There may be a way through it, looking at these matters by way of the late stage review. But obviously, when one's looking at the scope of that condition, one would need to make sure what it was restricted to, because clearly one is not going to have a position, for example, where the strategy necessarily involves changes to the plans that have been approved elsewhere in the permission. There must be some form of control over what any new energy strategy does. It can't change the development that's otherwise being approved under the permission.
Well, that was going to be one of my points, and Mr. Burton raised it as well. The suggested condition 13.
Yeah, I was about to refer to the suggested one.
You've got the suggested one by the appellant. You've got the suggested one in actual number 30 in the actual list. Neither actually includes any implementation. It just is about submitting something. Well, what are you going to do with it?
Well, that point's taken. I mean, I don't think any party is going to suggest that you should have a condition which seeks the approval of an energy strategy without it being implemented. That's probably the most straightforward point on the condition, ma'am.
Has the council considered the appellant's originally suggested condition, or is that not been on the table?
No, I think
was that the starting point?
I believe that was the starting point. Then Mr. Maguire and Mr. Felton worked out what you've got in your condition list. So broadly speaking, anyway, that's my understanding.
Okay.
Yeah, that's right.
So in terms of council's comments on the originally suggested condition by the appellant, notwithstanding that there isn't an implementation clause in there to actually set out what you're going to do with the information, notwithstanding that, what are there particular concerns about that? And I'm trying to read this without going into, I know there's a lot of background to this. I'm trying to read this as a condition and whether it meets the 6 tests, which is it's a completely different purpose than to go through the evidence to see whether the energy statements have been suitably produced or whatever. That's completely separate. This is just about, does this meet the 6 tests? And have both parties, because obviously at the moment doesn't, neither does that. Have both parties looked at that from the perspective of just, okay, we want a condition about this, how can we set it out so that it meets the 6 tests? Because I'm not happy with this at all, as you can probably tell.
I wrote it from my input was from a technical perspective.
Obviously, and I understand that, Mr. Maguire, because obviously you're not a planner. Your expertise is elsewhere, obviously. So that's what I'm trying to understand. But obviously, I understand you drew it up in conjunction with Mr. Feltham. So, Mr. Feltham, did you look at it from a perspective of, is this condition, does it meet the 6 tests?
So, in terms of actually both original and the council's one don't have implementation requirements. So obviously that definitely needs to change, but I think we're agreed on that. But yeah, we've looked at the original one and rejected that and come up with the new one. Obviously, normally it would be the other way around. We would be normally proposing that, and they would come up with another suggestion. But it was done the other way around this time. But yes, I think in terms of, I think it's necessary in this case. Otherwise, we don't get something which meets policy. That's I guess the point we're trying to.
But isn't that the purpose of deciding whether something gets planning permission or not? So what's the purpose of this condition? I will come back to it. If I was minded, and this is without prejudice to any of my ultimate final decision, but if I was minded to allow this appeal, then I am content with that is basically saying I'm content with the appellant's energy statements, subject to the additional work that they are proposing to do. If I decide otherwise and decide to dismiss, then obviously there wouldn't be any conditions at all, because I'm dismissing. So I'm trying to understand. You're trying to get something that the appellants, you consider the appellants haven't done, through a condition, which,
well, Madam,
seems a bit strange to me.
Well, I think, as I said, Madam, I think it's aimed at that very difficult to predict middle ground position, where you accept the council's case on energy, but yet decide to grant permission. And as I say, this condition will not give you what we say should be done or should have been done.
I understand that, yes.
But in those circumstances, it's the best that could be done, subject to the need for an implementation clause. So it almost needs to come with a, well, it clearly sits apart from the other conditions we've been discussing in that respect. It's in that grey area.
And I hear what, I hear what Mr. Maguire is saying about the additional measures that are to be implemented and what the implications of that would be, because obviously that's what Mr. Maguire is saying, and how that could, if the suggested condition, well, but both ways it would apply, what the implications would be on the development and the proposed scheme. So again, I'm trying to understand what implications those additional measures would have, and how and if it's appropriate or reasonable or necessary for such elements be set out as a condition. So I'd just like to understand that aspect of it.
If I might add,
Mr. Maguire, please.
Speak, madam. So you're exactly right. We're looking to see that implementing those changes may have wider impacts than just proceeding with the schemes as proposed now. So when the appellant reviews those changes, it might be that the appellant deems an alternative approach more appropriate, because it will affect the analysis, not just in terms of the carbon emission, but also in terms of energy demand, space requirement, capital cost, reinforcement costs, etc. So when Toby and I wrote that condition, we tried to make it not prescriptive in terms of the outcome, but just to say that when you do implement these changes that you've agreed to do, you need to revisit all of these, because that might necessarily result in a different outcome.
I think I understand the point that these matters obviously need to be reflected in the energy statement in terms that because they aren't at the moment. The difficulty we've got is that if the course that's being suggested is followed, and it opens up on Mr. Maguire's point, alternative approaches, that's where the difficulty arises, because if those alternative approaches involve essentially either potentially changes to the plan that couldn't be achieved, or, for example, massively increased cost of development in circumstances where the affordable housing had been agreed already, and it couldn't be covered by a review mechanism in a way that adequately reflected that issue, then the conditions, we would say, is going too far, because it's opening up issues which would already have been resolved as part of the permission. For example, as I say, if this work, as far as the council is concerned, were to open up a question of electrical capacity that was going to cost the development a few £1 million to achieve, that couldn't realistically be imposed in circumstances where the affordable housing had been fixed, and it couldn't be reduced, for example, at that stage, given the obligations have been entered into. So there's a line at which these features that we've identified in the original condition that we proposed would have to be reflected in any energy strategy, because it simply couldn't open up everything in the way that the condition appears to imply.
Mr. Linus, you mentioned about you wanted to take instructions in relation to whether a review of some kind could or couldn't be incorporated.
Yes,
do you still wish to do that, or are you now moving away from that?
I can do that, ma'am. I think the difficulty is obviously in any review mechanism, if there are additional costs that are taken into account, they would affect any uplift in affordable housing provision. But to be frank, the concern that might arise is if there's a few extra £1 million worth that one's talking about as a result of this sort of notional alternative strategy, that potentially might affect the level of affordable housing provision downwards in the way that would be approached before any permission is granted. So that's the difficulty. One can't have this approach anticipating potentially a few £1 million worth of extra costs in a way that couldn't be reflected in potentially a reduction in the affordable housing that was committed to as part of the scheme. And I think the concern we've got is whether or not that could be reflected, the risk of that could be reflected somehow in a late stage review. In other words, a reduction in the affordable housing provision. So I think that's whilst we're prepared, I can go away and discuss that over lunch with my client, but I just put that marker down. That's the concern about trying to, resolve this issue in a way that gives us a way forward, because we don't want that position to be reached where an energy statement goes in under this condition. The council reaches the view that, well, because of the outcome of that, one can find extra capacity in the system. It's going to cost a few £1 million to deliver, but we've signed up to a 106 delivering what we say is the maximum reasonable amount of affordable housing, and there's no provision to reduce that in order to viably fund that new approach.
What I would like to do is park this condition for now. What I would like to come back to it later this afternoon. I think it would give both main parties time to, again, look at the originally suggested condition by the appellant, notwithstanding implementation clause, but that's fine. That's easy enough to add on. And again, have a look at what's actually in the list of planning conditions and see if a review of some kind or some other wording needs to be incorporated. I just want to run through that. You may come back and say, no, there's nothing further to say, which is fine. Because obviously it will be ultimately up to me whether I feel that this condition meets the 6 tests, which I do have concerns about. And the implications of the condition that's worded that's in front of me. Obviously, I need to consider also what the appellant has put forward, the originally suggested wording, and whether that meets the 6 tests as well. But taking on board what's just been said, I'd like to just come back to this. I won't come back to it straight after lunch because I do want to get through the planning obligations. It may be at the end of the day, which at the rate we're going may be late. But that's the way of things. So I will give both main parties an opportunity to just rethink this one. If you both come back and say, no, there's nothing more to say, that's fine. But if you actually do want to rethink, then come back and tell me your thoughts. Okay.
Thank you, ma'am.
Thank you. If we can move on to condition 14. Can I just ask whether levels are set out on any of the plans, the submitted plans? They're not. I've got a shake of the head from Mr. McCurry.
I don't believe so.
I've looked and I couldn't see anything.
No.
And it's not unusual to have a levels condition.
No, it's
They
not.
can be pretty standard. I suppose my queries are in relation then if they're not in the plans, because obviously if they're in the plans, then it's not necessary because the levels are there. But if the levels are not there, and I couldn't see them, but it doesn't mean that they're not there. If you can
not there.
just confirm, that's
there.
great. Then it's the wording of the condition. Because what are the relevant works?
Also, ma'am, just our only concern with this was that we would wanted the condition to be phased.
Well, that was going to be, yes, when it's about the implementation, isn't it, as well?
Yeah.
So what's to be provided when, etc.
Yeah.
And that's one of my questions at each phase of construction was one of my questions. Because there's no implementation clause included. So can I just understand from both sides whether you agree or disagree with the comments that have been made and what potential changes need to be made to make it acceptable?
In terms of, well, just in terms of our concern about this being phased, I think solely really we want the details to set out how the development overall will be done in terms of levels, because obviously those relate to each other. We can't, I suppose, necessarily leave the phase 2 to later because we don't know that it'll work in relation to phase 1. So it's only asking for that to be submitted at the outset. And then, yes, in terms of implementation, it would be as each phase were to be implemented, that it would need to comply with the submitted and approved details.
Well, that's the effect of the shall only be in accordance with, isn't it?
Shall only be in accordance with details.
From my perspective, I'd just like to add that, as I understand it practically, we are talking about a phased proposal. As I understand it, both phases would, the detailed design, the working drawings, detailed design, and the construction side of each phase may even be done by a different contractor. So in terms of the detailed working drawings, the actual contractors that even work on the ground may be different on each of the phases. And so this information is just unlikely to be available as a site-wide perspective. It's just something, which is why we want it to be phased, essentially.
And why again, just explain why the council wants it all up front.
Yeah, because we have other phasing conditions.
Just explain to me that again, Mr. Feltham, so I understand.
So, I suppose, obviously, what you wouldn't want to be in a position was that you'd approved the level of phase 1, which, without knowing what the level of phase 2 would be, and it may be that what you wanted to do is to see that this worked overall, just on that very basic level that we're talking about, the level. So, because I suppose what you could find, you could approve phase 1, and you find actually what you've done is approve something which doesn't work very well with phase 2. Now, if you get that at the outset, you can see that works, and it's been considered that it works across phase 1 and phase 2. I mean, I don't necessarily see that as a huge amount of work to do that. Obviously, it's got to relate to the surrounding levels. We know this site is complicated, but it's got to relate to the surrounding levels to do that. But phase 1 and phase 2 crucially have to also relate to each other, and we can't tell that unless we see what phase 2 level will be. So that was my concern. I haven't, it's only it's this one and the landscaping one that I've got concerns about the phasing. Otherwise, I've accepted them. But that was my reasoning. Mr.
McCurry, have you got any comments on what Mr. Feltham has said?
I suppose the only thing I would add is that in reality, when we look at the site specifics and what this condition is trying to achieve specifically, that we've got an existing building where in reality the levels around the base of that building are unlikely to be very different to now, and that the site is relatively flat. So I would dispute the fact that the levels are that complicated personally, across where phase 1 and 2 sit at the ground level. So I wouldn't expect there to be a practical issue with setting levels for phase 1 that phase 2 could not then tie into neatly on this site, because it's not a complicated site with lots of lumps and bumps, for the want of a better phrase. So I don't see a practical issue with having a phased condition, and I don't see any issues with phase 2 being able to tie into phase 1 neatly when that detailed design comes forward. because I don't see it.
So are you saying that there are concerns from what you said about this could be a separate developer that comes forward? You've just mentioned about, because refurbing is different to constructing. You know, brand
not
new
developer, contractor.
Contractor, that's what I meant. Sorry,
that's
not developer.
right.
Contractor. There could be different contractors
Yeah.
involved in the different phases, in the different two phases, because there's different expertise required on each. Okay, so I understand that. Are you then saying that you would find the implementation of this condition unreasonable because it would be, you would have issues about providing the phase 2 levels until the contractor is in place and the detailed drawings are in place, and that you couldn't provide those at the beginning? I'm trying to understand what the issues are. It's a fairly flat site. I know there are different levels. I know there are different levels of things. You know, of pathways and the car parking areas and the actual buildings themselves, etc., and how they interrelate with the, adjacent footpaths and the adjacent highway, etc., or highways. I'm trying to understand what the issues are about being able to just do the levels all up front.
I think, ma'am, the issue is that if you have different contractors coming onto the site, you would essentially have the process that would be followed by the phase 1 contractor essentially being imposed on the phase 2 if you had to, phase 2 contractor, if they all had to be agreed at the outset. So that you would be fixing what a phase 1 contractor was doing, because that would be the information you had to work on when submitting information up front. And then you'd be restricting the phase 2 contractor to whatever information you'd taken from the phase 1. Now there may be means by which a phase 2 contractor could come forward and have positive suggestions for what is done on the site that's relevant to level. So it makes sense to split these matters out.
Well,
I'll have a look at those. Anything further? Well, Mr. Burton, anything further you want to say on this point?
Well,
I'm going to move on then.
I mean, it really is not. It's not unusual to expect the details of levels across the site to be provided up front, and you know, it might be different if we had a description of development that was phased, but we haven't. Comes back to that.
Well, I mean, I don't want to raise the description of development point, but I don't think there's anything unusual in a description of development in a phase scheme not mentioning the phasing. But,
okay. I mean, the principle of having a levels condition is not in dispute. It's how it's worded and when it comes into play. So that's fine. I understand, and I'll have a look at that and see what actually meets the tests, etc. Should I be minded to need to look at it in more detail. If we can then move on to the pre-occupancy conditions as they've been labelled. Condition 15, and this is about the electric vehicle charging points and the provision, and I understand that's in accordance with policy.
Yeah.
And obviously both have agreed to that. My only query on this is in relation to point 2. Does there need to be, because there's a retention clause on 1, but there isn't a retention clause on 2, which is the passive electric vehicle charging points. Does there need to be anything, or whether it's a retention or a maintenance or something to say that these.
I don't think we would object to retention under 2. The other point I might raise is that there doesn't appear to be, although it's probably implied, there doesn't appear to be an implementation clause in this one either.
No, exactly. That was going to be my next question.
That should be there.
Unless yeah, it may be implied, but it needs to be
That's not much
specifically
good.
set out. Yes, it needs to be specifically set out.
Okay, that's why I mentioned it, Mum.
Yeah. Yeah. Does the problem with simply using the word retained in relation to passive charging points is that you obviously want them to change into active points. Let's have a think about what needs to be said there.
Yeah, it's because they would at some stage need to be upgraded to active, wouldn't they?
They would. That is the point of having
But
them.
would you want loss of passive?
Well, they would be lost as passive, but they would be then gained as active.
No, as in, could it mean that you get lost? That they're lost as passive, and then there's no chance they'll become active?
No, we obviously don't want that.
That's what I'm saying. If you don't have a retention clause or something in there, then you could lose them, and then they don't become active. If you get my drift, in the future, it's about what's set out for now, isn't it?
I think in reality, if passive is putting the cables in,
yes,
you want to make sure they're not removed before they can become active.
Yes.
Yeah.
Yeah.
Mm-hmm.
Yeah.
So some form of wording for that.
Yeah.
Yeah. Maybe that thereafter retained until they are made active. Something like that.
Yeah, seems fine.
There is a definition actually in the London plan, isn't there, of passive electric vehicle charging points? So
yeah,
that's a good place to look as well.
Okay, well, unless anybody's got some potential wording now, I'd propose to move on because I'm just aware of the timing.
Okay.
So I've still got quite a bit to get through.
Yeah, I think my suggested wording got a couple of nods then.
I've written down your suggested wording. So unless there are any issues with that, and you may not be able to just think about it now. So again, I'm content to come back to this, whether it's well, ideally later today, but if necessary, there's nothing to stop a discussion on, not a discussion, but to just pick up points on Wednesday morning. Can I leave that with both main parties to just have a think about that? Because obviously I will have a look in more detail. So I'll ask on that point later this afternoon to see if anybody's got any thoughts on the wording for that. Bear with me.
Yeah, just I'm reminded by my instructing solicitors that strictly speaking, if we're parsing the wording of this condition in such detail, it should be the remaining 80%, just for the avoidance of any doubt. Because obviously you need to read the 80% with the 20 in the previous phrase.
Yes. Yep. Okay, I'll leave that one with you, both main parties, to just have a think about that. Moving on to 16, unless anybody's got any particular concerns, but I know you've agreed it. That's a pretty standard condition where cycle parking facilities are proposed. So I don't have any comments on that. Moving on to 17. Now this is building regulations in relation to the M42 and M43A standards. So these, because it requires so I'm just trying to read it. So what's it trying to achieve? It's trying to make sure that no dwellings should be occupied until the optional standards, the optional requirements, have been complied with, isn't it?
Yeah.
Yeah.
So is that a simpler way of saying what's set out there? Because it's a bit long-winded.
I suspect the details been set out to make it clear exactly which standards need to be provided in the
I mean,
proposal.
both standards need to be referenced, absolutely, because you've got
Yeah.
the M42 and then the M43A.
Yes. And then obviously there would proportions of the dwellings would need to be meeting those standards, so that's why the proportions are identified. So I wasn't sure how you would.
And is it appropriate to do proportions, or is it more appropriate to do number of units? Is that precise enough, saying 90%,
Well,
or does
It's
90%?
consistent with the policy. Policy references percentages.
Yes, and if you're doing it across different phases, the numbers would be different across each phase. So
Yeah.
that's why you have a flat reference to the percentage.
Yeah.
Okay.
The only thing I would add, just picking up on,
Sorry, apologies.
is at the beginning where we referenced phase 2B, we had the same point earlier. I actually don't think there's any problem just referencing phase 2 here.
Yep, I was going to make the same point.
Yes.
Must be right.
Because phase 2 will relate to the construction side of it. I think before we finish conditions, we want to pick up on that final phasing explanation, as it were. But I think in this particular condition, we can just say phase 1 and phase 2.
Does that then impact on, because phase 2 is 2 towers, so does that mean you can't occupy anything?
Yeah, I mean, the purpose is that it's phased. So prior to the beneficial occupation of each of phase 1 and phase 2. So the idea is that phase 1 cannot be occupied until it's provided 90% M42 and 10% M43, and then phase 2 can't be occupied until it's provided 90% M42 and 10% M43.
So does that mean you can't occupy tower 2 until you've built out tower 3 and given all the information?
Yeah, because phase 2 is essentially tower 2 and 3 together. Yeah.
It is, but I don't know what the proposals are for. Are you proposing to build both towers together at the same time, or can one tower be built and partially occupied before the other one is substantially constructed, etc., etc.? So are you imposing something that is not feasible?
I'm not.
I mean, it goes whether it says phase 2B or whether it's phase 2, and I know phase 2B is going to be isn't required, but it's about the 2 towers, isn't it?
Yes. Let's have a look. Well, I think just
Because
thinking
it's about
aloud,
demonstrating, isn't it?
so I think that the way it would operate is you'd have to have the approvals for both towers obtained before any occupation, even of the first tower. But that doesn't mean that you would then have to build out the second tower. All the condition is doing is asking that you have the approvals for both towers agreed by the council, showing how you're going to meet the standards, but it doesn't, there's nothing in the condition which would require you to effectively build out both towers before you started any occupation of the first tower. So I don't think we'd had a problem with at least securing the details for both towers before you occupied the first, but I mean, I suppose in reality they're going to be built together, but the way that condition operates is it wouldn't stop you occupying the first tower until the second one had been completed. It just says that the approved units shall be retained in accordance with the approved details. It doesn't stipulate exactly when they would be built.
I think that must be right, madam. I mean, we're only talking about phase 2 now, so T2 and T3 when we're having this discussion, aren't we?
Yes.
I should say, you asked earlier on about this phrase beneficial occupation. Can we generally, not just for this condition, could we remove some ambiguity by replacing beneficial with residential? Would that actually cut through that particular issue across the board? I wonder, because I see the point that the appellant obviously doesn't want, clearly contractors can occupy sites and doesn't want to be caught up in that. I absolutely understand why you need to have a word in front of occupation.
I think we just need to be, I take the point and it's a helpful suggestion. The only query I have is that you'd need to check that insofar as the condition related to, in particular, phase 2, which has some of the retail units in it.
It's got the commercial aspects.
There's commercial aspect to it, but I do take the point that I mean,
I don't think we want to stop the commercial occupation though, so I think I'm fine with the residential. The only other point I just wonder is whether it talks about retention, but should it be provision, should be provided and retained?
Well, I was about to say, what's the implementation?
Yeah, but I just wonder if we have provided and
retained.
Full retained.
That would be fine.
But that would, yes. So, okay.
Yeah.
Okay.
Yeah. I mean, look, from a lawyer's perspective, beneficial occupation is fine. I don't think it creates confusion, but I'm conscious that.
I mean, perhaps the easiest way of doing it is that in the first condition that it's mentioned, you bring in the definition, say for the purpose of this and other conditions imposed on this permission, the term beneficial occupation shall mean, and just add it at the end of the initial condition. I mean, I take Mr. Burton's point. It would be neater if you could find a residential occupation or permanent occupation or something like that. But if it's accepted that there's a degree of concern for enforcement purposes, that you avoid any doubt about what happens with contractors, and it seems like the least worst option is to bring a definition in within one of the conditions that's applied across.
I don't think though that most conditions it's relevant about contractors occupying. They're not occupying the development in the sense of the built development.
Well,
and this wouldn't apply anyway, because this is about, it doesn't matter whether they're occupying it or not, because this is about providing the details of where the M42 units and M43A units are going to be, etc.
I
So
suppose I know it's about those details, but if, for example, it's the enforcement issue, what the appellant is keen to avoid is that there isn't an enforcement issue created where there are contractors on the site as part of the development of T2 and T3, and the council turns around and says there's an issue with this condition because you haven't got those details approved. Because on one strict interpretation of occupation, if it weren't defined in that way, you'd have contractors on site before those details had been approved for the flats. I think that's the mischief that the definition was aimed at.
I think that, well, from what Mr. Feltham has told me, and he said that it's normal in council conditions to just put occupation, preoccupation.
Yes. Well,
You know, as I said, I don't necessarily have an issue if it's relevant for this scheme to have the term beneficial occupation and then a definition put in on the first condition or whatever.
Yeah. I mean, I think that's our preference, Ma'am. It's just an avoidance of, for the avoidance of doubt later on down the line in an enforcement context. I entirely appreciate Mr. Feltham's position, and I have to say, from my experience, the use of the word occupation isn't normally an issue because it's understood to mean permanent occupation. I think it's out of an abundance of caution that we don't want to find ourselves in an enforcement situation later on down the track when another enforcement officer, not Mr. Feltham in the council, takes a potentially different view.
Mr. Feltham, your thoughts?
Yeah, I mean, I think it's a very low risk. I don't think we're likely to be getting involved in that. So I'm happy with occupation personally. I think that would cover it.
Okay.
We're content to leave it there, Ma'am. You can reach a.
Thank you. Thank you. Let's move on to 18 then, condition 18. Now, my queries are in relation to the second part of the condition. So the first part, which is about the providing details on waste and recycling facilities, etc., to be submitted, that's absolutely fine. The refuse and recycling facilities, in the approved details, shall be provided prior to occupation, or whatever the term we will now use, of the relevant phase of development, and shall be permanently retained thereafter. Not necessarily an issue with that. But then it's the developer and or their successor. It's this next sentence. Can I just have an understanding about how that meets the tests and whether it's reasonable and enforceable? So this is reasonable steps to ensure that all refuse and recycling materials associated with it are either stored within. That's about management of the facilities, isn't it? So does either something else about management of the facilities need to be set out, or is that necessary at all?
I see the point. I mean, if there any concern that the matters covered by that condition needed to be tightened up, it would be details of waste and recycling facilities and their management. I mean, there is a delivery and servicing plan already in the.
Well, I'm about to come to that one as well. There's a condition.
Yeah.
Yeah, that must be right, madam. It would be putting the same wrapper around management.
Yes, and to do with your second point, might just be in accordance with the plan that's already been submitted. So it would be providing further details to confirm what's already before the council by way of a delivery and servicing management plan.
So this is about providing further information, because yes, I'm aware of the delivery and servicing plan. So I'm trying to understand again the purpose. Is it to provide further details then, the purpose of 19? Because if the plan is already there.
Well, yeah, I suppose 18 is showing where the facilities are. 19 is about showing how that will be, how deliveries and servicing will actually happen.
Well, but hold on, 18 is about waste and recycling and has a potential lacuna in it because it doesn't tie down the management of those facilities. You know, presumably things like the building management shall only bring the refuse out into Y place the day before the collection's due, or that kind of thing. And 19 is about delivery and servicing, which I wouldn't ordinarily understand to actually bear on that refuse and recycling management issue.
Yes, yeah.
It's waste management. It's waste management.
I mean, the plan that was submitted at CD 114 is an appendix, I think, to the transport assessment, and it is a delivery and servicing plan, but it includes reference to waste management, as I understand it. So I'm not sure whether these conditions would be necessary unless the council is identifying particular details that still need to be resolved arising out of the delivery and servicing plan. It includes a servicing strategy which indicates, for example, the routes that vehicles are going to take to service once they're in the site,
including
as well as loading and unloading, and waste. So it covers delivery, servicing, and waste management as well. Actually, it covers vehicle routing too. So there do appear to be matters within that plan which at the very least relate to the management side. Whether the council thinks further details need to be provided in terms of, for example, precise bin locations or sizes of bins, that sort of thing, I don't know, but those conditions don't appear to have taken into account the existence of the delivery and servicing plan.
Yeah, I mean, my experience in terms of waste and recycling is that what's required can shift over time. So I guess we'll be looking for that to be provided at that relevant time, and it will comply with what the policy is at the time. And I guess to some extent, delivery and servicing will depend to some extent on what units we've got on the ground floor of phase 2 as well. So that may be slightly different depending on what happens there, if you've got a restaurant unit or different type of unit.
I suppose, the conditions have been agreed already. I think what would be keen to do is to make sure that we weren't having to reinvent the wheel based on the information that was already in front of the council without any dispute in the delivery and servicing plan. So if further details were going to be required, that was only done on the basis that they're going to be consistent with the delivery and servicing plan that had been submitted.
Yeah, I wouldn't be expecting very many changes to those, but that doesn't mean there may not be some. There may be some that you would like as well, so it gives some flexibility on both sides.
Yes, I think ultimately it would be a condition which required further details consistent with the submitted delivery and servicing plan.
Can we not forget but there is the separate CD 115 waste management strategy, isn't there?
Yeah,
so
yeah,
I think
carried across for that too.
Yeah.
Okay, thank you for that. Let's move on to condition 20 on landscaping. I know this one's not in agreement, so can I understand the concerns that have been raised about this in relation to meeting the tests for conditions, please?
Yeah. Okay. So this is largely in relation to level 2, because we've got that. I don't know if you've probably seen the phasing plans, which splits that into 2 parts. So
Yes.
you've got a big chunk of that upper level, which is would be in phase 2, and that goes sort of basically between the existing building and the new T2 and T3. So I think the concern there is partly in relation to how it relates to that phasing, and I suppose given that this is the only amenity space for T1, it's relatively limited. Just to be clear on what I'm not asking you to do, and it's not intended. This covers, for instance, the Pocket Plaza. It's just really probably those upper levels, and I guess there'll be some of the planting which related to phase 1 around the southern end of the development. So, but I suppose what I was hoping for is a overall landscaping plan which shows how this will work overall, and then prior to occupation, the landscaping should be provided, so that the amenity space is provided prior to anyone occupying T1 in relation to phase 1. So I think that's and obviously then it's then, I'm not sure whether this might change or not, but then it's then.
Sorry, Mr. Feltham, you're saying prior to occupation of the development, though. The development is its entirety.
No, yeah. So okay, so to be, yeah.
So are you saying it's phase 1?
So prior to occupation of phase 1. So whatever is agreed as part of phase 1, and I suppose this does come back to this issue about the completion of the whole development, because obviously if we only ever get phase 1, then I guess there's concerns about the amount of amenity space that's provided. But yes, so it should be prior to occupation of whatever's implemented, whatever landscape is required in relation to phase 1 should be prior to the occupation of phase 1. Yes, not not that it all has to be provided prior to
and then
the whole development.
Thank you. And then there is reference here to tree planting and landscaping shall thereafter be maintained for 5 years to the satisfaction of the LPA. How does that relate to the play areas?
That
and the entirety of maintaining and managing the area for longer than 5 years, because obviously there's no reference to that in
terms of whether this should also include maintenance of play equipment. Well, I suppose in general.
I mean, I'm sure the obviously the appellant and the developers and the management, whatever management facilities come out, will obviously want to keep all of the landscaping and play areas and everything all up to scratch, etc. But is it necessary? You've got something about the planting and the landscaping. Is the play area deemed to be within the landscaping definition?
I guess the particular issue for picking out trees or plants is obviously you can do all of the landscaping, but if in 4 years' time it's all died, well, it's
it's pretty standard to have something in there to say if something dies or is removed, then, or there's vandalism or whatever, then it's to be replaced. That's pretty bog standard. I'm just trying to understand what the condition's trying to achieve.
Yeah.
Yeah,
Why only stop at trees and plants when
That's what I'm trying to understand.
Kids do things to play equipment that, however robust it is, means
it needs replacing after so long and stuff, doesn't it? And maintaining and whatever else, because you've got to think about safety, health and safety and stuff. So I'm just, but again, is it necessary to include anything within the condition anyway? So I just want to hear from the council side whether you've considered that, and then I'll obviously bring in the appellant and consider what the appellant thinks.
No, I haven't considered that. I mean, I agree it is important that, obviously, yes, firstly it's provided, but then it is there for people who move in, but then people in subsequent years to be able to use. So yes, I guess I was hoping it wasn't perhaps quite as fragile as perhaps trees or landscaping can be, but yes, it would be important that if something broke, that it was then replaced or repaired.
Well, it's all about ongoing retention and maintenance and management.
Yeah,
isn't
absolutely.
It?
So yeah, I think the same probably should apply to the play equipment as well, and I guess the other features to an extent.
The detail, just before we give the chance for the appellant to obviously come in on this and tell me their thoughts. In terms of the detailed landscaping scheme, does that include the, because obviously we've just been talking about the podium in a bit more detail, but does that include the areas outside where there is existing landscaping surrounding the area in relation to the trees and the shrubs and planting areas that are already around the tower and the tower complex? Does that include that? Or is this condition only in relation to the podium?
No, it's not only in relation to the podium. I think my concerns were in relation to the podium, but yes, it must also bite on the area. I think there's landscaped areas to the south of the site, sort of towards the edge where it meets the A3, and obviously the Pocket Plaza as well as in phase 2. It must bite on both of those, but my particular concern was in relation to the podium level.
Okay. Okay, I'll bring in the appellants then for your comments about this condition. It's obviously a landscaping condition, perfectly standard, perfectly, I would expect one. But your concerns or because obviously this isn't an agreed condition. So do you have any concerns about this condition, and Mr. McCurry?
So our initial concern was mostly around the phasing side of things again, and it was probably very similar comments to the levels condition, in that we have a phased application. If the application is approved, there would obviously be a detailed, an approved landscaping plan. But in terms of taking that to the next level, in terms of planting schedules and fine-grained detail of the play equipment, the situation is that it's phased, and that there would again be a phase 2 set of working drawings and details, and a different contractor potentially to phase 1. So it was really we just felt we didn't understand why it couldn't be phased, because obviously the principles of the landscaping would be approved on the landscaping drawing, so it wouldn't be a case of changing any of that. It's just taking it to the next level of detail. So that was the sort of reason for our concern when we sent it to you earlier in the week. Obviously, a couple of other bits have come up just now around the maintenance of play, etc., which I think in principle we'd be happy with, but I think obviously maintaining the play equipment, we would want to see that fit within the same time frame as the planting. So there's the 5 years, which I think has been set out there. This is just what's come to mind as hearing the conversation. I don't know if Mr. Linus has anything else to add.
No. I think the fundamental point, it just needs to relate to each phase. It's not an objection of principle with the concept of a landscaping condition, as you might expect, ma'am. It's just the phasing approach.
Exactly.
And Mr. Feltham, your comments about this issue about it should relate to each phase. Because what you mentioned beforehand was it's about prior to occupation of the phase. So are you now in agreement with what the appellant is now saying?
I suppose my biggest concern still really is given that we don't have any guarantee, and obviously we're discussing this later, but in terms of the completion of development, my concern primarily really is if we're left just with phase one and what comes with phase one, that may not be a satisfactory situation going forward. And so it relates back, I suppose, to the phasing plans that we've been given, and that's, I suppose, where my sort of sole concern, I suppose, remains. But I guess that's for ultimately, I suppose, for you to decide whether you think you'll be happy with just phase one at level 2 just coming forward on its own and never getting onto phase 2. But that's my concern. So I don't know that I can say that I'm completely happy with it, given that the phasing plans that we've got.
Okay, I understand your concerns though, and I've obviously listened to the appellant side. So,
can I add one more comment in response to
yes,
that?
Mr. McCurry.
Point. Thank you. I think Mr. Feltham asked us to provide this information, so we did email him information to highlight the proportionate amount of play, amenity, and also car and cycle parking for each of the phases. And I think it's while that information isn't necessarily in front of you, I'm of the view that the phase 1 and phase 2 are well proportioned in terms of the level of amenity, play, and other aspects such as car and cycle parking are well proportioned. I'm not going to get into the debate about phase 2 not being implemented at this point, because that's for later. And I'll just make the point that this is a full application. There's no intention from our perspective that phase 2 would not be implemented. But
no,
that's obviously for later. But the point is, I believe there's an appropriate provision of amenity and play within each phase. And we did send that information to Mr. Feltham. I think it's
yes, obviously I haven't got that, so I'm not going to be taking that on board. My concerns at this stage are the reasonableness and necessity of the conditions, etc., and meeting all of the tests. So that's the way I'm trying to look at it. So I will obviously go and take that away with me and see and decide on the actual wording if I need to. So thank you for that. Now, what I would like to do now, we haven't got through quite as quickly as I thought on some of these conditions. Not a surprise with the way this inquiry goes, but let's not worry about that. I'd like to take lunch, please, because I think we all need it, and I need time to go through some of the documents that obviously I need to for the session later this afternoon on planning conditions, on planning obligations. Now, before we do stop for lunch, so I will be taking the full hour because I need to read documents as well as have lunch. Are there any restrictions on anybody staying late? Because it's looking likely. So I just want to see if has anybody got any caring responsibilities or anything like that? Because it's whether we could continue on Wednesday if we have to finish by a certain time this afternoon. So nobody got any restrictions?
No, for my part, madam, I already sent up the distress flare earlier to my wife. She will have to take my daughter has a medical appointment today. She will now have to take her, and that's That's in
Right.
hand.
Okay. So
I'm
you
not-
don't need, because if it's urgent and
No.
anybody needs to leave, then please just let me know
No.
and we'll rearrange. So
No.
I do want to come back and we will try and finish. I don't know. I've still got a few issues on some of the conditions. So
Yeah.
some of them are fine. So we may be able to get through some of the conditions, or sort of conjoin some of them and have a discussion around them in a hopefully a succinct way straight after lunch. So if I can take an hour then, so it's 1:35. So if we can be back at 2:35, please, I'll adjourn for now. We'll
Just
come back and do the conditions. Sorry, Mr.
Just
Burton.
one point, Madam. I've noticed that the document that Mr. Feltham sent through to you this morning is a track change document. Now, obviously, you can that's the 3-bed statement of common ground one that he sent through to you. Obviously, you can toggle in Word between clean and track change. If you want him to send you a completely clean document, he'll do it. But if you're happy just to toggle between clean and track changes,
Well, I'll need to have a look at it first to see. I mean, if he wants to just send it through to the case officer anyway,
I think I'll suggest he just sends
then
you a clean
just
one.
do that, and
Yeah.
then hopefully my case officer. Yes, my case officer's there at the moment. So if you want to send that to her, then she can then forward that to me, and then I can just have a look.
Thanks.
We'll do that
Okay.
straight away.
Thank you. If we can be back then at 2:35, please. Thank you.
Thank you.
Welcome back, ladies and gentlemen. We'll make a start again. Just make sure everybody's here before I resume. Sorry, my camera didn't come on then for some reason. It's come on now.
Well, I think we're waiting for Mr. Linus at the moment.
Yes,
Madam.
We are.
I'm here, ma'am. I'm just having a difficulty with my camera. Just bear with me a moment. I'll try switching my camera on and off again. Ah, there we are.
Excellent.
Thank you, ma'am.
Great. Thank you. We'll move on to the next condition. Condition 21. I don't necessarily have an issue with this at all. The wording isn't necessarily, it could be tightened up, but nothing major. I suppose the only query I have is the final sentence, which is once approved, any measures necessary to meet the target shall be complied with. Fair enough. But then throughout the lifetime of the development, how will that be enforced? Or is that enforceable by the council?
Just telling you, read. I guess if it's found at any time that there's non-compliance with that condition, then that means that somebody from the enforcement team could come in and deal with that. So I would say yes, that is enforceable.
Yeah, well, presumably, madam, it's the water. I imagine it's the water usage side of things.
It's the water aspect, the water side of it. Yes.
And data would be available, wouldn't it? I presume, because I imagine it will all be metered.
Well, I presume. Well,
yeah.
Sorry, I can't presume anything. Will it all be metered?
I believe all new developments on water meters now. So and existing properties moving on to those as well. So
Okay.
I believe so. I think that certainly would be
Okay, that's fine then. Let's move on to 22. I haven't really got any queries in relation to this. It's just in only one small thing about the wording, which is on the final sentence, which is the workspace shall be operated in accordance with the approved details and shall be accessible / operational prior to the beneficial occupation of the development. What does it mean by operational? So it's up and, because obviously by being occupied, it becomes occupation. It becomes operational, doesn't it? Before that, it's not operational.
It may be, ma'am. Again, I'll be corrected if I'm wrong, but you'll notice from the definition of beneficial occupation that it doesn't just cover contractors, but marketing as well. So what may be intended here is that the idea is that you could use the workspace at least for example, marketing purposes before any permanent workspace occupier moves in. I don't know if Mr. Curry has anything, but that may be at least one underlying reason behind the drafting.
I agree. That was the intention behind the aspect of the definition and informative 10. Yeah.
Okay, that's fine. Okay, let's move on then to 23. So again, this is to do with the commercial units. Couple of questions. The commercial units. So are the retail kiosks commercial units? So would this apply to them? I know you refer to the retail kiosks as something separate.
No, in my mind, this is separate.
Okay, so these are the commercial units at the bottom of towers 2 and 3.
Yes,
okay.
Those are the units adjacent to the plaza as defined.
Yeah.
Which it says details of the, yes.
Yeah.
It says, it doesn't, yeah, it's the reading of the actual condition. Again, there's no implementation because you say prior to beneficial use, approved details need to be submitted. But then what?
Yeah, there needs to be an implementation part to it.
Yes.
It's fine. Okay, let's move on then to 24, which is, again, it refers to secure by design, but this is in relation to obtaining a certificate. So how does it relate to the other? I think it's condition 9, which was the secured by design one. How does it relate to that, if at all? And is it necessary to obtain a certificate as part of a condition?
Feels like a duplication to me. And if a certificate's required, it could, for me, it could be wrapped into the previous condition. But
well, isn't the way this works? You wouldn't actually want the certificate wrapped in, because isn't that a certificate that they give once you've actually done the thing?
Yeah.
So you wouldn't want it in the pre-commencement condition, if I've understood correctly, when the certificate would be given, would you?
Yes, an accreditation.
What's the earlier one? So the earlier one was condition 9, wasn't it?
Yeah.
Yes.
I mean, I confess, I don't know when the Met give their certificates out, but I imagine that you get a certificate for actually having done something.
In my experience, just regardless of this scheme, my experience is it's normally after occupation. It's normally something, often within sort of 3 months of occupation, because, like I said, it's not until you've put the locks on the doors and the windows that they issue it.
Yeah, well, that's my point. So that's why you wouldn't want to wrap this into condition 9, stop you actually getting on and commencing.
I suspect the distinction is that there is control over the actual design itself before commencement. Then you implement it, then you get your accreditation afterwards.
Yeah,
I suppose though that still leaves the question, which is, if the details have already been approved prior to commencement. I mean, I think we've agreed that it would be appropriate to nonetheless seek accreditation after occupation, but I don't know if that raises the question of necessity. If the details have previously been approved and then you simply then carry out in accordance with those details, is it necessary to have a condition allowing for accreditation? I mean, there may be good reasons for having accreditation going forward as part of the scheme, but I don't know, Mr. McCurry.
Well, I mean, just thinking outside the box a little bit, but accreditation is a good selling point, isn't it, in relation to the scheme, as in the,
Yeah.
But is it necessary as a condition? I would think not.
I mean, there'd be nothing if it's a good selling point for the scheme. There'd be nothing to prevent the developer seeking it outside the scope of the permission. If the fundamental mischief is that the scheme is designed in accordance with secure by design principles, then that would be achieved by the earlier condition. It's
then just kind of checking that later stage, isn't it, to confirm that it has met.
Yeah, that's what I was thinking, Mr. Felton. But also, condition 9 does say at the end of condition 9 shall be implemented in accordance with the approved details. So that's your validation to confirm that secured by design details need to be implemented in accordance with those that are approved.
Yeah, it does.
Why do you need a certification on top of implementation of the details?
Well, you, by doing that, all you're doing is basically saying that yes, you will carry that out. But I suppose at the end of that process, someone comes along and says, "Okay, yeah, great. We can see that you did achieve all of those, and therefore we'll give you your secured by design." Whereas actually 9 doesn't. It doesn't actually at any point get anyone to go back and check that. It just relies on you implementing that. And certainly our enforcement officers won't be going around checking that you've done it all. So
is it enforceable then? Condition 9.
Well, I was going to say, madam, isn't what condition 9 and 24 actually do is reflect the important reality of who it is the council would be deferring to do those checks. Because my understanding is that it is the Met who actually say yay or nay, and clearly the way they work is they don't say that until the things have actually been put in place. Then they'll give their certificate. So yeah. I mean, clearly there's nothing wrong with the council relying on the Met to be the ones who check it, because why would the council have that expertise in house? That's the Met's.
But I mean, it's not a major point. I suppose the only point is that if the council is relying upon the Met, presumably they would be involved at the earlier process of approving the plans, because the council would still have to have control over the earlier approval of the plans, and all we'd be doing is implementing what the council wanted, presumably with the Met's assistance. So, but I don't think in the end it's a significant point.
Okay, leave that one with me, and I can make a decision as to whether that should or should not be included if I need to look at these in more detail. Moving on to 25 then, which is about external lighting. So not necessarily an issue with external lighting. It's just, again, the final sentence. So the development shall thereafter be carried out in accordance with the approved details. But when should they be carried out? Is it prior to occupation? Is it after occupation? Because at the moment, there's nothing to say when the external lighting should be delivered. I presume, well, when would the council deem it necessary to have the external lighting scheme in place?
Yeah, I think the main reason for the condition is to ensure that the lighting doesn't cause a nuisance to others around. So I guess I hadn't thought of it from the point of view of making sure places are adequately lit, which I guess you could also look at that condition. But I hadn't thought that we necessarily needed to ensure it was implemented, only that they can't then do loads more lighting than they've shown on the external lighting scheme.
So does it not matter when the lighting is put in then on that basis?
No, well, I'm fairly relaxed about that, in that I imagine lighting will be put in, and so I don't know that we necessarily need to get involved in
Specify
controlling that.
Yeah.
The only thing we want to be sure is that we don't have really bright lights shining into neighbours' properties. So that's the reason for the condition, and so I'm happy to leave it at that personally.
Any comments, Mr. McCurry?
I'm happy with what Mr. Felton said. The only comment I've got rereading it is whether it needs to be phased, because of the points we've made earlier about phase 2 potentially being designed and coming forward by some other contractor potentially at another point in time. And so I just unfortunately have this concern that these details for phase 2 may not be available at the same time as phase 1. But I didn't have any concern what Mr. Felton said.
Well, reference is made in some of the conditions to each building, and there are 3. And some references made to phasing. So council comments on that, if something was put in about, because it's really about each tower, isn't it, or each building or each phase.
I mean, I think, ma'am, certainly let the council comment on it, but building may be slightly restricted because lighting may obviously take place over the course more of a phase rather than individual buildings.
Yes.
There'll be lighting on other places across the site, which is more easily defined by reference to the phase in the building itself.
Yeah, well, I was going to make the same point.
Okay. I mean, for me, external lighting is very closely related to external landscaping, and in dealing with it from a practical perspective, I can imagine the 2 being designed together. So it's the same comment for me regarding that phasing.
It's about each phase.
Yeah.
Council, any comments on that in relation to putting it in relation to each phase?
Yeah, I think it's fine. Obviously, what you'll need to consider when designing phase 1, lighting aren't impacting on the residential properties in phase 2, but that would be the only slight challenge of doing it that way. But obviously, I guess when we consider phase 1, we'll look at where the residential units will be. So it's probably fine. Yeah.
Okay.
Yeah, and madam, obviously the way this condition is worded, it's not requiring all the lighting to be implemented before you can occupy a unit, but it's a different point from the landscaping, clearly.
Yes, I realise that. Thank you. Okay, moving on then to well, if we do 26, 27 and sort of 28 sort of together, because 26 and 27 are in relation to noise. I know different aspects, but in relation to noise. And 28 is partially in relation to noise. I know some of it is to do with appearance as well. So I suppose first of all is in relation to 26, is the limit achievable? Is a noise limit condition essential? So again, does it meet the test? So just let me know your comments on that. In relation to 27, which is about sound insulation as well, because there isn't an implementation clause on that one. But that's that can be easily remedied.
Yeah.
And then just understanding what condition 28 is actually trying to achieve. So council, so Mr. Feltham, if you want to go first and just let me know your thoughts on those and the reasons for those conditions, just so I understand
a
little bit more. There's no implementation clause on 26 either, so
no.
as well.
No, so absolutely there needs to be. So condition 26 is basically around making sure that any plant effectively is below the background level of noise so that it isn't audible. and doesn't therefore cause a nuisance to proposed and existing residents who live around there, and is necessary. Number 27 is around making sure that the new residential properties are sufficiently well insulated and also ventilated, and still being able to meet the noise levels. So that's about the performance of specifically, I guess, windows and whether you need mechanical ventilation and things like that. Obviously, this is an area where there will be some background noise, and the background noise levels are reasonably high. And 28 is, again, well, it's then about looking at fixed plant and air source heat pumps and all those kind of things, that's setting out detailed specifications of those so that those can be approved. And I suppose potentially, I'm just wondering whether there should also be any sort of acoustic screening or potential for that if necessary, because it talks about the acoustic specifications, but it may also require some acoustic screening as well. So that maybe perhaps that should be widened out to incorporate the possibility of that.
So 26 only relates to commercial use, because that's what
it is. I'm just looking at that wording there, madam, because certainly that's how it starts, doesn't it? But then when it continues, it refers to any plant.
Yes,
as part of this
that's what I'm a bit confused about as to what it's trying to achieve. Is it only any plant related to the commercial use, or is it any plant within the development?
Yeah, I mean, I suppose.
I mean, well, logically, if there's an intention to guard against nuisance, I can't immediately see why one would restrict it to the commercial units.
No, and because the residential will.
It makes sense to me. Sorry. So you're measuring the plant in the commercial spaces to ensure that they don't impact on the adjacent residential residential units. So it's measuring the acoustic performance of the plant from the commercial space. It's measuring that impact on the 1 meter externally to any window at the nearest residential facade. So it's measuring the impact of the commercial plant on the residential facade. Which, so, yeah, that's how I read it. It's quite common.
Yeah, and also there is a distinction being drawn, obviously, between that plant and the plant in 28, and I'm just thinking about how those interrelate.
Yeah. So 28 needs to exclude commercial, doesn't it? If 26 is dealing with commercial.
Well, it seems so. It's 26. It does seem that effectively it's just a compliance condition, isn't it? It isn't asking for any details. Whereas
I was going to say, does 28 cover 26, or does it not? Because it specifies the measurement to the nearest residential window, etc. So I'm just trying to understand why you've got three conditions related to noise.
Yeah, I do wonder if on this development whether we could just cover everything under 28.
Well, that really depends whether it's a sufficient approach to leave things rather loose weave as 28 does, whereas 26 sets a clear target, doesn't it? 5 dB below background.
Yes, it does. Yeah. That's actually, yeah, sorry, it does require an acoustic report to be submitted.
How does this interlink to the commercial one? How's it interlinked with 23? Which requires information about the commercial units, including shopfront details, hours of operation, ventilation strategies, etc., because the reasons for that is safeguarding amenities of existing future residential occupiers.
I think that condition obviously requires details of those units to be provided, and as I read it, noise has been sort of separated out.
Does it need to be?
I suspect it's been drafted separately because when one looks at noise, there are more sort of particular criteria. There's a bit more detail that's been loaded into that condition when compared with the breadth that's in condition 23. I don't think there'd be an in principle difficulty with merging the two, but I think presentation it might look a bit sort of clunky if it's brought in as part of the same condition, given that you have a mixture of breadth in condition 23 and something more specific in condition 26.
Wouldn't it? Because you'd have to have essentially all the words in 26 in parenthesis in condition 23.
Yeah. It would be added as part of the same condition.
Yeah.
So the advantage of merging doesn't actually lose you any words as such.
No. But it might lose you clarity.
Yes, and I think as looking at it, I do see the distinction between 26 and 27, whereas 26 is specifically designed to deal with the impact on residential units that are near to where the commercial use is. The condition's not intending to look at residential noise on residential amenity generally, but then that is done in condition 27 because that covers all of the residential units, and it's deliberately crafted in a broader way. So I think I do see a distinction between 26 and 27, which justifies separate conditions there.
Is my learned friend talking about 26 and 28? So 26 is plan, 27 is then installation, and then 28 is that broader.
Well, partly 26 is only about some of the residential units, whereas 27 is about all of them. So there's a distinction still to be drawn there. And then 28, not sure. I think 28 might be the one that you would potentially drop, actually.
Well, 26, it doesn't restrict itself to this development. There could be another nearer residential facade, of course. So that it could in practice only be talking about the residential facade of this development, but it could also be talking about some other residential facade.
It could be.
Then 27 is obviously the noise insulation reduction for these units in the appeal scheme.
Yeah.
Clearly, must be read that way.
Why do you need 28 then? Because I take your point. Technically, you could have an external facade that's closer, but it is outside the scheme. But if that closer facade has been mitigated for, then it would also have mitigated for the closest residential facades within the scheme. So it still covers the closest residential facades to any commercial unit that lie within the scheme. When I just read 26 and 27, I then query what would 28 cover that either 26 or 27 doesn't? Because if this is about fixed plant and equipment being approved, the only potential impacts that there would be on the residential development, which would be covered by 27, or 26 to the extent that it comes from the commercial use. So
well, I think that because 26 is all about noise, but 28 and it's setting that hard limit, whereas 28 is the let's not have a proliferation of visually offensive bits and bobs, isn't it? I think is part of 28. That's part of what it's concerned with.
Details for each phase, including acoustic specifications.
Yeah.
I suppose if you're looking for a logic between them, it would be 26 is the noise from commercial uses on resi, 27 is noise affecting resi generally, and then 28 is a catch-all to make sure that amenity is generally covered. There may be some overlap given the reference to acoustic specifications, but it's allowing for other matters, possibly like vibration, to be covered as part of that.
And visual. And visual. Yeah.
Yeah. So there is I think when you analyze them, instinctively, I think 28 is probably doubtful, but if there's the potential for visual or other potential amenities to be called as a catch-all within that condition, then that would indicate the logic behind it being treated separately.
Yeah.
For my benefit, 23, when it talks about ventilation strategy, when I've dealt with conditions dealing with that in the past, it normally means, is the ventilation louvered out the front of the commercial space? Is it vented up the building? What is this kind of strategy? And then the actual noise implications that would be picked up, as we've already said, on the 26.
I think the practical reason is that the commercial fit out will often be undertaken separately to the residential.
Yeah.
So there's an advantage in having that condition discharged discreetly. And as Mr. McCurry says, it might cover, particular matters relating to the commercial units that are fitted out on a separate basis.
Okay, thank you. Okay, let's move on then to condition 29. And I think this is duplicated at 43 as well. Yes, I think it's just a complete duplication, so that's fine. So you've already said that this won't include commercial premises, won't include the retail kiosks. So that applies to this as well.
Yes, although as kiosks, I think the prospect of needing control over kiosks is different, Mel.
Okay. And obviously, Class C now has a wide variety of uses.
Yeah,
as we're all fully aware. Okay. Condition 30 then. I just want to understand the reasoning for a condition requiring this monitoring. sort of post-construction assessment, whatever we want to call it, to be carried out. And again, why it needs to be a condition. How does it meet the tests? And that also goes for 31. So, Mr. Feltham, if you can just explain the reasonings behind them.
Yeah, these are, again, I think these are standard conditions that we've been given by the GLA to, I think it's basically about, sorry, it's reading it through. Yeah, just kind of monitoring and making sure that it does what it needs to in terms of the whole life carbon assessment.
As I understand it, madam, it's crucial to show that you have actually done what you promised, and clearly local planning authorities are going to have to be very hot on this, because one risks otherwise people over promising on their whole life analysis.
Yeah, we'll come on to it in a bit, but condition 34 is similar, I think, but it is different. I have some extra comments from the GLA on that, but I guess we'll deal with that when we get to that one.
So all 30 is requiring is just the template to be completed. There's no there's no implications from that.
Just to add my bit to this is I agree with that statement, Madam Inspector. The GLA seem quite clear that they want to gather information. So this is part of their Be Seen and monitoring energy performance across schemes in London. So I've seen requirements like this on other schemes where the GLA want to gather information so that they can better monitor performance over time. So it doesn't necessarily require us to do anything other than provide the information, as it were.
Okay.
I mean, the other thing to note, ma'am, is that we'll come on to the unilateral, but Schedule 3 to that includes
yeah.
So whether there's duplication.
That's what I was going to raise. Is there duplication? Because if you've got, you need, and obviously the PPG and the framework says if you can do it by condition, do it by condition rather than in an obligation. So there certainly shouldn't be duplication between the both. So
if I could add just something to that, is the Mayor's SPG, which is Be Seen, I think it's Be Seen monitoring, which is on the monitoring of energy performance. It does say that their preference is for an obligation as opposed to a condition. Yeah, Be Seen energy monitoring guidance. 21.
So if it's deemed in this instance that it's better to be in the obligation, then is it necessary to have a condition as well?
I mean, I think looking at the schedule and the obligation, it may be that the preference for the obligation is because it's actually a reasonably detailed obligation about the steps that need to be taken, which might explain why it's not considered preferable to put it into a condition. If that's right, and if it covers the same ground, then it wouldn't be necessary to duplicate with the condition, given the guidance Mr. McCurry's referred to.
Okay, thank you. Well, we'll come on to the planning obligation shortly, so we can have a look at that. And Does this also relate to condition 31 then? Is that interlinked?
I don't think, certainly I don't think it raises the same issues as the related schedule in the 106. It looks to be more.
It's more to do with sustainable design and.
Yeah,
but again,
yeah,
that's so it requires submission and approval. And then what? What does that mean?
I have no idea what a damage cost assessment.
Well, I'm glad somebody asked that question because I have no idea what a damage cost assessment is. I've never seen it before, and that's why I want to understand what's it trying to achieve and does it meet the tests?
Instinctively, if it's a damage cost assessment, presumably it relates to some form of damage that has actually occurred.
And it's a toolkit from DEFRA, and
it's air quality, isn't it?
Air quality,
it's to do with air quality. Yeah, it's air quality policy that's related to that. But so again, from the council perspective, why is this necessary?
To basically ensure that we know what the air quality situation is. Just trying to see when this is. So that's prior to the occupation of each building. So I'm not 100% sure whether it's to look at it. It's presumably to so that we understand what the air quality is of people that are living there and what the air quality issues are in the area. But I
is that not already monitored?
I think it may be that the damage cost, if there's sort of impact values measured by pollutant with a particular methodology for doing so, it's probably something that estimates the changes in pollutant emissions that might arise from the scheme. So it may not be that it's being sort of monitored, generically in the way that you suggested. Ma'am, it's intended to be attributable to the scheme.
Yeah. Oh, yes. It wouldn't be like what's the air quality on the street here.
Exactly. So it's not something that general overall sort of monitoring would fix upon.
No.
I still don't understand where this has come from. Reference is made to London Plan SI1 and the GLA SPG, but I don't understand why it must be a necessity in terms of a condition. So if somebody can just explain to me where it says in policy or in the SPG that this isn't, well, it needs to be set out in the policy really, if it's a requirement. So I'm just trying to understand, because I still don't understand what it's trying to do. I'm sorry. I just don't. So if you can explain to me what it's trying to do, because at the moment I wouldn't put it in because I don't understand what it's trying to achieve.
Yeah, well, I think it's a fair point in the sense that, I understand it's related to monitoring changes in air quality, but what the actual outcome of that work is,
yes,
the product being imposed on.
And don't get me wrong, air quality is absolutely essential, and monitoring of air quality is essential. But I'm trying to understand: is this a standard condition that's attached to every single application?
I think it's quite a new condition, so I'm just trying to.
There is government guidance on damage cost guidance, which frankly I've just looked at while discussing this condition. So it is a concept which is there in national guidance, and as I understand it will be reflected in the SPG as well. But I think our concern is what is actually being required of the developer as a result of this.
Well, I mean, at the moment, because yet again, it's a clause without an implementation kicker. I think the answer is not.
It's almost like,
not
okay,
very much. I mean,
provide information, but so what? You know,
that's the question I have. I mean, I think
so what?
Unless it's part of the wider process whereby it's necessary to, although the information may relate to the development, it may be part of sort of broader objective of achieving air quality limits. So the information is provided to enable that to be considered. But I don't know, Ma'am, I'm afraid.
No. I mean, the whole point of a damage cost analysis is that you're meant to identify essentially the damage to air quality your scheme is causing, and then that goes through an equation sausage machine, and it's like a carbon, it's like a carbon trading analysis. You get a pound sign at the end of it.
Yes, and I think in the end, ma'am, obviously this is a condition the council's suggesting. If the council can't give a clear indication as to what's required of us, I can't say that we would accept it as a condition which needs to be imposed.
Mr. Feltham, anything else you want to add before we move on?
Well, I'm sure given enough time, I could find out more about it. But
I think we can probably tell you immediately that, as you know from the policy requires as a minimum that developments be air quality neutral. And I'm not sure how one can keep any kind of handle on that and confirm that unless there is such an analysis. It's really I would say it's in a sense the other way around. It's the lack of an implementation clause in here that is inviting the question. Well, does it have enough wording in it?
I think it's a bit more than the lack of an implementation clause, because we don't know what we'd be asked to implement, and we don't know the reason for it. So I completely understand that if a condition along these lines is going to be imposed, it would need an implementation clause. But frankly, nobody really knows what it's supposed to be doing, or what we would be required to do under it. And obviously, that's a matter which would need to be known before the condition could be imposed.
My understanding is it's presumably the GLA looking for some money if there's an air quality damage.
Well, we have no idea. So it's not for us to divine the purpose of what the GLA might be wanting. We don't know, and the GLA haven't explained it.
Okay, thank you. I think we're going to move on with that one. Thank you. Can we move on to 32, please, which is a water related condition?
yeah, this is just to make sure that there's sufficient water infrastructure to serve the development, and if upgrades are required, then that happens.
So again, why is that a requirement? Just explain to me. Because water has to be provided as a utility to the development.
Yes.
So what's this condition trying to achieve?
Madam Inspector, should I respond on that, just on knowledge of water infrastructure?
Yes, please, Mr. Maguire.
Whilst there might be a connection to the development. The developer may take a connection from the local network. What that doesn't do is a capacity analysis and pressure study of the wider network as a whole. And what you sometimes find is that whilst there might be adequate pressure and flow in the immediate vicinity of the development, the demand from that particular development might starve a particular node in the network, which might be a kilometre away. And the reason this condition is important is to ensure that that process is followed through, so there aren't any secondary or unintended loss of pressure, service, etc. issues elsewhere in the water undertaker's network.
I'm just reflecting on that. I mean, if this is to do with the water network, are there not separate statutory duties that would be imposed on Thames Water that would obviate the need for this condition?
No, because there's an existing connection to the site, and the developer, someone may elect just to use that service, and that use of that service might, if the entire network isn't reinforced to cater for the demands of that site, that might be starved at some point.
Yes, but is it not the duty of Thames Water to provide the necessary sort of infrastructure so that
if Mr. Linus, if a developer were allowed to do that and effectively took more water from the development, and Thames Water wasn't aware, let's say, that the demand had increased significantly as a result of the development, not as a result of the existing connection, it might then not know what was causing some of the issues in its wider network, which would have been caused by the development. It's similar to what we'd said on electricity. When you're designing a new water system for a building, you have to apply for a service of sufficient capacity to service your own development, and that will have a knock-on effect up the network. And as part of that application, Thames Water or whoever the undertaker would do that analysis, and then the developer should pay for the reinforcement to make sure that the water can be delivered to site. There are obligations on the undertaker to maintain pressure in the network, without a doubt. But if it comes solely for the purpose of one development, then the development has to pay for that.
How can it be determined that it would be this development that caused the issue?
Because at the design stage, you'll apply to Thames Water for the service, or whoever the undertaker is. They'll then do their network analysis based upon the load that you require, and then they'll address that and what they'll do is they'll work out the income offset that they'll get from the amount of water that will go through the pipe work to serve the development through its lifetime or over a predetermined period, and then they offset that against the reinforcement costs, and then the difference will be the charge that's payable. So they'll know about it in advance by virtue of the supply being requested, which is what's stated here. If they didn't do that, and the existing service managed to take a particular amount of water from the system, then it would potentially starve, and they wouldn't necessarily be able to identify what was causing that loss of pressure availability in other parts of the network.
I'm still struggling to say whether this is a matter for planning, because I mean, Thames Water would still have to provide water to the scheme. They couldn't, as I understand it, just say no to us. Well, is this not a matter that would be regulated outside planning?
Mr. Linus, you're right. They wouldn't say no. I mean, now water markets have been deregulated as well, so there are other alternative providers that could be used. But what this condition requires is that the process of applying to Thames Water and reinforcing the network as required for the purposes of this development is undertaken, as opposed to perhaps using an existing service that might enter the site is probably the best example I can give. If you approach Thames Water and say this is the demand, then they'll be obliged to give you that, subject to the financial compensation that I mentioned earlier.
So this is about protecting whoever's network it is, essentially.
Not convinced this is a matter that needs to be covered by a planning condition still.
We have used this certainly previously on applications.
I think you might know what my answer to that is, Mr. Feller.
No, well, that obviously of itself is doesn't really take much further forward. But what other?
I mean,
what other mechanism is there? I
mean, I suppose there's a wider proposition. I mean, if this, okay, not sure we can add too much, man.
This is one of the agreed conditions. So,
well, they're all
they're almost all agreed, Mr. Felton. That's
what I'm raising is issues, and quite rightly, that makes people think, doesn't it, differently? So it's irrelevant whether they're agreed or not, because if they don't meet the tests, they're not going to go in as conditions. If I was minded to allow, which has not been determined yet. So I'll leave that one with me, I think, and let's move on. 33, so thank you for that. 33 then, this is about sustainable drainage scheme. How does this relate to 42, which is the drainage strategy? It's just my first question, really. I haven't necessarily got an issue with having a SUD scheme, as they used to be called.
33, sorry, how does it relate to which condition?
42, which is about the drainage strategy.
So that's drainage strategy is about being managed and maintained.
And obviously I've got issues with the wording of that, because if you're only managing and maintaining the drainage strategy, you're not actually implementing anything, are you?
You're keeping a piece of paper managed and maintained.
Managed and maintained. So so we'll go back to that. But how does the sustainable drainage scheme and what condition 33 is trying to say, requiring, so you want evidence to demonstrate that the sustainable drainage scheme has been completed in accordance with the submitted details. Well, are those in the drainage strategy, or are they separate?
Yeah, I would, because that was ultimately something we agreed, wasn't it? So I would think it is in it probably isn't all in the drainage strategy, because there was some various elements which were agreed.
Well, let's ask the appellant. I'm sure the appellant can help us out on this one. Does the drainage strategy, without pulling it up, because I'm aware, because of just thinking of timing, etc. Although we're near the end now, I'd be pleased to hear on conditions. It's been a long while, because obviously it wasn't a reason for refusal in terms of it wasn't an issue. So it's been a long while since I've looked at the drainage strategy. Did it months ago. So, and obviously I can look at it again. I just haven't looked at it for this purpose, because I was hoping you would have the answers. So, Mr. McCurry, any chance you've got the answer there?
Sorry, from my perspective, I just reading those two conditions, I just feel there's an opportunity to combine them in terms of, highlighting that the scheme needs to be built out in accordance with the strategy, and then obviously evident. I think then it's talking about photographs and installation, so evidence that it's been built out in accordance with that strategy, and then it's obviously maintained going forward. So it just seems like those three key elements of that, of those two conditions, can be brought together for me. If there is a specific, sorry, is there a specific question on the drainage strategy that I could try and answer? But otherwise, I don't see the need for 42 really, and it could be brought into 33.
So 42 in terms of the implementation of the drainage strategy was brought in to 33.
Yeah, I can see that. Yeah, that's how I would
Council,
see a way of
Mr. Mr.
I-
Feltham, any concerns with that or issues?
I'm just wondering whether it feels like we should have something submitted to us to then be implemented, etc. Just to make sure that and it probably won't be very different to the drainage strategy referenced in 42, but I'm concerned not to miss any points which may have happened since December 2020. So I don't have a particular problem with them being combined. I think it feels like they could be combined, but perhaps with adding that in.
So what it sounds like you're after, if I'm right, is you want details of the drainage strategy details of the drainage proposals for each building in accordance with the drainage strategy, and then evidence of installation, and that should therefore be maintained going forward.
Yeah, evidence of installation, and also it is really how it's going to be managed going forwards, isn't it? Because I think part of it is about, well, it's very easy to put it in, or it's probably not that easy to put in. You put it in, and then you've got to make sure it's maintained so that it provides the function for which it's there. Because I believe if it isn't, then it can, stop working, and therefore you lose the benefit.
Okay, well, for me, I think that management and maintenance plan needs to be submitted and approved then, doesn't it?
Absolutely, yeah, and I guess it needs to then be complied with, doesn't it?
Yeah. And just to highlight that the start of this condition says no building shall be occupied, and just I'm comfortable with that wording in terms of the phasing of this drainage approach, if you know what I mean. So it's based on a this information needs to be provided and dealt with prior to the occupation of any building, it says.
Yeah.
Okay. Anything further on 33 and 42?
No.
Okay. I shall move on to 34, which is to be discussed.
Yeah.
So who would like to start?
Do you want me to say?
I need to say I've got an update from the GLA. So
okay.
Do you want me to set out what?
Yes, if council can make a start and just let me know.
Okay.
Your thoughts on this condition.
So I think the only issue between us is about timing of implementation, I believe. But so this is what the GLA said. The applicant is required to provide an informed estimate of operational and municipal waste based on the implementation of of commitments made within the circular economy statement and on that operational waste management plan prepared as part of the statement. So what they have said in terms of triggers, I'm hoping this makes sense. They've said the alternative trigger of 50% to 75% occupancy of the relevant phase could be workable, as this would give more accurate information rather than just estimates. So they could accept that.
Just okay. Just to help give Madam Inspector some context, this condition was sent to us last week, and we're happy with the broad principles of the condition, but it was the trigger points for the submission of the information. So it's requiring a post-completion report setting out performance against the circular economy statement. Now, from my perspective, this is quite similar to dealing with things like, for example, when you finish BREEAM, and or as we've just talked about, maybe getting a certificate from your Secure by Design. Quite often you can't produce these reports until occupation has taken place and actual data is available in order to provide reporting on what you said you were going to do, essentially. So we suggested that the circular economy statement report could be submitted within 6 months of occupation, or 6 months of completion. Sorry. And then there's a second part to this condition relating to waste, reporting on recycling and waste specifically. And again, we said that to actually get sufficient information to report on this with actual data, we suggested that we would rather this was submitted probably 12 months after completion, or as Mr. Felton has just said, we suggested maybe 50 or 75% of the occupancy levels. That could be a trigger point for submitting that information. So it sounds like, as Mr. Felton just said, it sounds like the GLA seem happy that we could maybe put in a 50 or 75% occupancy level for the waste reporting. Not sure if there was anything on the first point I said about the post-completion report on circular economy, where we suggested that that could be submitted within 6 months of completion.
Doesn't look like there's anything that's come back on that.
Okay. So just to be clear, so we were suggesting submitting the post-completion circular economy report within 6 months of completion and submitting the recycling and waste report. I had put in 12 months after completion. We had said that we'd happily accept a trigger point on occupancy levels as well, let's say 50 or 75% as an example. And that's where the correspondence has got to on this.
Okay, fine, Alex. I think you're basically saying some of this is well, yeah. Sorry, what are your thoughts?
I think it's entirely reasonable. But there's a little point estimating levels when you're due to start getting actual levels. So I think the post completion for everything up until the table 6 data should be submitted as soon as possible. I don't necessarily think you'll need 6 months, because completion may, what defines completion? The bulk of the information needs to be gathered dynamically, but everything, the first two, table 1 and 2 and table 6, I think it was, as soon as possible, and then the table 7 on recycling for the municipal waste, I think it's entirely reasonable to defer that.
Can I suggest then that some form of agreed wording on that condition is provided, and that it be provided to me by Wednesday morning? Well, be provided so that we can discuss it Wednesday morning, so it needs to be provided sometime tomorrow. It's not for discussion any further, because I've heard what you've both said and whether I agree that it goes in, because it's a monitoring condition. It doesn't do anything else. It just monitors. and then at least I know I will have the wording in front of me, because I've read what you've put in your email, etc. So obviously I read that over lunch. It would be useful to just have that agreement in writing, so that I can at least then that can be brought to my attention Wednesday morning, so that then I've just got it. But it won't be for discussion any further on Wednesday morning.
Yeah,
okay.
I'm sure we can get that. Yeah.
Thank you.
Yeah.
Let's move on to 35 then, which is the car parking. Just in relation to this, do any details need to be submitted, or are all relevant details to that the Highway Authority would need are covered in the submitted information? Quite often information in terms of how, the surfacing and all that can be submitted, but that's not set out in this condition. So is the council content with the information that's been provided?
Yes, we are. Yeah.
Okay, great. Let's move on then. Then we move on to some post-occupancy conditions, although others may well get, or a post-occupancy condition, I should say, in relation to acoustic insulation. And this is to do with, well, it talks about within the premises. So is this the commercial premises? Or are you talking about other premises? Because it's not clear.
I think it refers to the commercial premises.
And how does that relate then to the other conditions?
I think this just then relates to specific uses within Class B. So B is sale of food and drink. So I suppose if
is this not already covered by the noise? I'm trying not to go back to the noise. The noise once again. I don't want to reopen that debate, but we've already got, in essence, sort of 3 conditions already on noise. I know one condition, it has visual elements and appearance related to it as well. So is it not covered by that when you've got an acoustic report that needs to be submitted?
I think this would cover the situation, given there's such a lot of flexibility within Class E, that if one of these uses, B, D, or F, were to be introduced, there may need to be, this would then trigger this condition to look at acoustic insulation, which may need to be
so it's
upgraded.
Different. So it's different to the other conditions.
But I think it's different to the other conditions. Yeah.
Okay.
It is different, Matt. I mean, I suppose one way to conceptualize this is almost asking you to put yourself in. Well, it's almost an agent of change type policy application, but down the line. I suppose one could say, well, if under condition 27, it was a requirement of the acoustic report that it assume the noisiest possible E-class uses, but that would seem unduly onerous. So this is in fact the proportionate way to approach it. If one gets the noisiest E-class uses come along, then it's for whoever wants to use the unit in that way.
The only thing on that aspect, sorry, I haven't got it in front of me, but Mr. Feltham said that E-class B is food and drink, isn't it? Which is most possibly a most likely use of the.
Yes, it probably is, and in that case, I think you would then be looking at dealing with this condition at the same time as the other conditions. But it might be you had a restaurant and you had you had Boots relocating, then you only in this case need to look at this one in relation to the restaurant use and not in relation to the other, unless that then subsequently changed to that type of use. I mean, yes, I suppose it wouldn't stop you looking at the worst case scenario and ensuring you complied with that. So that gives that ultimate flexibility. But this gives that choice.
Okay, as long as there isn't duplication in terms of conditions, then there's not necessarily an issue, as long as it's.
And the only other point, ma'am, is that if this is intended to pick up on uses that change over time, then the requirement that the scheme be implemented and thereafter permanently retained would run contrary to that.
Yes. Yes.
Yeah. It would need to be retained for the duration of the identified use or the identified occupier.
Yeah.
Well, it's retained whilst that use.
Yes.
Yeah.
Retained for the duration of retained for the duration of that use.
Okay. Anything else on that one? Let's swiftly move on then. 37. No issues in relation to having hours, pretty standard construction, demolition, sort of building works hours, etc. So not necessarily concerned. Second sentence though, you set the hours, but then the second sentence says, yes, but if any works do occur outside those hours. So I don't understand why that's necessary if you already set the hours.
Yeah, I don't think that was our suggestion, I suspect, but
because if the appellant wished to change the hours, then they'd have to do a variation, wouldn't they? So
yeah,
and go through that process.
Yeah, I think I feel that yes, we probably should delete the second sentence.
Well,
any
comments?
I think the only thing is, ma'am, there may be sort of isolated instances where one needs to, go beyond those hours for very sort of discrete short-term works, and I think the idea is that the condition gives a little bit of flexibility rather than you essentially having to apply to amend the condition for a single one-off extension of time if there's a particular issue with a road closure or something like that, or something that could be predicted a week or two in advance. It just gives a little flexibility into the condition.
Yeah,
I can have a think about that one. I mean, it doesn't necessarily mean that if it's something that you are going to discuss with the council to ensure and local residents, because something is going to happen on a Sunday, for instance, because that's the only day that a delivery can occur because it's coming all the way from wherever, whatever the reasoning is for that, but it's known and can be arranged so that the council knows that's going to occur. I'm sure the council isn't necessarily going to say, well, that's a breach of your condition, therefore you're not allowed to do that, if it's going to stall everything. That doesn't make sense. So the reason for the condition is so that there isn't persistent abuse of working at times when local residents, etc., should be able to have some some non-construction or whatever time whilst the development is going ahead. So
I think it's just the reality of large scale construction works, Mum, is that
I know. The issue is that obviously local residents need to be aware of what's going on, and they can find out through if you have to apply for a variation in condition, etc. They will then be able to have an opportunity to have a look at that. If it's something that is a bit of more of a one-off, if it's something that, and again, this is a tailpiece saying, well, we might allow it. Let's see if, get the council to agree it in writing. The council may not then consult local residents. They may just say, oh, actually, we'll allow that, and just get it into writing, but local residents won't be aware.
I suppose the broader question, Mum, is that I don't want to go back to the beginning, the initial conditions, but the construction hours is often something that would be covered as part of the construction management.
It can
plan.
be, yes, you're absolutely right.
So
it can be covered in there.
Yeah, so it may be that one could address this through the construction management plan, which, if one goes back up to 4.
Yeah, so it's 4 and 5.
4 and 5.
What's the council's view on that in terms of setting the construction hours as part of the management plans that are going, as they're going to be called?
I mean, the other advantage, Mum, is that if there is going to be a procedure which allows for hours to work to take place outside these hours by way of discussions with the council, that could be fed into that construction management plan, which from local residents' point of view is often the neater way of dealing with it, because then there'd be an approved plan that the developer would have to adhere to, and all the controls relating to demolition and construction are set within it.
But I mean, we would, the 8 till 6 Monday to Friday and 8 till 1 on Saturdays are reasonably long hours, so we wouldn't be expecting any development really to be taking place outside of that time.
So this was the point I just wanted to flag, where something you said earlier, Madam Inspector, that you wouldn't want to assume anything. I wouldn't want to assume that the council would allow any specialist works outside of those hours, which Mr. Felton has just confirmed. And I would like to make the point here that this is quite a complex, large development, that there is the potential that there could be some specialist works, for whatever reason that isn't known at this stage, that might have to take place outside of those hours. And I think, just want to reiterate, as we said, that we felt there might be a need to have some flexibility to agree those in advance with the council. And I mean, I take your point on residents not knowing. Maybe the point is that if we submitted these details, that those details would be put onto the council's website in accordance with a district condition submission, potentially. I mean, and the other thing about the CMP is obviously it can set broad principles, but again, maybe not the specifics around whatever that special piece of work is required. But I do agree that the CMP could help. But I just want to flag that there isn't an assumption from our side that we will necessarily be able to agree with the council outside of these hours for any specialist works. Hence the need for some flexible wording.
Okay.
But yeah, but the wording there would require details to be submitted and approved by the planning authority anyway. So
yeah,
but I think it does seem that the variation of condition is the way to approach that. I mean, this does give, I think, 55 hours of time to build, and it only covers noisy works, I believe, anyway. So it's, you can get on and do quiet works. It's just trying to.
That's not what the condition says, though.
No, it's not actually.
But if it is intended to cover noisy work, should that not be part of this a separate consent process under the 1974 Act we looked up before?
Yeah, I mean,
I think there could be an issue here because you've got to obviously I've dealt with variations of conditions in terms of operations of construction before, and invariably it comes around, and I've dealt with where deliveries weren't allowed. So I allowed a variation of condition to allow a delivery to occur at an earlier time, so from 7 o'clock, for instance, instead of from 8 o'clock, because but obviously taking on board different situation. There wasn't lots of residential existing residential occupiers in the vicinity, so it's slightly different, but obviously there were implications for the highway network and for the routing and implications like that, because obviously you've still got routing that may go past residential, that 7 o'clock in the morning maybe, or even earlier, can't remember the timing now, that may have implications. So I'm just trying to understand the best location, because it's not just about this condition is very short and it's not specific, whereas in the demolition or construction management plan you could even set out different timings for different types of development that occurs, if you so wished, perhaps, that would give that element of flexibility, but we're still protecting the amenity of local residents.
Yes, I just noticed, ma'am, it's not a document that's, I think, in front of the inquiry yet, but the council does have construction management guidelines which make provision for example, out of hours work requests and hours generally. So it may be that first of all, it seems that in principle the scope for an out of hours work request is accepted and acknowledged, that may need to happen. And secondly, that there are guidelines that the council has about how these matters can be addressed within the construction management plan.
Mr. Feltham, anything you want to?
Yeah, I don't think we're ruling out that there may not be circumstances where it could, but I think that the variation of condition, which does then lead to us being able to consult neighbours and get various comments on, which helps us to gauge their experiences and things like that before we take a decision, is the way that we would expect to deal with it. And
I think, ma'am, perhaps one way through it, as long as it appears to be accepted now that there needs to be a degree of flexibility to cover the principle of out of hours work, perhaps one way through is to make sure that the demolition and construction management plans make provision for hours of working, including any out of hours work requests. And then that is fed in. So that's in the face of the condition, then it's fed into the drafting of the CMP. So the need for flexibility is acknowledged in the conditions, but then the details are sorted through the CMP process.
Just not sure how that allows the public to engage, does it?
I suppose the CMP can set out
the CMP would set out the processes. Yeah.
So that would be submitted as a condition, in the details pursuant to the condition.
Yes, we'd have to submit a construction management plan that covered these matters, and then it would be approved by the council. But we just want to make sure that there's flexibility. The need for flexibility is identified on the face of the condition, so that when the CMP is approved, this matter is properly covered within it.
We could go out to consultation on a condition potentially. So I suppose that
Mr. Feltham, my point is, coming back to Madam Inspector's point, how would you involve the public in the event that a developer wanted to work outside the hours? That's sometimes the issue with you wrap it up in a construction management plan, and that's got its own processes, and it becomes quite difficult to get a request like that out to the public.
Well, I think, again, I don't want to refer too much to the document that's not in front of the inquiry, but one of the matters for consideration that's identified in it is immediate and impacted neighbouring properties are to be identified on a site map. And then one of the things that the CMP has to do is identify the procedure for applying for out of hours construction and approval from the council prior to the works taking place. So to the extent that the council wants to build in a procedure within the approved construction management plan whereby affected residents are notified before the works take place, then there's the provision to do that within any CMP that's approved under the condition.
Council response? Anything you want to add? Or do you want to leave it with me?
Yeah, I'll leave it. Yeah, I have to leave it with you. Yeah.
Fair enough. That's fine. That's fine. I've got all aspects now, so it won't be a surprise if anything comes forward, if I were minded to allow the appeal, which has not been decided yet, I hasten to add. Okay, so let's move on to 38.
Yeah. This is again about emissions and
Yes, sorry, I should have brought this up earlier when we were dealing with other aspects. So why is this condition required?
This has been asked to be put on applications for a number of years now by the GLA, and the idea is to during the construction phase is to limit emissions from machinery. So yeah, so
is that not part of the demolition and construction management plans then? Or does it need to be separate? I'm just, again, it's just you need to do this.
Absolutely. So it basically says unless it complies with the standards, then it's fine. It's basically I think it's just a compliance condition, and it's also a monitoring condition because it asks for the an online register to be updated. So
but again, can't that form part of the management plans, construction and demolition management plans?
I mean, obviously, madam, we are requiring, aren't we? And I don't think we've quite hit upon the wording, but we are requiring demolition and construction to be expanded to capture all those things that aren't demolition and construction, but might be site clearance. When we're discussing this condition and condition 37, we've just been looking at, and one does have that issue again where you can't, not obvious to see how one could save on wording in this condition. You'd have to pick it up and drop it wholesale.
Okay. Okay, let's move on then to 39.
Yeah, it's just controlling the hours of the retail kiosks.
Is there because for the other commercial premises, i.e. the other retail units, but they're now deemed to be commercial premises, that's to be determined through submission of additional details. So, and hours of opening are to be determined as part of that. So does it need to be that specific at this stage, or can that be submitted? Because it depends on, I suppose it depends on who they are, who takes them on, what exactly they are, whether they cause any amenity issues, I suppose. I don't know. I'm just trying to wonder. why it's
From my
specific for the retail kiosk, but not now for
Yeah.
the commercial premises
From my
at this
perspective,
stage. Sorry, Mr. McCurry.
sorry, yeah, I mean, just quickly from my perspective, I could see that this requirement could be added to the kiosk condition, where I think the condition was asking for servicing and details of the kiosk, and we could just put proposed opening hours in that condition as well.
Yeah, be fine.
I can't see why we couldn't do that, really. Just trying to find which one it was. Number
was
6.
Early on, yes.
Number
6, is it?
Yeah. So it was 6 said prior to commencement.
Yep.
Sociographic, yeah, details, refuse, servicing arrangements, and we could just put in hours of operation to be submitted to the LPA and approved.
Okay, thank you. Yes, all I'm thinking is you're setting the time there. It could be actually, depending on who goes into the retail kiosks, the council actually wants to restrict the opening times to different times, potentially. I don't know. So, okay, that makes sense. Let's move on to 40 then, which is to do with biodiversity. And this is now, the condition says the development should be carried out in accordance with the recommendations made within section 2 of the biodiversity action plan. Now, section 2 is actually the rationale. So I presume that means section 3. It's been numbered incorrectly.
Yeah, I think so. Yeah.
Because it's section 3 that's the ecological enhancement strategy, although then each enhancement is then numbered 2.1, 2.2, 2.3, etc. So I presume you mean section 3, because that's the one with each of the enhancements that's set out. Is that, am I correct on that?
Just give me a second. I was just double checking, but yeah.
Yeah, it's CD 120.
Yeah, so section 3 strategy.
Yeah.
Okay.
Yeah. Agreed.
And is it clear which biodiversity action plan is referenced? Because it just says the biodiversity action plan. So I presume it means the one that's been produced for this application.
It's dated August 2020, CD 120, ma'am.
Yeah.
There is only one, I believe.
I don't think it was updated with the rest of the material, so that appears to be the correct.
Okay, so it is that. So it's actually dated December 2020.
Right.
On the main sleeve, but then the Lindsay Carrington Ecological Services one says August.
Yes, fair enough.
2020. So which date is it? August 2020?
I think because the documentation was submitted as part of the planning application December 20, so it may be easier to say December 2020 given the front sheet and the relationship with other applications.
Okay, December 2020.
Yeah.
Okay, that's fine. Thank you. That's my only questions on that.
I don't think it was updated. No, so.
No, it's not. There's no update.
No.
Okay. 41. You'll be pleased to hear this is the last one now. 41. In the event that contamination, this is all about contamination. So pretty standard form of development, and I have taken off contamination conditions before where there's absolutely no evidence whatsoever of contamination, i.e. it's a completely virgin greenfield site and has never been developed ever. But the council still wanted a contamination condition on there, so that was taken off. However, this is slightly different, obviously, because we're in an urban area, and it does make sense to have something there just in case. My only query is that so you've got contamination is found, so that if it's identified, etc., then development shall cease. An assessment, remediation scheme and verification report shall then be submitted to and approved in writing by the LPA before development resumes. But what does that mean? Does that mean then, does it mean that then remediation needs to occur before the development resumes if contamination has been found? It doesn't mention anything about remediation, only that a remediation scheme needs to be submitted, not that it needs to be implemented.
Yeah, I would.
Am I reading that
Implementation, doesn't
correctly?
it?
Yeah, am I reading that correctly?
Yeah.
Yes, madam. And it looks like it's yet another one that's missing an implementation clause.
Okay. Okay, anything further on the conditions? That's the end of the conditions element.
Ma'am, there were a couple of sort of hangover points from earlier.
There were, yes.
I think the first one relates to this phasing question. We know we've been through some of the conditions where it hasn't been necessary to distinguish between 2A and 2B. But I think, as the council will be aware, we need to make sure that there's something in the face of the permission which makes provision for two separate or two elements to phase 2, given that the demolition and then the construction within phase 2 has different implications as far as SIL is concerned. And just to confirm that position, we just need to make sure that's reflected in the nature of the permission. So we don't have a particular preference as to how it's done, but the easiest way to do it is just to make sure that the development shall take place and in accordance with phase 2 shall include 2A and 2B, and that's defined in the way that's been put into the informatives. So it doesn't affect many of the conditions where this distinction doesn't have any strong bearing, but it's important for sort of SIL purposes to be clear what the distinct phases are.
Sorry, so Mr. Linus, I didn't quite understand where you were going with that then. So what are you actually saying? That now that the conditions actually need to specify?
Yeah, there needs to be something.
2A and 2B. Something needs to be set out.
Yes, we think we need to have something on the face of the permission which just says within phase 2 on the plan, there will be phase 2A, which on phase 2B, which is defined essentially as per the informative. And the reason for that is to be clear that as far as the SIL is concerned, that there are essentially two different phases or two different aspects to the development, just to make sure there's clarity as to when SIL is going to be liable.
Is that a matter for conditions, though?
Well, it needs to be that needs to be identified on the face of the permission. Otherwise, we need to have a way so that when SIL liability is being determined down the track, there's a.
So you're talking about a change to the description of the development?
No, we don't take the view that you need to describe the development, because ultimately the development is as per the description. Certainly my experience of many phase schemes, it tells you what overall the permission would cover, and it doesn't descend into the detail of what's going on within each phase. That's covered by separate conditions, which are often drafted by reference to the phasing plans, whether they're included in an environmental statement or otherwise. And I don't think that there's really an issue here as far as the description of development itself is concerned, because that's just essentially identifying what we're seeking permission for. I think the phasing issue is different, but the point remains that we need to make sure there's something within the scope of the permission that distinguishes those works where sill liability is going to be attracted or not.
And if it's worth me just adding to that point from just a practical perspective, in dealing with sill liability post permission, obviously I'm liaising with various sill officers across London that all talk to each other, and there just seems to be a real emphasis on the fact that phased nature of a scheme, or the aspect in which a scheme is being brought forward, either with aspects of demolition and construction maybe being quite distinct, need to be set out quite clearly on the face of the permission. And I think the sill regs, I believe the sill regs are quite clear in actually explaining that you can't bring forward a phased permission, etc., unless it's on the face of the permission. So I think we were thinking that it would be helpful from a sill perspective to either have a separate condition or maybe some definition after maybe in condition 2 at the end of the list of plans, just identifying that this application includes phase 1, phase 2A, which is obviously the demolition of the Broadway, and then phase 2, or which is the construction of the of phase 2, and that can be defined. I think because the way we've been through the conditions, I know Mr. Liner said phase 2B, but I think we've knocked out 2B from a couple of the conditions. So I feel that could be worded now as phase 1, 2A, which is demolition, and then phase 2, which is the construction. It's just, but I'm just trying to highlight from a practical perspective that there's a real requirement just to be quite explicit around phasing aspects in relation to dealing with the sill liabilities and practicalities of dealing with sill.
I still can't get, I'm afraid I simply can't get myself past my point I've made many times now, that why isn't this in the description of development? I hear what Mr. McCurry and my learned friends say, that they haven't done it that way on other schemes, but, well, I mean, in a sense, it's the same answer that's given to Mr. Feltham saying, well, we've applied this condition many times in the past.
Well, I mean, it's not
a reason.
I mean, I take the point is you don't simply rely upon past practice, but the description of development is essentially setting out the overall development that you are seeking permission for, and you have other conditions in the permission which deal with other aspects of how that development's going to come forward. I don't think there's any legal requirement for phasing to be specified in the description of development. That's the first point. The second point is that, as Mr. McCurry's explained, the application of the sill regulations means that there needs to be something which defines a sort of separate phasing, so that there's clarity over when sill liability arises and what the implications are. And the most natural way to do that is somewhere on the face of the permission. As I said, it doesn't need to be the description of development. Now, technically, in some ways, it doesn't really matter whether or not demolition is covered, what label is applied to it, whether it's 1, 2A, 2B or whatever. It just needs to, for the purpose of the sill regs, needs to ensure that the demolition is identified as a discrete phase to be clear as to when the sill liability is going to accrue.
Okay, I'll have a look at that.
And it is quite an important point, ma'am. The description of development, as I said, tells you what you're going to build out over the entire course of the permission, because it's telling you what the scope of the entire consent is. That's its fundamental purpose. You don't need phasing in that. You then have the plans that are referred to, and as we say, the plans need to be added to for the purposes of being clear on SIL, which would require something in the permission. We suggest a way of condition to say that the phase 2 shall include phase there shall be phase 2A and 2B, so there's clarity in that respect.
Anything further the council wants to add on that point about adding something, for instance, to condition 2 to explain that?
I'm sorry, ma'am, I'm reminded by my instructing solicitor that if phasing was only mentioned in the description of development, we have a concern that it wouldn't satisfy the SIL regs in the sense that they require sort of separate phase to be specifically identified. We think a condition is the secure way of achieving that objective. So that's another reason for why you wouldn't put it into the description of development. It's really about clarity and certainty at this stage, ma'am.
Anything, anybody from the council's perspective, anything else you want to raise about potential of adding a something to condition 2 to set out the phasing aspects? Because obviously I'll take that away with me.
Yes, ma'am. I don't want to go back to damage costs, but while the discussion has been going on, I've had a look at the national guidance on it. It appears that the condition is really it appears to be an information gathering exercise. Certainly the condition is drafted doesn't impose any requirement on us apart from the preparation of the toolkit. I've had a quick look at the toolkit, and it's simply about inputting factors relating to what changes in air quality are going to be to enable some value to be attributed to that. So it seems that the purpose of the condition is just for that information to be gathered without anything, certainly more in the face of the condition being required of the developer. I just wanted to make that clear.
So it's purely just monitoring.
Monitoring, or it's sort of I think the underlying purpose is that there's some sort of value, societal value ascribed to any changes in air quality that take place. What happens with that information, I am not entirely sure, but as matters stand, the condition doesn't appear to pose anything beyond the preparation of the toolkit on the developer, and we're content to leave that to you as a matter of judgment. We haven't heard anything more specifically that this condition is supposed to be aimed at, but I just wanted to be clear that we have that's our understanding of what the condition would require.
Okay, thank you.
Yeah, can I just say on that, I've been trying to explore that while this has been going on, and certainly other conditions I've seen, but I'm trying to get to the bottom of it. Talk about mitigation measures. Now, obviously, the condition that we have doesn't do that, but I just wonder if I can explore that further and sort of get finally to the bottom of that. What the condition should say, what the rationale for it is, and whether there's anything more that it should be asking for. Certainly, I've just seen some which have been drafted which are looking at mitigation measures, but I can't say until I've done a bit more work on that, so how that should work.
I think the difficulty, ma'am, I mean, I understand the position Mr. Feltham is in now, but if there's any contemplation that an extra mitigation requirement is going to be imposed on the developer, this is, to be frank, something which we really ought to have known about before now, because we don't know exactly what is being contemplated here.
And to be clear, I can't even tell you definitively, because what I want to do is to find the original, where this originally came from, and track it from there. So it may be before the end of the day that I have that, but that may be too late, because I know we're moving on to the next topic.
Well, madam, this of course will not be the only condition. In fact, I've lost count of the number of conditions we've identified that don't have an implementation, an actual kicker clause within them. And as I explained, the way this is meant to work, you work out what the additional emissions due to development are. That has a cost, as my own friend said. The term of art used is societal cost. It's, you know, it's much like a carbon offset or anything, but it's air quality specific. The only way I can see it could work is that there's a cost kicker once you've done your damage, as the name would imply, the damage cost.
Well,
analysis.
I'm not. To be frank, I'm not. I don't think we could say we're convinced about that at the moment. That is an identified output.
The issue that I've got is that this is the conditions session. Everybody's had time to consider the conditions and look at the conditions. Yes, I have, having discussed a couple of things, I have said that you can go away and have a look at a couple of the conditions and come back, as long as it's come back by tomorrow. Because obviously I'm planning on closing this inquiry on Wednesday, and I can't have the closing submissions and then keep the inquiry open to then discuss further elements, because that would be wrong. So I have to base the conditions and whether I accept these conditions are necessary and meet the other tests based on the evidence that I've got now, rather than any additional evidence, except in relation to, we know that implementation clauses are required, and we know that, you know, I have asked and said, can you go away and have a look at this aspect, which I'm about to raise actually, because I did say, can you have a look at this over lunch on a couple of the conditions. So if I haven't got the evidence to show or reasons as to why certain conditions should be applied, and I can't see how they meet the tests, then if, and it's a very big if I were minded to allow, then I would have to take a view as to whether those conditions meet the tests or not based on that evidence, rather than, unfortunately, it's not now the time to go away and look for more evidence on conditions. So that may cause some issues, but I can't see how else to deal with this, really. So I fully understand, Mr. Feltham. You know, obviously, it's something you've probably obviously been told by somebody, put this in as a condition, and then it looks like it's something fairly newish.
Yes.
But it's, you know, if I haven't got the evidence to say why it meets the tests, I can't really include it.
No. Okay.
If I consider it doesn't meet the test. I haven't made those decisions yet.
Yeah.
Because obviously, you know, I need to go through and decide which way I'm going to go on this, ultimately on this appeal anyway, and whether I go down the route of dismissal or allow. Can I just highlight, but obviously what this has done is highlighted the issue that any other developments that come forward, you need to obviously make sure that you've gone through your conditions in great detail to make sure that they are justified, really, and that applies to every appellant and every council, really. For over lunch, I asked you to just have a think about the energy. I don't want to go back to the energy condition, but I did ask you to just have a think about that, because I know, Mr. Linus, you were thinking about whether a review, some form of wording, could or couldn't or could not be included. I know you had reservations about that. Have you had a think about that? Have you been able to discuss it with your clients in more detail, etc., or with any advice that you've gleaned over lunch?
Yes, ma'am. We have discussed it, and I think the concerns that I was intimating before lunch remain, because what the fundamental difficulty we've got with the condition that's being suggested by the council is its sort of broad, open-ended nature. For example, it would potentially contemplate the way it's being presented by the council, a new energy strategy which could potentially have an effect on the approved plans. We don't see how you could have a condition which somehow contemplated changes to the approved plans, plus potential changes to the viability position of the scheme, which has already been secured through the affordable housing provisions in the 106. So I think those are two reasons sort of underlying the concerns that I was raising just before lunch. I mean, if the council's case is accepted, contrary to everything we'll be saying in closing, we don't see that this open-ended condition that is being advanced as a sticking plaster is going to work, because it holds open the prospect potentially of a strategy which is essentially inconsistent with other aspects of the permission that we've been granted.
Okay, thank you.
And just on the contrary, the condition that we've imposed has a clear purpose of restricting any changes to the proposed energy strategy to effectively securing the matters that have been identified in the condition without sort of opening up the strategy in the way that the council's condition appears to do. So it has a more limited purpose, which is intended to maintain the integrity of the rest of the permission. And the essential strategy that we propose. So if you accept our case, then the condition is essentially designed to secure the strategy that we propose, subject to those matters that are identified in the condition, rather than to open up the entire energy strategy for a debate which goes beyond the other parameters of the consent.
Okay, thank you. Anything that the council wants to add?
I don't see we have anything further to add,
Okay.
man. You have all our points.
Okay, thank you. Okay, on that note then, if we can take a short-ish break and then come back. I am concerned that planning obligations may take a little while, and it's already 16:37. So I'm a little bit concerned.
Well, the concern, just to be perfectly honest, the concern I've got is that if we don't,
because I don't want to rush it.
No, well, my concern is, Frank, I don't think tomorrow is an option. We've got closing on Wednesday, and to be, perfectly upfront, eating into the time between now and closings is problematic in terms of you having the closings delivered to you on Wednesday morning. So I'm just sort of raising an issue with the time that we have. I'd be concerned if there was any contemplation of this moving into tomorrow and taking half a day tomorrow, for example, because it would put us under too much pressure.
Well, that would be my concern. I would rather try and finish it today, but I am aware that we could be going beyond 6.
Well, Madam,
which could cause issues.
Yeah, I'm afraid quite apart from preparing and finalising closings, as it were, I wasn't going to mention this, but I have to go to hospital tomorrow for a whatever it's called, COVID thing, before I then undergo some emergency stuff on Thursday. I was going to let you know that I wouldn't be sat in this room on Wednesday, because I understand I've got to be in isolation once I've done my pre-COVID test. So apologies in advance for any poor reception on Wednesday, but I'm afraid I really don't. I'm on one of these 2-week wait list things, so I really don't want to.
No, that's understood from our part. We would never suggest that anything's done to interfere with Mr. Burton's arrangements. The other factor to bear in mind, of course, ma'am, is that if anything arises from the planning obligation session that for whatever reason requires a change in the sort of drafting, that would have a sort of knock-on effect, obviously, as far as execution is concerned. But that's a separate issue.
Okay, well, shall we take a break and then shall we start? And then let's just see how long it takes. As in, once we get a start. And there, I haven't got questions on every aspect of the planning obligation. It certainly won't take as long as dealing with conditions.
It's good.
She says,
that's
tongue
a
in
welcome
cheek.
relief, ma'am. I mean, ma'am, I know there's also the question of the statement of common ground as submitted by the council in draft, and the statement of uncommon ground as submitted in draft by us, ma'am. I mean, we need to address that as well. I mean, perhaps one way through it is, I don't know if you had any thoughts on that, but I suspect we're probably in a position where both parties want to make submissions on this issue rather than take more time today. And one neater way through it is for you to, unless you had any concerns you wanted to raise now or other queries, is to accept both documents and let both parties say what they want about them. But I realize that's a suggestion which is done in an attempt to keep time short today.
Okay. Well, can we take a shortish break? Can we take 15 minutes? Is that going to be acceptable to everybody, or 20 minutes? If we do 20 minutes, it's 5 o'clock. We'd be starting at 5.
Thank you, ma'am.
What is the time that people can stay until, realizing that everybody does actually have their own lives outside of this process? I'm just a little bit concerned of not finishing by 6. That's my concern, because that's an hour.
Subject to the life outside, but I've no limit on my own time.
Okay.
I don't know what Mr. Felton's position is.
No, I can stay until this is sorted.
Until the bitter end.
No.
Yes.
Well, you're already at home, Mr. Felton.
Actually,
I think I'm not getting any instructions from my side that we have any constraints, ma'am. So I think it's better to see if we can get this done.
Let's see if we can do this, because then it alleviates any other concerns. So can I ask everybody to come back at 5 o'clock then, and we'll start on the planning obligations. So I will adjourn for now. Thank you.
Thank you, madam.
Thank you, ladies and gentlemen. Let's get started. So welcome back. I'll resume now. So let's move straight into the planning obligation. And what I'd like to do is go through, or for the appellants to take me through the elements of the planning obligation, particularly in relation to some of the requirements set out in the schedules. Now, some of the provisions I don't necessarily have an issue with, and I've got the SIL compliance statement. Can I just confirm, has the SIL compliance statement just been produced by the council, or is it something that's been agreed? I know there's an element at the bottom where there is disagreement.
It's been produced by the council, ma'am.
Only by the council, okay. But if you've had sight of it?
We've had sight of it, yes.
Do you have any concerns or issues with it? Or
Um,
do you want to highlight that as you go through?
Yes, ma'am. What I was going to do is identify how the obligations in the 106 relate to the table in the SIL compliance statement, so you can understand where they are. But we don't have any comment on the contributions themselves beyond what is put into the SIL compliance statement. Just to help, ma'am, the obligations in the schedules are brought into effect by clause 6 on internal page 21. But then if you turn to the schedules, schedule 2 is affordable housing, which I won't deal with immediately. Schedule 1 covers a number of the general planning obligations that are the subject of the SIL statement.
It does, yes.
So by way of example, if one looks at the SIL statement, the primary healthcare contribution is covered in paragraph 8 within schedule 1. The travel plan monitoring fee is covered in paragraph 9. The controlled parking zone, one turns back, is covered in paragraph 5 of schedule 1, and the terms of that are agreed as explained in the transport statement that the appellant submitted to the inquiry. The car club is dealt with in paragraph 6. The car park management plan is in paragraph 4. The carbon reduction offsets contribution in lieu is dealt with in paragraph 7 of schedule 1. And the GLA B scene energy measures, rather than being covered within schedule 1, they appear in detail in schedule 3. So we note that the SIL compliance statement refers to play space amenity space. Again, I'll be corrected by Mr. Hammore, who's been dealing with this for the solicitor, but I'm not sure exactly where that's reflected in any obligations within the unilateral undertaking, but certainly as we understand it, with the affordable housing provision that comes into schedule 2, all of the contributions, with the all the contributions have been asked for, are agreed within the body of the undertaking, and the main issue in dispute relates to the obligation on completion of the site, plus there is disagreement over the approach to whether we've maximised reasonably the affordable housing provision. But in the event that our case on that were accepted, schedule 2 reflects our offer, and it also builds in the provision by which the current dispute over the SIL deduction would be fed into the ultimate provision. So if one turns to Schedule 2, ma'am, briefly on affordable housing, I'll come back to the optional further delivery assurance at 1.4 and 1.5. But if you turn to Part B, starting on page 34, supplementary affordable housing units, that is intended, as I understand it, to reflect the alternative outcomes of the SIL dispute that we mentioned in opening to the inquiry. That's a very broad run. Part C of Schedule 2 deals with the viability review mechanism, which I don't need to go through. There are detailed provisions set out there which are agreed. And Part D deals with the viability formula, which is obviously related to that. I mentioned earlier, ma'am, that within Schedule 2, Part A, there's the optional further delivery assurance mechanism, which we say isn't necessary for reasons that we may be able to discuss, so that there's essentially a blue pencil clause in there, paragraph 1.4, confirming that delivery assurance would kick in the event that you regard it as necessary, contrary to anything we say to you now. But those provisions are intended to address the concern that has been expressed by the council about essentially the incentive to move beyond phase 1. We don't accept it would be correct or appropriate to require an obligation to complete the scheme. We don't think it's actually necessary to provide this further delivery assurance, but we do it. We've provided for it here in case there are any residual concerns about that, and it provides additional comfort regarding the delivery phase 2. I won't explain that in detail now, but that's in summary the structure of the 106.
Great, thank you. I think the majority of our discussions are going to be around the affordable housing element, and I know that the issue around, I know it's not in the unilateral undertaking, but the 3-bed element, if there are anything we need to discuss as part of that, because now I've read the information that has been submitted to me this morning, then we can discuss that. If we can just clarify a couple of points then first, just in relation to Schedule 1.
Mm.
The vast majority of Schedule 1 is, as I said, seems to be in agreement. So not necessarily any issues with that. The primary healthcare contribution, I'm just looking back to the reasons for refusal. And reason for refusal 10 was that no mechanism has been submitted by the applicant to secure the required financial contribution to mitigate the site-specific primary healthcare requirements that would arise from the proposed development. Does that now alleviate, from the council's perspective, does that alleviate that concern, or is this something different?
Yeah, that does alleviate this concern. Yeah.
Okay.
Yeah, I think it addresses it. Sorry to be lawyerly about it, but I think it goes further than alleviate. It basically removes it.
Wrong word, but it's
okay.
getting late now. So yeah, addresses the concern. Yes, the reason for refusal. Okay. Thank you. And the issue that you've obviously pointed out, and I've made a note of, in the SIL compliance statement, reference is made to play space and amenity space. Can the council just explain why that's been included when it's not in the section 106?
Sorry. Okay, I don't have that up. Let me just get that thing. Hold on.
That's fine.
So yes, it's still not coming up. What's not coming up? Okay. Okay. I know, so that's yes. Okay. So this is where we said play space, amenity space. Yeah. So I think the issue there, because I guess in the legal agreement there's some appendices which show the phasing, which show the phasing for the play space and the amenity space, and I was basically said, well, that yeah, we need to ensure that we've got sufficient of play space and amenity space for each phase effectively. So that's why I'd included that.
I think, ma'am, those plans, as I understand it, are the submitted phasing plans. So if the desire is just to secure the play space, we've already discussed this as part of the conditions. I don't see why this bears upon the Section 106 obligations.
Well, isn't this back to Mr. Felton's concern that the phase 1 plan doesn't show what he considered to be enough space for phase 1?
I'm not sure how that really, if there's a debate about the approach taken to the plan on landscaping, so understand why it's in the SIL compliance statement though. I think that's the point. That there might have been a debate on that in the conditions, but if we're looking at the Section 106, I'm not clear why it's being suggested that there's either something which is included in the SIL compliance statement which relates to play space, or why this touches upon the 106 in particular, as far as a particular obligation on us is concerned.
Well,
yeah.
Obviously the council can't change the plans. Equally, the council can't make the appellant sign up to any particular UU, but it's made the suggestion.
I'm not entirely I think we're not entirely clear what we're being asked to sign up to though, because nothing's been proposed within the SIL compliance statement, you see. I mean, Mr. Felton's referred to the fact there were plans appended, which is patently correct as a matter of fact, but I'm just not clear what the council's asking us for by way of an obligation. We've yeah.
Ms. Felton?
You need more from me? Yeah, I mean, it may be that it's not supposed to be there. I've not. It is my first SIL compliance statement for in relation to this, so it may be that I've put that in the wrong place. But maybe we can look at that as we go through. Yes, but yeah, if it's provided in the conditions and therefore it shouldn't be in the SIL compliance statement, then that's fine. I'm happy with that.
Okay.
Sorry, madam, I'm not sure if you realize you're on mute.
My apologies. You can tell it's getting late, can't you? Thank you. Thank you for that reminder. Thank you, Mr. Felton, for just clarifying that point on the SIL compliance. I haven't got any other queries on the Schedule 1. So if we can move on to Schedule 2 and go through the affordable housing elements, particularly those that are in dispute, or potentially there are aspects that the appellant has put in here, but you've stated not necessarily consider that it's necessary, but you've put it in here anyway. So if the appellant wants to take me through just the reasoning, not the reasoning for the main affordable housing, that's clear, although I just wanted clarification about because you've got the figures in there in relation to phase 1 and how much affordable housing would be delivered. This is para 1.2, and then the new build towers. Just to remind me, because I didn't go back and look it up again, but the affordable housing in towers 2 and 3, are they in both of those towers, or is it just in tower 3? I'm trying to remember now.
Just in 3, madam.
It's just in 3, isn't it? Okay.
And obviously that phased approach that you see in paragraphs 1.2 and 1.3.
Yes.
One can note that, as we've covered in the inquiry already, that you'd have 56% of the affordable housing units across the entire development would be provided in phase 1 before any market units within phase 1 could be occupied. And our case is that in the context of a phase scheme, as we've discussed, that's an entirely normal way to approach affordable housing delivery. And in fact, 56% of the affordable housing proposal across the entire scheme being provided in Tower 1 is quite a stringent and generous approach to take as far as the overall delivery of the site is concerned. So that's our offer. We know that the council don't accept that for reasons that we've heard on 2 separate bases, really. One is that they think that more affordable housing could be provided. It was all loaded into T3 rather than a split between Tower 1 and T3. And you've heard our evidence as to why that approach shouldn't be accepted, and you'll hear about that more in submissions. The other point, which is that the 3-bed issue doesn't really bear upon this in the same direct way, but as we understand the council's case, is that one essentially needs to prioritise 3-bed delivery over affordable housing, so that if one did that, it would result in a position where potentially there isn't actually affordable housing offered at all in the scheme. That's not a direct sort of dispute with the level that's being proposed within this offer, because this all assumes you accept our case on affordable housing generally. But that's the reason why phase 1 and phase 2 are set out as they are. They reflect the offer that's been discussed at the inquiry so far.
Yes, Madam, I'm not going to go into the arguments and the submissions. No.
I know what's coming. Yes.
Yeah.
On both sides. Yes, that's fine. Can I just confirm? And I think these figures were provided, but I just bear with me because I couldn't find them earlier. with the provision of 28 affordable housing in phase 1, what percentage of phase 1 is that? I'm sure that's been provided to me, but
whatever it is of 261, isn't it?
Yes, I'm not allowed to create my own calculations.
It is something pretty similar, actually.
It's 10.7%.
10.7, yeah. Right. Okay. Thank you. Whoever that was, thank you very much.
Mr. Ashdown tapping up, thank you.
Mr. Ashdown, I thought it was, yes. Thank you for that. Okay. And then obviously then it's 0% in Tower 2, and then whatever the percentage is for Tower 3. So Mr. Ashdown, are you ready there for that calculation?
So it's 22 of the whole of phase 2 though, isn't it? So that's 238 units. So that's 9.2.
And what would it be as part of Tower 3?
Tower 3, I think, is 102 units, I believe.
Yes.
So what would be the percentage?
21.6.
Sorry, what would it be for the entirety of T2 and T3? Just the percentage?
Yeah, I think so that's 22 divided by 238 is 9.2%.
9.2%. Okay, thank you.
Just, I don't know whether it's worth saying that the plan is that both those towers go up at the same time. In terms of the construction phasing, it's not thought that phase 2 is T2 is built and then T3 is built. They both get built at the same time.
Okay, thank you. Okay, sorry, that was a slight digression, but it was just I just wanted to ensure that I'd got understood those requirements. So, Ms. Linus, do you want to just take me through these additional requirement, or what's called the optional further delivery assurance, so that I understand exactly what that means? I have read the information, so I do understand it, but I just want to just make sure that we have a discussion about it before, so that I understand, so that I clearly understand exactly what is being proposed, why you're proposing it, and then whether it should or shouldn't be in there, or whether, as you said, it's left in, but then there is a get out of jail free card clause, isn't there? 1.4, which only says that it would only come into effect only if the decision letter made it clear.
Yes, Matt. I mean,
so
can I, obviously this touches upon the contents of the explanatory note and the text,
which I've read, yes. So I'm not planning on going through all of the information, but what are the key points that I need to understand?
Very well. Can I assume that those documents are accepted then, because it obviously bears upon how much I say to you now?
Yes, because Mr. Burton accepted them.
So, yeah, save as I said, save us to the evidence in them. There's, I think what Mishcons have done, and I know my learned friend won't, I'm saying no, but I'm sure he won't be relying on this anyway, but there are bits of the Mishcons explanatory note that are evidence. That it's them giving evidence about, for example, what it does to risk profiling, which I say you cannot accept. Most of it is legal submissions, which is fine. And then obviously Mr. Ashdown's technical note is his technical note, and I've got Mr. Scott here to speak to that when Mr. Ashdown speaks to it, essentially.
Well, I'm as far as I'm concerned, ma'am, I'm not excluding any part of the explanatory note or the technical note from what I'm going to describe to you.
Well, I certainly don't accept the bits that are evidence. Well, there can't be anything else in Mishcon's note as admissible. Not at this stage.
So there is an issue then about whether I accept something or not.
Ma'am, the explanatory note, as I've said, is a mixture of explanation as to why the site completion obligation shouldn't be accepted, plus a description of the further delivery assurance mechanism, which starts at 3.9 and goes on to 3.13. And that explains the thinking behind the delivery assurance mechanism, and it refers to figures and the appraisals that have been run by Mr. Ashdown, to which he refers in his technical note. So we don't see any reason why you shouldn't take this material into account, not least because it touches upon and is consistent with what Mr. Ashdown puts in his note, which is available for discussion as part of this roundtable. So there's no reason to exclude any part of this note, because the explanatory note and the technical note can be read as one.
So, Mr. Burton, what exactly are your concerns about? And obviously, there is still an avenue to go down if you wished in terms of cross-examination. I don't think anybody wants to go down that route, but the avenue is still there.
5:25.
Yeah, I don't think so. Yes.
No time before.
No. No, but it would mean delaying submissions, closing submissions. That is what it would mean.
Well, Madam, these are the issues. We're calling it the explanatory note. I mean, I think we're all clear about what we're referring to, but it's the note that Mishcon de Reya have headed after the appeal reference, section 106 note, affordable housing delivery. And within that document, you will see, firstly, under section 2, there is text that appears to be purporting to give you evidence about what the council has or has not suggested, etc., etc. Now, I say the appellant, through its solicitors, it can't be giving you evidence about discussions that have or haven't gone on. Certainly, it can't be giving you evidence about matters at this stage, because there's no time to deal with them, nor is it necessary, because you've heard all sorts of evidence about what the council is looking for, what it's been asking for. So that's the first element. The other element, though, which is actually of more concern, is when you go through the document, you'll see there are various bits of text about the extent to which an obligation, i.e. complete the whole development, has or hasn't been encountered before, and what it does to risk profiling. Now, these are matters of evidence. They're not matters of submission, plainly. So they belonged in the evidence sessions. Now, from the council's perspective, it's not at all clear why, or that there's any need at all for the appellant to have included the matters of evidence in its explanatory note, in order to make the legal submissions that it wants to make, and it has made. There's when you go through the explanatory note, you will see cropping up again and again bits of evidence, and all I am suggesting, not that you exclude the whole explanatory note, that would be completely disproportionate, but you read it de bene esse. So you read the whole thing, but you ignore the bits in it that are evidence. And it's obvious what's evidence and what's legal submission. That seems to me, my submission, to be most proportionate, efficient, and sensible way to deal with this. Because what I don't want to do, because this would just be, I mean, it would be complete overkill, is say, well, you can't have that document in because it's got X, Y, Z bit of evidence in it.
No, I'm afraid I just don't understand that. I mean, I don't know what he thinks Mr. Burton thinks Mr. Scott's going to be doing when he appears at the roundtable session. But apart from that, so far as complaint is made about a reference to the council not suggesting any specific mechanisms to ensure completion of the whole development, that could quite conceivably be a matter of a submission based on the facts that you got before you got the inquiry. But in any event, the point about it being novel and untested is a matter which has been raised at the inquiry already, and I asked Mr. Feltham about it, so it doesn't seem to be any particularly problematic about referring to this. Similarly with the risk profile, Mr. Ashdown has already been asked about this at the inquiry, what the implications as far as he's concerned with imposing that form of obligation to complete the development on the developer. So I frankly just don't see what the problem is when you have a roundtable session that discusses Section 106. There are inevitably comments that are going to be made about whether an obligation is usual or unusual, why a party should not be required to take on a particular obligation. And all that was being done here was setting down in writing what we could quite easily have mentioned orally through the Section 106 session. So we don't see any basis whatsoever for somehow parsing this document and excluding matters when the roundtable session is an opportunity for these matters to be raised in the entirely normal way. There's no reason why this couldn't have been introduced at a round table session.
Like, I have to say, I'm not at all used to solicitors giving evidence. I mean, that I don't see how that could possibly be appropriate.
It happens a number of times at Section 106 sessions if an obligation is being discussed in exactly the same way as a condition is being discussed, and the team generally for an appellant in the council discusses whether they've seen a condition such as one relating to damage costs for air quality. It's part of the general discussion, and there's no reason why, as part of a round table session, a solicitor, a planning consultant, or a lawyer representing any particular party can make a statement as to whether or not an obligation is novel or what experience they have of providing it. Just part of a normal roundtable session. I really don't see the issue. And ma'am, for you to be asked to go through here and try and excise unspecified paragraphs is not an acceptable way of proceeding in my submission. None of these matters are issues which could not be raised in the normal way at a roundtable session.
I do want to be able to move on, so I'm going to accept the documents as they are.
Yes,
and there is an opportunity through the roundtable session to state exactly what your concerns and issues are, and I will obviously take those on board in considering the issues. But I don't want to, I just want to try and progress as far as we possibly can on this matter. But obviously I've heard both sides, so I will, let's go through.
Thank you, I won't deal with the point about the completion of development obligation, because I think where we were beginning this was you asking me for an explanation of the further delivery assurance. Shall I return to that? Okay, the explanatory note needs to be read with the technical note that Mr. Ashdown's put in, and others will jump in if I have not explained this accurately, but broadly, the effect of the obligations is first of all to prevent occupation of the last remaining 22 units in T1 until the existing parade of shops on Tolworth Broadway has been demolished to make way for T2 and T3. And the reason behind doing it that way is obviously that the developer of T1 would not be able to access the value and the profit in those last 22 units until the demolition had taken place. So the idea behind that mechanism is to incentivize the demolition. Okay. Now, once that happens, we say that makes phase 2 more attractive, because having had to demolish the retail parade to allow for phase 1 to be completed, the developer looking at phase 2 would not be able to obtain any value from the existence of the retail units, because they would have been demolished, and they would not have had to bear the cost of demolishing those units, because that would have had to be carried out before phase 1 could be completed. And those matters obviously affect the viability of proceeding with phase 2 in a way that makes phase 2 even more attractive than was the case before. Essentially, in short, I can ask Mr. Ashdown to run through it in more detail, but it means that the demolition of those retail parades avoids the cost of demolishing them, and it precludes the developer from taking advantage of the existence of those units to obtain value. Once those factors are fed into the appraisal work for phase 2, it means that phase 2 essentially becomes more profitable. So there's an even greater incentive to develop it out. And that has been introduced in paragraphs 3.9 to 3.13 of the explanatory note, which explains how placing the demolition cost into phase 1 removes the economic advantage of just sitting on the retail units and getting value out of them rather than developing phase 2, and it makes the development of phase 2 cheaper by removing the cost of demolishing those units, and that increases the profit incentive that's available to the developer. And that's explained in more detail in Mr. Ashdown's note, where he has provided the figure work to confirm both the extent of profit that would be withheld under phase 1 until the demolition works have taken place, as well as fundamentally the overall profit levels that would still be available to the developer once the demolition of the retail units takes place, by way of encouragement to develop out phase 2. And he's explained that further in his note.
So obviously this is an additional option that's been put forward.
Yes, I should say we don't say it's necessary, because as
you don't. I was about to say that you don't.
Because as you recall from, I think, the final day of evidence at the last session of the inquiry, when Mr. Ashdown gave evidence, we say that there is still profit in phase 2 that would be sufficient to act as an incentive to the developer of phase 2 to proceed with it. Notwithstanding that phase 1 has been identified as the more viable aspect of the scheme, there is still sufficient value in phase 2 that would prompt a developer to do it, and that can be explained further. So we don't think it's necessary to provide this further assurance, because we don't accept the proposition there is insufficient incentive to proceed to phase 2 for reasons that we've gone into before, and because this is an entirely normal approach that we're suggesting to how development should proceed. But if there are any residual concerns about the incentive to deliver beyond phase 1, we say that this mechanism increases even further the incentive that is there to the prospective developer of phase 2, so that there shouldn't be any concerns about delivery of phase 2. We appreciate entirely that this doesn't go as far as what the council is wanting, but for reasons we've set out elsewhere in the note, we simply do not accept that the approach that's being mentioned by the council as a means of incentivizing or requiring delivery of the entire development is acceptable. So that this is our alternative way of assuaging any residual concerns, ma'am.
Thank you, Mr. Linus. Mr. Burton, if I can have your thoughts. I know that the council wants has certainly consistently stated that it wants some form of mechanism to ensure completion of the entire development. But in relation, I'd like your thoughts on what the appellant has put in about this optional further delivery, or assurance as they've called it. Your comments, particularly in relation to whether this actually meets the test for an obligation and meets the Reg 122 tests as well.
Well, Madam, can I, if I take things in stages, if I may. Firstly, I'm obviously not going to go over the evidence you've heard and the discussions had with various witnesses about why the council is concerned there's a risk of non-delivery of the whole. We've had that, we'll come back to it in submissions. Secondly, this doesn't come close to assuaging the council's concern. I'll tell you very briefly why, if need be. Mr. Scott can explain, but you'll recall my cross-examination of Mr. Ashdown, one of the aspects of which was exploring with him why one has profit figures agreed in viability appraisals and so on and so forth. The position here that you'll see from, it may not jump out, but from the second page of Mr. Ashdown's technical note, the final paragraph, it remains the case, you'll see it in paragraph 8, it remains the case that it would not be viable to deliver phase 2 in isolation. So, and you have the headline there is that it would still be minus 792. So effectively what the appellant is saying is that even though one could not achieve the agreed market profit level on phase 2, you, madam, should, for reasons that are completely opaque to us, you should assume that someone is sufficiently incentivized to deliver phase 2. On the contrary, the way we see this, I'm afraid, is that what is being set up here in the section 106 is a situation that delivers to someone, whoever it is, a site, the phase 2 site, that's already been cleared. And when one asks the question, well, what would one expect that person to do with that site? And I should say that that's a person who will have had to pay for that site, and there's nothing here at the moment that tells one, well, of course, factors in any kind of payment for the site. But what would one expect that person to do with that site? Would you expect them to build out something that's not viable, or do something else? We say the answer is completely obvious. They'll try to do something else. So this was not a welcome arrival for the council for those reasons. As to whether following on from there, consequentially, what's suggested meets the test. Well, I'm not sure, Madam, one is going to, or one should try to do better than going back to the starting point here and asking fundamentally, is the council's concern or justified or not? If the council's concern is justified, then this won't meet the test because it doesn't meet the concern. If the council's concern is not justified, then I would have to accept that there would be no need for this additional mechanism on the basis of first principles. So in my submission, it's a binary point. Your mic is on.
I know.
Adam.
I just noticed.
I should say, of course, like my learned friend, as you know, I have Mr. Scott here if need be.
So what the council is saying is that either way, this isn't required as an obligation in the UU. Because either way, it doesn't.
Exactly. In a nutshell, either you agree with us, in which case this does not meet the concern, or you don't agree with us, in which case there's no need to provide any. There's no need to do anything to try to address the concern that you found isn't justified.
So, Mr. Linus, in relation to how, I mean, how does it, I've just been trying to understand, having read the information now, is how it would fit into the planning obligation and how it becomes part of meeting those tests. And whether with the planning obligation, with it included in the planning obligation, it addresses the concern that's been highlighted. Now, obviously the council said no, it doesn't. You're saying that it doesn't necessarily address the council's concerns, as in because it doesn't provide what the council has requested, but it improves the viability situation. That's what you're telling me for T2 and T3 for phase 2.
Yes, ma'am. We don't suggest that it's necessary because, as we said, I'm not going to go through the evidence. We say, insofar as there is a concern about development proceeding beyond phase 1, we don't accept that you need to make any provision to do that, because it's entirely normal approach that you have phase development, that different parts of a site will be more viable than others, and in any event, we say there's nonetheless an incentive to build beyond phase 1 here. So for all those reasons, we don't think there's any obligation that's necessary at all. But we put this in on a protective basis, that if it were thought that there is some form of concern about development stopping at phase 1, which I emphasize we do not accept, but if that were the concern, then this obligation would meet the concern about developing beyond phase 1 and going into phase 2, and you would have to find it was necessary to address a concern about development essentially stopping at phase 1, which, as I say, we don't accept. But if an alternative finding was made, this this obligation would meet it, and it would be necessary in the sense that it was designed to ensure that development progressed beyond phase 1, even though we don't think that is a valid concern. We don't accept the way that the council sort of characterised the obligation working. by way of an example, I mean, if it's right that the appraisal shows that the value of the residual value would be negative, one circumstance which could arise is that the developer of phase one unable to sell the site in any event to someone else for phase two because of the negative value, and is then placed in a position where, as a last resort to do anything with the site that it can't sell on, it is faced with the appraisal that is included in Mr. Ashdown's note, and on that basis there would still be substantial profit left in the development, even allowing for the fact that the outcome is a negative appraisal of 700,000. There's profit of 15 million, which has been assumed at normal values. So even if one absorbed that loss under the residual valuation output, there would still be a substantial profit left in the development. But that essentially is a variation on the point that has been put in evidence to you already.
Well, Madam, you anticipate what we say about that, which is, well, no, what would happen is that someone would buy this with a view to doing something else with it, something that was actually profitable, and they'd pay money for it, no doubt. But that's just the way the world works, I'm afraid.
So, because I'm trying to understand the reasoning behind this. I am struggling to understand the purpose of this being included within the UU. And I know there is a clause to say it would only come into effect should I find that it's necessary, but I am struggling to understand in what way it would become necessary to include it.
The fundamental reason for doing it, ma'am, is that to address the concern that the council raised about the development stopping at phase one. As I said, we don't accept that concern is justified on the basis that one has phase development all the time with different elements of viability across a development site that is phased, and the way that one deals with any concerns about being able to deliver an acceptable form of development across the site is to stagger the way that development proceeds, so that a proportion, for example, of affordable housing appears in the development up front. And that's what we have done by loading 56% of the entire affordable housing into phase one. So we say that our offer, as it stands, is entirely acceptable. The reason behind offering it is that we're aware that the council has raised this concern, and we're protecting our position that in case you are having any residual concerns about the proposition that development will stop at phase one, here is a means to ensure that there's an incentive demonstrated for the developer of phase two. And when one looks at the technical note, the outcome of that work is that essentially there is £15 million worth of profit in phase two. So we accept that as far as a notional residualized price at 792,000, which would be the outcome of assuming that profit level. Nonetheless, even allowing for that, there would be substantial profits available in the second phase, which would be attractive to a developer to incentivize delivery. We say that there is an incentive there already, and it's part of the normal operation of a development site. But the technical note is intended to confirm that profit level is there, and developers will always take a commercial view in any event, that it's designed to show that there's profit in this scheme.
Anything further on this point?
Well, Madam, I know you have the point, but let me just make sure it is crystal clear. It's not just that phase two, even with the retail units already demolished and those costs of demolition moved into phase one, as it were, it's not just that it would still be unviable. One must not forget that in the real world, someone coming to this site, let me put it this way, it would be quite surprising were a developer to come into possession of the phase two site for no pounds. They would rather likely have to pay something for it. And of course, that already unviable minus £792,000 doesn't reflect whatever they would have to pay for it. What you have to take from this, and this is just a hard number, is that a developer acting rashly in accordance with the market would not build out phase two. That's how viability appraisal works.
Yes, ma'am. I mean, I don't want to prolong this, but if the concern was that a developer who was developing phase one was not then going to proceed, the reality of the position is that, as we discussed in evidence before, it doesn't really matter what this notional further purchaser would pay for it. One can contemplate the position where it's a developer of phase one faced with the decision of whether to proceed with phase two, having demolished to achieve the completion of phase one. And the figures represent the commercial position that would be facing that developer. So finishes phase one, having demolished the retail parade to complete phase one. The figures, as far as our case is concerned, clearly demonstrate that there would be profit available to incentivize that developer to continue, having already carried out demolition to secure the completion of phase one. I mean, I'm reminded as well that in some sense it doesn't matter what a purchaser sort of pays for that site, because if someone were contemplating coming on to the site, any new scheme would be subject to its own financial viability appraisal if there was a new form of development being contemplated. No BLV, increased levels of affordable housing. So they would have the choice of going through that process or building out phase two as consented, because there wouldn't be any retail parade on the land. There wouldn't be any BLV. That would then mean that if any developer wanted to come onto the site, walking on the cleared site and do something, they'd be faced with the viability appraisal, the cost of affordable housing, and they'd still have the choice of building out the consented scheme with the profit levels that are indicated in the note. So we don't accept that you have to contemplate the spectre of a cleared site, because it's just not how the commercial market would work in reality. Either on the part of the developer who's done phase one is contemplating phase two, or on the part of a developer theoretically walking in to look at phase two with a retail parade cleared. We just don't accept that scenario is remotely realistic. I think, ma'am, if these notes have gone in, I suspect unless there's anything more we can help you with, it's a matter that we can explain in our submissions. I'm
content for that, rather than.
I would say, I must emphasize, you do not need to go here if you accept our evidence that the approach that we've taken and we started with is acceptable, including a large proportion of the affordable housing provided at an initial stage of the development in the normal way. And we've only gone here just because of the way the issue appeared to be evolving through the inquiry. But our starting point is that you don't need to go there at all.
Okay, thank you.
Just finally, ma'am, we will set in submissions, but obviously in any event, as you indicated at the outset, the scheme is balanced in any event, so that not only is there substantial delivery within phase 1, there is a balance between phase 1 and phase 3 delivery. So as in a normal way, if there's any risk whatsoever of development stopping at an initial phase, there's still a balanced level of provision of affordable housing versus private within that discrete phase.
Thank you. I'm not proposing to go through any more detail on that aspect. I've got the information that's in front of me. I've got the section 106 that is there. Just bear with me, I'm just looking at my notes in relation to other aspects of the section 106. Is there anything further I need to either just need to understand? In terms of Part B and the supplementary affordable housing units. Now, I'm fully aware of, I've read it, and I'm fully aware of why that is in as a supplementary, because it is dependent upon whether SIL payment is required or not, and that won't be known until development commences, etc., etc. So I'm not necessarily proposing to have a discussion about that unless there is anything that either main party wants to raise that thinks this is a critical part, because I understand what that is, why that's there, and what that would deliver if it was required, subject to whether SIL is paid or not. Are there any concerns or differences in opinion as to how much affordable housing could be delivered? Because obviously that's clearly set out in the section 106.
Well, I mean, obviously the council disagrees with our affordable housing offer, which is the sort of starting point for the application of the mechanism, but the mechanism itself and the implications of that mechanism being followed are agreed as a discrete matter. So I don't think there's any need to go further. As far
I thought that was the case, but I just wanted to just ensure that give you both the opportunity to have your say if you so wished.
No, thank you, madam. On this, we don't need to have our say. A rarity.
Right. Okay, thank you. So the rest of the section 106, when we come to the schedule 3, again, I've looked at that. It's quite a short schedule. I haven't got any anything I wish to query on that.
Ma'am, we have nothing to add to that.
Okay, anything, Mr. Burton, on schedule 3?
No. Well, sorry, I should check with Mr. Felton, but no.
Okay, thank you. So is there anything that, I know it's been raised in relation to, this will be brought up in submissions, but is there anything that needs to be discussed as we have the experts in the room in regarding 3-bed? Or is that going to be left now to submissions?
Ma'am, I think we just need to understand the basis upon which the submissions would be made. Obviously, you have both those documents. I given this time, I have no objection to those documents going in and the parties making reference to either of them as they see fit in submissions. I think there is obviously a difference between the parties, which in large part may actually be down to how the relevant policy is interpreted as well, and that's primarily a matter for submissions, it seems to me, and the matter of weighting as well.
when I read through the information, that I did read it in that way, in terms of it's a policy implementation issue. So if it's not, and it needs to, something needs to be aired, I need it to be aired now, obviously. But that was when I read the information, that's how I read it, that it's the interpretation of the policy. So, Mr. Burton, do you agree with that or not? Or do you have, or are there issues that you wish to, in terms of the differences between the two sides?
Yeah, well, firstly, Madam, the council's quite content with the evidence as it's come forward in terms of a basis on which to make submissions to on Wednesday. Secondly, the issues between the parties, much though I wish I could say to you it's terribly easy and it just turns on a question of policy interpretation and implementation. It's not, in fact, simply a question of policy interpretation and implementation. Just to break it down, firstly, there is, I think, as we heard from Mr. McCurry and my learned friend as well, on the appellant side, a view that one should approach DM13B on the basis that essentially it's a qualified obligation or qualified requirement to deliver at least 30% 3-bed units, and it should be read as it were, embedding a subject to what that does to affordable housing caveat within it. I mean, I attempt to summarize what I understood to be the argument being advanced, but that's my understanding. And also, it seemed to be suggested in cross-examination of Mr. Feltham that if one can't hit 30%, then essentially that's it, and one doesn't need to try to get as close to 30% as possible. If I've understood right. Now, obviously,
that was asked and was accepted.
Well, we have as you know, Madam, we have quite a dispute about that bit of cross-examination and indeed the re-examination on it.
Yes, that was raised. I remember it well. Yes.
Yeah. Well, you yourself sought clarification as well, as I recall.
Yes,
Madam,
I did.
In any event, and that we'll have all that out in submissions. And on the council side, of course, the council says no, the policy is clear. You obviously you aim for, and you have to aim at the design stage, of course, first formative stages, you aim for your at least 30%, and if you can't hit 30%, then you get as close as you can, subject of course to viability and suitability, which are the only caveats that are in the policy. So that, as I understand it, is the policy interpretation difference. There is then a disagreement, and I don't think there's any way of getting around it. The appellant is saying to you, we have demonstrated one cannot viably provide more than 27.5% 3-bed units. The council is saying to you, no, you have not demonstrated that. And so that is the other aspect of the dispute. Now, as to the parties' respective position on whether that has or has not been demonstrated, those positions in the somewhat cumbersome way, but they are set out in these two statements of unagreed statements of common ground, and you're already familiar with them from the evidence. But that, I hope, it was my attempt to hopefully break the issues down. I invited you, perhaps slightly unfairly, but I invited you to obviously ask any questions of the viability witnesses if you had any, having read those statements of common ground. When I offered that invitation, it was very much with the second issue in mind, namely the has it been demonstrated or not issue in mind. But the positions, as I say, seem to the council at least to be tolerably clear on those documents.
I think for my part, if those documents are both accepted, I'm minded to agree with Mr. Burton that you have, albeit in a less than ideal form, you have the positions of the parties which they can draw upon as they see fit in their submissions. It's better that you have those documents in front of you to understand those rival contentions, which can then be distilled in the submissions. I don't think I need to say anything more, provided that I know when preparing the closing that we can refer to the documents that have been submitted both by the council and by ourselves. There is just one other matter I just want to raise on the 3-bed issue, but that's my position on the documentation.
Thank you, Mr. Linus. What was your other
It was just
element that you wanted to raise?
It was just a question of clarification, because obviously, as we understand the council's position, Mr. Burton's characterised ours, but as we understand the council position, that when one applies the 3-bed policy, one prioritises the delivery of the 3-bed over affordable housing, even if that means reducing affordable housing to effectively 0 because of the priority that's given to 3-bed. If that is the case, it would be helpful to know what the council position is on whether we have maximised reasonably the provision of affordable housing within the scheme. Because if its approach is that one sinks everything into the 3-bed units, we need to understand whether the council is still saying that we should be effectively loading affordable housing into T3 alone to achieve a greater level of affordable housing than the offer. We just don't know if those two positions are both being advanced at the same time by the council.
Ms. Button?
Sorry, I'm not sure I entirely understand that, but let's see if I have managed to understand it and see if I can assist. The council's position is that, as a matter of logic and practicality, when one's designing a scheme, one has to start with the 3-bed policy. Have to when you're working out what your building floor plates are and how you're subdividing them. Once you've done that you're then in a position to stand back and say, right, what affordable housing is viable on this scheme? And clearly you can't, well, affordable housing is tenure blind. So you can't design a scheme for affordable housing first. You put your units in, you try, I mean, the idea is you try to get the unit mix that reflects the development plan. And then you look at the question of, is affordable housing viable? What's the maximum affordable housing, and so on and so forth. Now, I think what my learned friend is asking of me is that consistent with the position the council's adopting as regards moving affordable housing to T3? Well, of course it is, because the council is stuck with the scheme that's before it. That's what we've got to work with. The appellant has not been willing to change the scheme, so we've got the unit mix that we've got, and so in a word, yes, of course, there's no inconsistency in those two positions. Doesn't in any way stop the council or prevent the council from making the point that it's made many times already that this scheme clearly doesn't comply with DM13B.
Well, I think I can just respond to that in position in submissions, ma'am. I'm not sure that actually provides us with any more clarity, but then you can reach a view on that depending on what you hear in submissions, ma'am.
Thank you.
Yeah.
I'm just double checking something just in case I've got a query. Okay. Is there anything else? I've got the information in front of me, so I'll just, obviously I've quickly read through and I will read in much more detail when relevant. Is there anything else that anybody wants to raise in relation to the planning obligation, 3-bed, and or anything else that we've just discussed today in relation to planning conditions?
Ma'am, no, the only other point I was going to raise is the time when you need the final executed version of the 106. Obviously, we need to obtain final signatures, and we'd ask for that being provided to you within 2 weeks of the
two weeks is the norm. Do you need those 2 weeks?
My instructions are yes, ma'am.
Okay, then that's fine.
And would it be appropriate, I think in other cases, to make sure you see it, would you find it acceptable for us to mark any document being sent to you for with the permission of the inspector? Because I know if that isn't put on any documentation of hard copies that are sent to you, then it can cause a problem.
Yes, that's fine.
Thank you.
I'm just checking, madam, to make sure that, well, I presume Mr. Felton is still here. I know he's not. Yeah. So I'm not inviting it, Mr. Felton, but obviously I'm checking that you've got nothing more to say. Mr. Scott, who's been very diligently sat here, has helpfully said he has nothing further to add. So obviously I thank him and Mr. Ashdown for sitting here.
Very patiently,
nothing.
yes.
Very patiently saying nothing.
Yeah, the only things which I know it's quite late, but the housing person did raise a couple of issues about definitions of the affordable housing, which
you're killing us, Mr. Felton.
I just think there aren't the definitions. Apparently, that's what he said. The affordable intermediate rented homes. There is no definition for this tenure type. This is the fallback, I think.
Why hasn't this been raised? Even if it were a point which I'm not accepting at all, why hasn't it been raised when this has been with the council for some time now?
Yeah, he was on leave, unfortunately. So he's raised it when he's come back. So I don't know if there's anything we do about it, but that's
okay.
That's the only issue. That is the
only issue. Sounds like a very long period of leave.
Well, I think this came. I think you made your team made some amendments.
I think there've been 6 drafts in total.
Yeah, but this was a relatively late amendment. I know when it was done, I think, but so that went backwards and forwards a bit.
Sorry, Mr. Felton, what's the point?
So he says he's comfortable with the temporary switch to shared ownership.
Where in the document are we looking?
Okay. That's it's. I think it must be in Schedule 2. Hang on, let me just get that up.
It's possible I might be able to assist, ma'am. I think I know where Mr. Feltham's coming from.
Oh, please do, Mr. Hamill.
There's a provision in, I think it must be Schedule 2, that allows for the shared ownership units to be temporarily occupied on a different tenure in the event that they can't be let.
Yeah.
And I think the point is simply that the tenure to which they might temporarily switch is not precisely defined. And that's because it's to be occupied, I'm looking at page 33, 2.1, occupied as an affordable intermediate rented basis as may be agreed with the council. So in the event that this clause is ever used, which would only be for shared ownership units that could not be sold and only ever exercised temporarily, then there would have to be a further agreement with the council to decide exactly what tenure was appropriate for that particular unit to be let on until the market picked up and it was able to be sold again. So if it's the lack of a definition relevant only to that paragraph, I think it's addressed by the fact that it's to be agreed with the council in the event that it's needed.
Okay. Yeah, and then it's and then the usual kind of nomination rights to Kingston. I think we're broadly the two issues basically.
That might be out of date. That there is a nominations agreement provision. It's the next immediate paragraph after the one we just talked about.
Yes.
And does that relate to this undefined?
It could do because it's yet to be entered into, but I would suggest that the mechanism we're talking about is a temporary solution for not necessarily all or any of the shared ownership units. And it's probably, I would suggest, not necessary to go to that level of specificity. But in any event, it's a tenure to be agreed, so the council has their say.
Exactly, it's all to be agreed with the council.
Okay, fine. So that's it.
Okay, well that's it. Well, that's good.
Was that it, Mr. Phillips?
So that's not an issue, really.
Okay.
Well, no, I mean, obviously, before you sign it, you just want to check that it's dealt with those with the points that have been raised. So yeah.
Thank you, Mr. Hanmore. That was very helpful. So to just point out exactly where that was. So thank you. Thank you. Anything else then? Because I am going to draw this session to a close. I know I said I would deal with cost applications, which I assume there are none. So, but if there are, then I'll deal with it on Wednesday morning. If either main party decides to submit cost applications, and then I will quickly discuss site visit arrangements on again Wednesday morning, but that's going to be very quick anyway, and then move into the closing submissions.
Well, in terms of scheduling for Wednesday, madam, I can tell you I'll be grateful my loan friend could give me an indication as well. We were both shaking our heads there, but I've no instructions to make a cost application.
No.
I don't either.
And no. So can I leave that then? So I won't even raise it on Wednesday. There isn't, nothing's going to happen tomorrow.
We're not sitting tomorrow.
No, but no, which is good news. But yes, I don't want anybody making a changing their mind. So,
Ma'am, obviously, that's the position as I understand it. I will double check if there's anything different to that. I will let Mr. Burton and yourself know absolutely immediately. But that's I don't.
Okay, I will raise it again. I will raise it very quickly again on Wednesday morning. But obviously, Wednesday is about the closing submissions. I want to focus on those. Can I just confirm in terms of the closing submissions when I will obtain those? Obviously, it's usually handed to me when we do face-to-face events, etc., etc. but I just need to make sure that my case officer is available, because otherwise I can't have copies. So is it literally going to be 10 minutes or so before each of you speaks?
Yes.
Literally to the wire.
Maybe not even 10.
I wouldn't stretch it to 10 minutes, Ma'am. I think from my point of view, obviously, if I need to respond, then I think Mr. Burton says it's going to be more helpful to you for me to put that, if possible, into the text, which means that I couldn't send it to you much before I start in any event.
No, which is absolutely fine. I just need to make sure that my that a case officer is available.
That's fine. So, I mean, the other point is, as far as timing is concerned, I know we start at 9:30 today. I'm just wondering, given that the pressures are on all parties to get the submissions finalised, whether we could push the 9:30 back a little bit, even just to 10 o'clock. An extra half hour in the morning of closing submissions is always welcome.
Well, what are the timings that are proposed for the closing submissions? If we're only dealing with closing submissions on Wednesday, then any ideas at the moment for either party?
So,
in terms of how many hours each?
Yeah, my feeling is that mine will probably take 2 hours, and I would propose to skip in order to stay at 2 hours, because I can't see, frankly, Madam, that you would be assisted by going on for more. I mean, 2 hours is already quite a fulsome closing. So
it is, yes.
That's my indication. I hope that's helpful.
Okay, that's very helpful. And Mr. Linus, please.
Ma'am, I'm the same. I don't think I'd be in a position to read out everything, otherwise that time would be extended. I know that even the Bristol Airport inquiry, which went on for even longer than this inquiry did, that closing submissions were kept to a couple of hours from each party. I think that's a useful discipline. So I won't read everything out, but I will make sure that it doesn't go beyond 2 hours.
Okay, because if each of you is saying 2 hours, then there is nothing to stop us starting later than 10 o'clock.
Well, perhaps
if you need commencing at 11, for instance, or half 10.
Perhaps, ma'am, if it were looking at 2 hours, we could start at 11, then that would give a convenient point to break for.
That's what I was thinking. Then it's that there's a break. I know it gives you an added advantage of an additional break.
Well, ma'am, I mean, I don't, if there are any concern about that, I wouldn't have any objection to making sure the document was sent through before the full luncheon adjournment was taken. It's just more a case of giving people who are listening a break from having to listen to the closing submissions one after the other without a proper break. It's not for my own purposes to get any kind of advantage.
Madam, I for my part, I would be, I suppose I need strictly to take instructions in this, but I'd be relaxed about Mr. Linus spending the lunch hour typing any additional bits he wants into his closing, rather than the alternative, of course, is him orally addressing you, and you
having to write every element down.
Every single word down, which we know does take up time.
It does take time.
I wouldn't be standing.
And you would have the joy of an additional couple of hours in the morning to do yours, Mr. Burton. If we didn't start until 11, for instance.
I would. Well, at least that would allow me time to try to ensure that my home internet connection is working. It's usually absolutely fine, but I'm in here in chambers for safety's sake, as it were.
Okay. Well, can I suggest a start? Can we just start? Let's just start at 10:45. It gives us 15 minutes to just go through any outstanding matters or go through the site visit aspects. And then we can go straight into closing submissions to make sure that you have each have 2 hours. And then if we can stick to that, then that would be, I think that would be very good way of finishing the inquiry. So and then hopefully finishing at 4 then on Wednesday. So thank you for that. Okay, without further ado then, 6:30. That's a bit of a long one, but we got there in the end. Thank you very much. And I will see you then on Wednesday. So I'll adjourn until then. Okay,
Thank
so
you very much, ma'am.
be 10:45. We'll make sure that's on the website. Thank you.
Thank you, ma'am.
Thank you, madam.